having some issues with the live stream. So if anyone is has parents asking or whatever, we're dealing with that. We're also still waiting for one of the judges and Delegate Plaskett to log on. So that's why we're still a little late, but we are going to be going. We're just waiting for those last two people in the IT to get the live stream going.
Good morning, everyone. I'm just testing my mic.
Publish everything online and everything.
Can you guys hear me?
You're a little quiet, whoever is talking. We can hear you, but it's a little soft.
Hello?
That's better.
Um, Good morning, everyone.
Good morning.
Well, that's fine. Okay.
Yeah.
Can you guys hear me now?
Yes.
Thank you.
Adam, can you hear me?
Yes, that was fine. The live stream should be working now. So vicourts.org is the website. On that page, you'll see a link on the lower right that says media services. And on the media service page, there's a live stream tab. If you follow that, anyone can watch from anywhere. They don't need, they shouldn't be on this link right here. There's concerns about bandwidth and stuff. So if anyone wants to watch that, that's what you follow. And we are still waiting on Judge McKee. He tried logging in, and I haven't seen him since that attempt. And also, the guest speaker isn't online yet. All right. Good morning, everyone. So there was a scheduling conflict in somehow Delegate Plaskett double booked this morning. So we are going to try and add her speech at the end of the competition. I see that Judge McKee is online. Can you hear us, Judge? Oh, good morning, Judge McKee. Can you hear us? Judge McKee, can you hear us? Someone else want to try speaking?
Yeah, good morning. Ted, can you hear us?
Does not look like it.
Mm-mm.
Okay, he's gonna put on a headset. Okay.
All right. Good morning. Are you there, Judge McKee? Oh, it looks like his internet connection. Oh, there. Okay. Can you hear us? You there, Judge McKee? Can you hear us?
I hear. I am so sorry. I'm in Chicago, and I was looking at my watch, which is an hour behind. I even logged on a while ago, and I couldn't figure out when everybody was in session. I logged on to make sure my Zoom link was good, and I thought I had interrupted the meeting, so I immediately signed out. But I'm very, very sorry.
Oh, no worries. It wasn't just you. So we're ready to begin today. Well, let me make sure that we have all the schools. Let's start with St. Croix Educational Complex. Are you online? Is that a yes from someone?
Yes, we are.
Okay. St. Croix Seventh Day School. Holly, are you online?
Yes, we are.
All right. St. Peter and Paul, I see Carol. Is everyone else online? Okay. Is Charlotte Molly High School? Are all your people there, Mr. Richardson? Or someone else from Charlotte and Molly? I see some of the participants, but I don't know.
Well, we know Tia was here because she.
Yeah.
Can you hear us now?
Yes, we can hear.
Okay.
Are all of you there, Tia?
Yes, we're all here.
Okay. St. Thomas, Seventh Day, I see you online. And Antilles, are you there? Tulane, Anna?
Yeah, we're here.
Awesome. Okay, we got everyone then. All right, so let's get started. We're a little late here. So first off, before we do anything, I want to have everyone's attention. I want to do a shout out for smile.amazon.com. I actually personally don't believe in buying corporate, but the fact of the matter is that if everyone following Hurricanes Irma and Maria had used this website to purchase on Amazon, we would still be funding scholarships through the funding they would have donated to the Barr Foundation if these orders, they had donated their 0.5%. And so since we live on an island and everyone ultimately at least once a year ends up buying something on Amazon, I would encourage everyone to use Smile and identify the Bar Association as their nonprofit that they donate to. Every purchase, 0.5% of it would be donated to the moot court competition that would fund scholarships in the territory. With that, I also want to say thank you to the coaches. We're starting the first day of the competition, and while I have everyone, the coaches are essential. It is a lot of work, and we could not do it. And what was apparent from yesterday is that you all put in work. So thank you all You're essential to the program, and we really appreciate all the hard work you do, and we're looking forward to the performances today. I do want to, at the beginning, reiterate that the scholarship awards this year. So, the best oralist will win $1,250. The first runner-up will win $925. The second runner-up will win $750. The third runner-up will win $250, and the fourth and fifth runners-up will win $100 each. And then the teams, to be divided among the members equally, first place will receive $1,500, second place will receive $1,050, third place will receive $900, and fourth place will receive $675. So that is what we're here for today, is to determine the team ranking and placement and to award the scholarships. There will be a break at approximately 12:40. That's the halfway mark, just following St. Croix Educational Complex appellees. That'll be a 20-minute sort of stretch moment where everyone can take a break, eat a snack, and all of that, and then we'll be on back for the second half of it. And just as to the procedure today, once the Chief Justice gives his welcome remarks, the judges will each introduce themselves and say a little bit, and then everyone will log out except the team that's going to compete, and each team that competes can remain online watching, and I will admit the team that is going to argue next when it's time for them to argue. And everyone logs out, I log in. So everyone should be logged on about 7 minutes before their scheduled time or so. And you're going to have to adjust your schedule by how late we started. So we started 20 minutes late, so every time should be moved back about 20 minutes or so, I think. But also don't be too lax in getting online. And with that, and then if you don't know how to pin stuff, figure that out while the chief is speaking, and then you can start pinning the judges to your screen so you can see them through the competition. And with that, I will welcome everyone and turn it over to the Chief Justice of the Virgin Islands Supreme Court to say a few words of welcome and encouragement to the competitors.
Yes, good morning, everyone. My name is Reese Hodge, and I'm the Chief Justice of the Virgin Islands. And on behalf of the judicial officers and the staff of the judicial branch of the Virgin Islands, I welcome you to the annual Moot Court competition. This competition, now in its 27th year, is one of the signature outreach programs of the Virgin Islands Bar Association, to which the judiciary has always given its support. It was actually started 27 years ago by a judge of the Superior Court, Judge Diazi, and has continued on through the hard work of the chairs and court chairs. And it would not be possible really to have this competition without the hard work, the countless hours of the volunteer services that are offered by members of the bar and others who serve as coaches or those who serve on the Moot Court Committee. This year, the Moot Court competition looks a very lot different from in the years past. I would normally be giving this welcome address, welcoming you to the court facilities in person. This year, we are doing it over Zoom. Don't feel bad. That is the way that we have all had to adjust over the past year. And as you will be presenting the Moot Supreme Court of the Virgin Islands, you'll be doing it the exact same way as the attorneys who argue before the real Supreme Court of the Virgin Islands. So you're in good company. Now, What has not changed, however, is the value that you will gain from your participation in this company. And I'm not just referring to the scholarship money that the winners, although that is certainly a plus, but rather to the knowledge of the legal system that you have acquired, as well as the important critical thinking and public speaking skills you have developed through understanding and digesting a complex set of facts and legal authorities, crafting your arguments and refining them with your coaches and your partners, and presenting them to a panel of judges. Today you'll be presenting to real judges, and I'm happy to see former Chief Judge McKee, I see Judge Lewis, and of course from the Supreme Court, Justice Capet. So you'll be arguing to real judges, and that is certainly a treat. And with this, the caliber of the judges today, I know that you will shine and perform. Now, what I certainly hope many of you will consider attending law school and coming back to the Virgin Islands and performing as real lawyers. I am sure that the skills that you will have developed in your preparation for this competition will serve you well. And regardless of what profession you go to, we have had competitors in this competition that has gone on to be lawyers. Some has been scientists, some working at MIT teaching science, and certainly we've had some lawyers. And I'll just take a minute to tell you my recent experience. Early last year, I received an application from someone who was requesting to do an internship in my chambers. And the cover letter to the packet stated out front that he had participated in the moot court competition and that he was motivated to attend law school because of comments that he had heard from the judges on his panel. The very last page of his packet, he presented, he had good grades, and I was very impressed with his writing sample that he submitted. But the very last page was a copy of a news report that had a photograph of the Charlotte Amalie High School team that won the competition that year. And in the photograph was myself and the two other judges. I believe it was Judge Miller and Judge Donahue. And when I saw that, although I had never met him, I just looked at the photograph and figured out which of them, was him. And it turned out that it was him. And I remembered his argument. But it was, of course, by the time the summer came around, we were not able to have the normal internship where he would be in chambers and would be able to talk with the law clerks and with myself. We had to do it on Zoom, as usual. Actually, we used Teams. But we were able to at least allow him to have the experience of interning in the office. So it does happen, we say it, but based on the experience and the encouragement that you receive in this competition, many of you do go off and come back as attorneys. So I wish all of you the same encouragement today. I was going to, I've been asked to keep my comments very short. You were to have a keynote speech by our delegate, Stacey Plaskett. That may come later. But since we are starting 20 minutes late today, I just really want to close by, again, thanking, on behalf of the Virgin Islands Judiciary, on behalf of the committee, I wish to extend our deepest thanks to the teachers, as well as to the attorney coaches and other volunteers who I hope will remain in contact with your you will remain in contact with those coaches because I know that you have developed a close relationship with them. So I would particularly like to recognize one of our judiciary-owned employees, Attorney Adam Thorpe, who's law clerk to Associate Justice Arlington Swan, Arlington Swan, and his co-chair as well, Attorney Kuczynski. So to all those who are arguing today, I wish you good luck. I hope that you enjoy the experience. I know that this is a competition, and by necessity, someone has to come in first, someone second, someone third. But as I always say at the end of the competition, I believe that the fact that you are here, you are all winners already, and regardless of where you're placed in the competition, just go out, make your arguments, enjoy yourself, and again, I wish you all well. Thank you.
Thank you, Chief Justice Hodge. Those are a wonderful message to begin on. It really encapsulates what the experience of Moot Court is. And also, we, the members of the committee, and on behalf of everyone who participates, thank you specifically. You do a ton to support this. We wouldn't be live streaming this now if the Chief Justice weren't so supportive of this competition. There are just innumerable logistics that underpin this entire thing that the Chief Justice never hesitates to provide in support of it. And so just thank you. We don't get to say that to you nearly often enough, given how much you really do for us. With that, I want to start to allow the judges each a little bit of time to introduce themselves and give a little bit of words of encouragement for the students. And also, this is the opportunity for each person to pin the judge to their view so they have the three judges at the start of their screen and they don't move away. So the first judge I would like to introduce is Judge Lewis, the Chief Judge of the District Court of the Virgin Islands. We are thrilled to have her here. She has been a long-time vociferous supporter of the Moot Court competition and went out of her way to give a welcome address last year, and we are absolutely thrilled to have her sitting on the panel this year. And so with that, Judge Lewis, we'd love to hear from you a little bit this morning.
Thank you, Attorney Thorpe, and good morning to everyone. It's always such a pleasure to participate in the annual Moot Court program hosted by the VI Bar Association. It's always so well coordinated, and indeed it has been for the many, many years that the bar has hosted this program. It's also well supported by people like all of you who have tuned in today to be here in the varying capacities in which you are attending. But the highlight of our program each year is the students. The ones who work so hard together with all who support them to come and present their arguments. Each year, I find, at least the years that I have participated, and I'm sure the other years as well, that the students are so very impressive. So very impressive. You can see and hear the hard work that's put into it, the motivation that they have, the determination that they have, and it's just a real joy to see that. The talent that they display allows us to leave the program each year knowing that the future of the Virgin Islands will be bright. The future of the Virgin Islands will be in good hands. Because of what they display just as high school students. We know that the potential that they have is great indeed. I'd like to thank Attorney Thorpe and Attorney Kuczynski for inviting me to be a part of this again this year. And I certainly look forward to the presentation. And what I'm sure we'll all leave with is having had a very good day here today. Thank you all very much.
Thank you, Judge Lewis. So to tie in with the Attorney General's speech yesterday, she talked to you about federalism and dual sovereignty and the territorial clause of the Constitution in her speech. And the Judge Lewis is a federal judge. She sits at the Federal District Court of the Virgin Islands. And so she participates in the federal system, which is at the trial level of the federal system. We also have with us today Judge Theodore McKee of the United States Court of Appeals for the Third Circuit. He also is a judge in the federal system and has graciously agreed to sit on the panel today. And with that, Judge McKee, I'll turn it over to you for some comments.
Thanks, Adam. I'll be very brief. I already feel incredibly bad about having infringed on your time. I cannot tell you the number of mental gymnastics I've gone through in the past few days after I flew out to Chicago to make sure that I was synchronized properly, and I still screwed it up. So I'm convinced that all the competitors today will do a much better job than I have already done. I want to thank everyone for allowing me to participate. I'm really honored to be in the presence of Chief Judge Lewis and Justice Cabret, both of whom I have tremendous respect for. At the risk of embarrassing Justice Cabret, she had a footnote, I believe it was, in an opinion years ago criticizing one of our Third Circuit opinions and basically saying we were wrong. And we were absolutely wrong. And we finally got the opportunity in a subsequent en banc opinion to recognize the error and to applaud Justice Cabret for her foresight in being more insightful in the law and certain statutes than the Court of Appeals was. She got it right, and we had been getting it wrong for decades. So, and Chief Judge Lewis, someone I've had the pleasure of working with both while I was Chief of the Third Circuit, and since then, two just real stellar intellects and real fine legal minds and jurists. So I'm really honored to be part of that. I also want to say to the competitors that the problem that you have been given, when I first read it, I kind of scratched my head and I thought I had the wrong fact pattern because it is not an easy pattern at all. It's a very difficult pattern. It is the kind of pattern that would give seasoned lawyers some trouble in formulating an argument. So good luck with it. I think you'll do very, very well, and I'm looking forward to engaging with all of you.
Thank you so much, Judge McKee. And with that, I will introduce Associate Justice Maria Cabret, who is your Chief Justice of your Moot Supreme Court today. She was first appointed to the Territorial Court of the Virgin Islands and then was elevated to presiding judge. And then she retired for all of 30 seconds and was appointed an Associate Justice on the VI Supreme Court. And we are thrilled to have her here. She is always wonderful on the panel, and it's amazing to see her ask questions of the students and see how they respond to it. So with that, I will turn it over to Justice Cabret for some comments. You're muted still if you didn't notice.
Thank you, Attorney Thorpe. Good morning, everyone, especially the students. I know that you cannot wait to argue this morning. And I must say that I completely agree with Judge McGee. The fact pattern, the cases, the issues are very complex. And I know that you have prepared well. I am certain of that. I know that the coaches have worked very hard. I know that the planning committee has worked extremely hard. And since you are a part of this, people who are observing us may not realize how much work goes into producing an event like this one. But you have been involved in it. So you know the hard work, the long hours that you put in, the coordination that it takes, and all of the support that it requires. On my part, I want to thank you for putting in that effort. I know that you're going to do really well this morning. I also want to thank your parents and your teachers and your attorney coaches and the planning committee, especially Attorney Kaczynski and Attorney Gregory Allen Thorpe, who I'm sure Adam was tired of answering the phone yesterday.
Not even a little. Not even a little.
I was peppering him with questions, making sure that we're going to be ready for today. We had a little technology challenge this morning, and that wasn't most stressful, but we were able to solve it in time. And for that, and I really want to thank our IT division. It's a stressful job to work in IT. And they're usually called when we have problems and we want things fixed right away because we have to get online. And it was a challenging situation this morning, but together we solved the problem. So I want to thank you. And lastly, I just want to thank Judge McKee and Judge Lewis for serving on this panel. I am truly humbled to be working with them this morning. They are brilliant jurists with a record that judicial records that are among the best in the nation. And so you're in for a treat this morning. Again, welcome and good luck. I know you're going to do great.
Thank you so much, Justice Cabret. So a few things for the judges. When you ask a question today, if you could, while the students are answering, mute your microphone. We had some I don't think this will be an issue for Judge McKee since he's got the headset, but we had some feedback issues where a lot of the students yesterday were having trouble because while they were answering the judge's question, their voice was looping through the microphones and it was creating that. So if you could, I know it's awkward and a bit difficult, but if you could do that, it would be appreciated. Also to the judges, I don't know how you're processing your score sheets, but if you can hand them off to someone to email them to us in real time, that would be helpful. Otherwise, if you could do a half of the score sheets when we take our break and then the other half. But it would help us move along in the tallying process and shorten the delay between the end of arguments and the beginning of the awards. And so with that, I would, yes.
Email address, should we send to one email address? And if so, what is that email address?
To me, my address, attorneythorpe@gmail.com.
Okay.
And Rob's, what is yours?
It is Rob with 2 B's, ROBB @becksteadlaw.com.
That'd be helpful. Could you just send us even a blank email and we can just copy your email address that way? And
I'll do that right now.
And the other thing, I almost never do anything in hard copy, but for this, yesterday, I did actually print out and develop a score sheet on hard copy. Where I am situated, it's going to be hard for me to figure out how. I can't really scan this. I'll figure out some way to get this to you.
You can take a photo of it and email it to us.
Okay.
A judge did that yesterday, and she just emailed them individually in real time, and it worked very well.
Okay, that's what I'll do.
All right. I just sent an email with me and Rob to 2 of you. Judge Lewis, I apologize. I don't have your email address, so I couldn't include you, but Rob's copied on it, so he can forward it to you. And then with that, Arnell, can we get you online? Yep, unmute and say hi.
Good morning, everyone.
Arnell is our timekeeper, so after the 3 judges, you should have her pinned to your screen so that she doesn't disappear on you. And can you hold up your signs that you'll give for warnings?
3 minutes, 1 minute, 30 seconds, and then I'll hit you with the last one, time.
All right. And with that, Rob, do you have anything?
Good luck, everybody, and try to have some fun. I think we try to make the problem as entertaining as possible.
And I would just note that we are actually only about 4 minutes behind when we were supposed to start. So we aren't actually behind. So you should be in the waiting room about 7 minutes prior to the start time on the schedule as of now. And other than Charlotte Amalie High School, all other schools should log out. And then at 7 minutes before your time, you can log in and be in the waiting room, and I will admit you at that time when your arguments are to commence. As a reminder, you should spell your name and do everything that we did at the beginning of last time. And so with that, please log out if you are not a member of Charlotte Amalie High School's team and you aren't a judge or a judge. Cheryl George, Sheila St. John. Okay, we still got some stragglers. Okay, there we go. Who is Diana De Garcia? Diana.
Hello. Yes, good morning. One of the coaches from Cinco Educational Complex. Do the coaches also log out?
Yes. Just so there's no issue with that or anyone for that. Even if students aren't present, the coaches should log off. Yes.
Okay, thank you.
You're all welcome to watch on the live stream if the students aren't around or something.
Okay, thank you.
All right. And can I? All righty. Put in waiting room. All right, there we go. All right, Ms. Tapia, you are up.
What he said?
You're up. So just like yesterday, please say and spell your name, say your school, say whether you represent appellants or appellees, and your issue you're arguing.
Okay. Hi, good morning. My name is Tia Tapia, TIAH TAPIA. I'm representing Charlotte Amalia High School for the appellant side for Buck Island.
Are you ready, Attorney Tapia?
Yes, I'm ready.
You may proceed.
Okay. Good day, Chief Justice, Associate Justices, and may it please the court. I am Tia Tapia, and I, along with my co-counsel, Shawty Richardson, represent a state of President et al. In a matter before the court today. Your Honors, before this court is a string of questionable, controversial, planned acquisitions of land to eminent domain by the United States Postal Service. In regards to Buck Island, if this action is not stopped, the Postal Service will cause irreparable harm to the Buck Island National Monument, both on land and underwater, the environment, ocean life, and the rights of the inhabitants of the United States Virgin Islands.
What is the test we should apply in determining whether or not they should be stopped?
May you please repeat? I didn't hear that.
What is the test that we should apply in deciding whether or not this construction should be stopped?
I will be using the proclamation, Kennedy's proclamation, along with 28 VIC section 414, along with others.
Go ahead.
We intend to establish that the Moot Superior Court erred in denying the request for injunctive relief and that the ruling should be vacated for the following reasons. The condition outlined in the Buck Island National Monument Proclamation demands injunctive relief, and the development will cause irreparable harm to the land, will be a clear violation of the Virgin Islands Open Shorelines Act and other statutes of Virgin Islands law.
Counsel, you have used a couple times now the term irreparable harm. How do you define that?
Your Honors, I'm basically trying to say that whatever damage will be done if the postal officers do continue with this plan would be considered as irreparable harm, that the damage cannot be undone.
Okay.
To my first point, Your Honors, President Kennedy's proclamation states that Buck Island was relinquished to the United States for the facilitation, establishment, and administration of a national monument. This is specifically for the protection of 5 things: this unique natural area, the rare marine life, one of the finest marine gardens in the Caribbean Sea, the caliber and scientific importance on the coral reef, and the educational value to the students of the sea and to the public. And then the proclamation noted the conditions for this monument. Building and construction on Buck Island is strictly prohibited. The construction of a postal hub clearly violates that. The proclamation also states a condition that the people of the Virgin Islands...
If there's going to be a public benefit to a building, cannot there still be building as long as it's for a public benefit?
Yes, Your Honor, but later in my argument, I will be addressing why this public benefit might not be seen as an actual public benefit. Later on in my argument, Your Honor.
What about the protection it gives against hurricanes?
As stated in their plan, they said that the postal hubs and the office for the postmaster, the apartment complex, will be built to withstand Category 5 hurricanes.
Isn't that a public benefit?
Yes, Your Honor, but mostly when you're on a hurricane, people wouldn't really be staying in a postal hub. They would most likely be in their homes looking for protection.
Is it legal to construct any building on Buck Island?
No, it is not, Your Honor.
Why isn't it?
Why not?
It violates the Open Shorelines Act and Kennedy's proclamation to protect the national monument.
Are you saying that any building on Buck Island would violate the Open Shores Act and violate the proclamation, the presidential proclamation by President Kennedy?
The proclamation will be violated by them clearing 80% of the land, and 2/3 of the shorelines will be violating the Open Shorelines Act.
But Turtle Beach is being left intact, isn't it? Isn't that where most of the recreational activity takes place?
Yes, but the Open Shorelines Act specifically states that no kind of obstructions shall be built on the beaches that would be inhibiting. Even though it is only 5%, it is still an obstruction that is inhibiting the people of the Virgin Islands from enjoying their recreational activities.
Doesn't that have to be balanced, though, against the public benefit that a particular building might allow? In this case, there's really a problem with mail delivery and timely delivery, and isn't it the case that this building is supposed to address some of the problems that bear on people, for example, getting medicines in a timely fashion and merchandise for stores? Doesn't there have to be a balance of some sort?
Yes, there could be a balance, but there are many other suited islands that they can build this postal hub. And later on in my argument, I'll be addressing why these the postal service would not really help with the improvement of the delivery rates. Okay. The proclamation also states as a condition that the people of the Virgin Islands are allowed their forbidden and recreational activities with no restrictions and no limits. Yes, a postal hub could improve the mailing rates, but the sacrificing of our national monument is not worth it for an extra day or two of mail. For example, Amazon offers same-day shipping, but it is not available for the Virgin Islands. The building of this postal hub will not help the Virgin Islands get their packages faster because of our location. It will only hamper
The very fact that Amazon deliveries is not available would seem to me to be an argument in favor of the Postal Service doing whatever it can to expedite delivery for the very reasons that Judge Lewis suggested. We're not just talking about postcards at holidays. We're talking about people receiving their medicine on time.
Yes, Your Honor, but later on in my argument right here, I will address that.
We've only got a few minutes left, so why don't you go ahead and answer that now?
No problem. It will only hamper our monument and natural wildlife. Your Honors, the problem isn't our sorting facilities and the post offices we have on islands now. It's how it gets here from the United States and other countries. Also, Your Honors, there's nothing stated in their plans to put a customs clearing center. Certain mail coming from certain places has to be cleared. Opposing counsel, I would like you to answer this question. How do you plan to clear these foreign items coming into the Virgin Islands? The proclamation even gives express warning to all unauthorized persons not to appropriate, injure, destroy, deface, or remove any feature of the monument and not to locate or settle upon the land of the monument. 28 VIC Section 414 states, before any property can be taken, that the use to which it is to be applied is authorized by law, and if it is already appropriated for public use, the taking must be more necessary. The proclamation blocks a construction outright, and while the public would benefit from improved mail, the risk of
But what is the test? This is here on a summary judgment. What is the test for whether or not the summary judgment was appropriate?
Please repeat that. I didn't catch that.
Yes, this is here based upon the Superior Court's award of summary judgment. What is the test for our reviewing summary judgment?
We will be reviewing a heightened standard of review, Your Honors. Heightened scrutiny is needed. As stated in Norwood versus Horney, it states when authority is delegated to another, the courts must ensure that the grant of authority is constructed strictly and that any doubt over the property of taken is resolved in favor of the property owner. To sum up, Your Honor, the court has to review our plan over again to make sure that the Postal Service plan over again to make sure that it benefits the public and not harm it. As stated in Water Isle Hotel v. Contiki, U.S. Government of the Virgin Islands v. St. Thomas Beach Resorts, and Revere v. Hope, the Virgin Islands has jurisdictional powers equivalent to a state to regulate property, including federal property in the Virgin Islands. By using concurrent jurisdiction, the court has to recognize our request for the injunctive relief so that we'll be able to regulate what happens on our national monument. Opposing counsel may say these were early plans and that this was just a leak, but the conspiracy to build coincides with the hiring of contractors and entering into an agreement showing that they were planning to move forward and build in secret. They say this plan was the favor in public by justifying it.
Wait, hold on a second. You said build in secret. What do you mean by that?
Their plans, they kept their plans, like they did not release their plans to the public, Your Honor. Their plans was only leaked because of a pure cyber security system.
Did they have any obligation to release it to the public at this stage in the development? Was there any legal obligation to do that?
I would say yes, Your Honor, because once they were moving forward, they hired contractors and other things to start building. So once you are starting to build on a national monument that is there for the Virgin Islanders, the public should be able to have a right to know.
And where does that right come from?
Repeat that, Your Honor?
Where does that right come from? You're saying there's a right to know. Where does that right come from? Is there a constitutional right? Is there a statute? Is there a case?
Yes, Your Honor, but right now the case is not coming to me.
Okay. Not coming to me either.
I see that my time is about to elapse. May I please conclude?
Yes, you may.
They say this plan was in favor for the public by justifying it with Kelo versus City of London, but cases ruled after like Norwood v. Horney, their plan can be seen as nothing else more than them justifying the use of Buck Island for public use by using eminent domain, when in actuality they are benefiting from it more than the public. They clearly stated more than once that they only chose Buck Island because they didn't have to pay just compensation. This clearly shows that they are looking out more for themselves rather than the people of the Virgin Islands. And even 100 years before Keller v. the City of London, cases like the Country of Wayne v. Hancock referenced Judge Cooley's ruling stating that economic benefit isn't enough to satisfy the public use benefit. In brief, Your Honors, we can admit that the Postal Service is a necessity, but defacing 80% of our national monument, taking 2/3 of a shoreline from this monument and building into the ocean, affecting the marine life, is not necessary. There are many obvious flaws and gaps in their plan, and they are risking a loss that can never be regained. If the Postal Service is allowed to move forward with the Virgin Islands risk to law of rare habitat, a unique natural area, and rare wildlife, the Buck Island Proclamation, Open Shorelines Act, and 28 VIC Section 414 will be violated. The Postal Service can find somewhere else best suited and provide just compensation where these violations can be avoided. It is for the aforementioned reasons, Your Honor, that this court should vacate the Moot Superior Court's ruling for injunctive relief and install judgment in favor for my clients. I yield the floor to my co-counsel, Attorney Richardson, and thank you.
All right, judges, take some time to complete your score sheets. Oof, and just let me know when it's done and we'll get the other students started. Judge Lewis, are you still filling your score sheet?
Yeah, I'm set. Thank you.
Oh, you're all good? Justice
Yep.
Brett, you good?
Good.
And Judge McKee?
Yep, I'm okay.
All right. With that, then, Ms. Richardson, please spell your name and say your school, your appellant, and issue.
Good day. My name is Shadi Richardson. SHADEAE Richardson. RCHAARDON. And I represent the Charlotte Amalia High School on the side of Presser et al., the appellants for Great and Little St. James. May I begin?
Yes, you may begin, Attorney Richardson.
Good day, Chief Justice, Associate Justices, and may it please the court. I am Shadi Richardson, and I am also representing the estate of Presser et al. In the matter before the court today. Your Honors, present before the court is the matter in which the citizens of the Virgin Islands are at risk of having their fundamental rights taken away to build a structure that is to benefit the people. We intend to establish
What
that...
fundamental right are you referring to?
Excuse me, Your Honor?
What fundamental right is being taken away?
I would like to intend that not exactly the fundamental rights being life, liberty, and the pursuit of happiness, Your Honor, but they do have a right
to the shorelines and the beaches surrounding Great and Little St. James, which will be taken away, and I will address in my argument.
Okay.
We intend to establish that the Moot Superior Court should not grant the respondents with the jurisdiction to acquire the privately owned islands of Great and Little St. James, and that ruling should be vacated for the following reasons. Point 1. The acquisition of the islands known as Great and Little St. James for the construction of the postal hub is a clear violation of the Open Shorelines Act of the United States Virgin Islands. Point 2. It would be impossible, in accordance with the facts, to construct the postal hub on Great and Little St. James without damaging the surrounding environment, more specifically, the coral reefs. To my first point, Your Honors, the United States Postal Services wishes to be granted the lands known as Great and Little St. James for the construction of a postal hub in the Virgin Islands territory. The acquisition
What process is the post office using to obtain these two islands?
Excuse me, Your Honor, can you repeat that question?
Sure. What process is let me ask the question a little differently. How is the post office going to obtain the lands that is Greater St. James and Little St. James, where it intends to build the postal hub?
Can I be able to address that in my argument, Your Honor?
Well, why don't you answer the question?
Excuse me?
Yes, you say you will address that in your argument, but you're being asked a question by the Chief Justice. So rather than telling her you'll get to it when you want to get to it, why don't you just answer her question?
Okay. So, Your Honor, under eminent domain, the Postal Services has the right to use the land, but they would have to use it correctly. The Postal Services plans to build a luxury apartment for the benefit of the postal master and the workers, which is not incidental, necessary, or appropriate to the carrying on of the functions of the Postal Services, as stated under Title 39 U.S.C.A. Section 40110. Because, Your Honor, let's be honest, the postal master nor his workers have a luxury apartment right now. In the
Well, you started out by mentioning these was privately owned land, at least on St. James. So that is right. It's currently privately owned?
Yes, Your Honor.
Well, it's being shifted from a privately owned estate to something which is there to, by definition, to benefit the public, to being publicly owned. Why isn't that a public use by definition? It's going from private ownership to public use.
That's a good question, Your Honor. The postal hub can be seen as a public use because it is a public benefit, as outlined in Title 28 of the Virgin Islands Code. But, Your Honor, the islands of Great and Little St. James are split into two properties. Part is owned by the estate of the deceased title owner, and the other, being the beach and the shoreline, is granted to the people of the Virgin Islands collectively. Although the people of the Virgin Islands do not actually own the shoreline, nor the beaches under Title 12 of the Virgin Islands Code, Section 402, states that the public individually and collectively has and shall continue to have the right to use and enjoy the shorelines of the United States Virgin Islands.
Well, if the shorelines are being used to get people their medicine and their mail, don't they still have the benefit of the shoreline?
Can you repeat that question, Your Honor?
I'm sorry. Yes, if the shorelines are being used to get people their mail, their medicine, their mail, their packages, why doesn't the public still have the benefit of the shoreline? Plus, it's not protecting them from a hurricane.
Your Honor, they do have the benefit to the shoreline, but as stated under the case of eminent domain, their enjoyment and use of the shoreline will be interfered with because they no longer would be able to access the beach in the way that they used to, Your Honor.
Well, but it's a different use, isn't it? I'm sorry. Go ahead, Judge.
I was just going to ask you, counsel, so isn't there some sort of balancing that has to take place, or what? How does the court determine which is better in this situation? On the one hand, you have the benefit of faster delivery, medicines, merchandise, et cetera, but you are arguing that because there is an impact on the ability to use a shoreline that the court should necessarily rule in your favor. How does the court make that determination?
That's a great question, Your Honor. Let's think of it this way. In the 2005 case of Kello versus the City of New London, the plan intended that the economic development and the benefits qualified as public use and authorized the taking. About 14 years later, in the Putney case, the economic benefit alone was not enough to authorize the taking. The ruling in the Putney case proves that the increase in revenue, more jobs, and more essentially, faster mail services being the economic benefit for the Virgin Islands is not enough to authorize the taking of the land. To do so, however, Your Honors, according to the case of Cole versus the United States, the Fifth Amendment contains a provision that private property shall not be taken for public use without just compensation. Although the citizens do not own the lands, their use and enjoyment are being interfered with, making them...
So is the issue here how much money was received by the estate? So you're saying that it has to be taken only with just compensation. So isn't the only issue then whether or not they got enough money in exchange for the taking?
Your Honor, as of right now, they have not received any money as yet.
Well, but you're not arguing that they're not going to get any money, though, are you?
That's not what I'm trying to argue, but I'm trying to argue, are they willing to give them the money? That is what I'm about to argue right now. If you allow me.
I'm sorry. Say it again, please.
I'm about to argue if they'd be willing to grant them this, give them this money. If you allow me to argue.
Okay. All right.
Your Honors, based on the Postal Service's plans, we are spending additional funds to build an entire hotel to fund the development, putting us in more of a financial bind. If the Postal Service is finding hardship in funding the development, where would the money to compensate the people individually come from, and how would they do it? Consider this. In 1917, the Virgin Islands and surrounding islands were sold for $25 million in gold. Adjusted for inflation today, that's approximately $513 million, Your Honors. The United States Virgin Islands population is approximately 100,000 people. Hypothetically speaking, let's say we wanted to be generous and give them Great and Little St. James for even 1% of that $513 million. They would have to justly compensate each Virgin Islander $5 million individually. With the Postal Service...
You're assuming that all of the conditions surrounding the initial purchase are the same, but at the time the Virgin Islands were acquired, there was a world war pending. There was a hurricane that had just devastated the area, and that was one of the reasons why Denmark wanted to get rid of it. How can we possibly come up with any kind of an equation that would allow us to put a dollar value per resident today, comparing that with the initial purchase price? That's an impossible metric, isn't it?
Your Honor, I have to disagree respectfully because...
Well, you don't have to. You can agree. There's no law that says you have to disagree with me. Why do you disagree?
Because in Title 12 of the Virgin Islands Code, Section 4028 states that the public individually and collectively has and shall continue to have the right to use and enjoy the shorelines of the United States Virgin Islands. Your Honors, if you are to take the lands and the shorelines that they have the right to under law, then you do have to justly compensate them. Do you not?
Well, I'm not sure. This is for an opportunity for you to ask us questions.
Oh.
Go ahead. There's another question, I think, by one of my colleagues.
That was a rhetorical question, Your Honor. What I was intending is that you have to do it. That's something that you have to do. May I proceed?
Yes.
Yes, you may.
Would the Postal Services be willing to pay this amount to each Virgin Islander? Essentially, is it an effective way to use $5 million? These are points that counsel, opposing counsel to be specific, should address. To my second point, Your Honors, in regards to the St. Thomas East End Reserve Management Plan of 2011, in 2008, DPNR, Division of Coastal Zone Management, received an application submitted by WT Enterprises to moor a vessel in Christmas Cove to operate as a floating bar and restaurant on Great St. James Island, which was designated as a marine reserve and wildlife sanctuary. This upset the public so much, Your Honors, so much that they felt the need to review the regulation. Little did they know, mooring the vessel was not prohibited, but it also did not strengthen the goals that upheld the area as a reserve, being to protect the ecological value of the area, to protect the value of the area for scientific research, to protect the ability of the area to support fisheries, and to protect the ability to maintain recreational use of the area. Your Honors, I see that my time has elapsed. May I be granted some time to conclude?
Yes, you may.
Thank you. Groups such as DPNR, the University of the Virgin Islands, the Nature Conservancy, and a community group called the Friends of Christmas Cove partnered to create a management plan for all the designated MRWs on St. Thomas's East End. Look at it this way, Your Honors. The public reacted so negatively to the mooring of a vessel. How do you think they would react to the building of an entire postal hub? In no way, shape, or form, in accordance with the facts, of course, can the postal hub be built without harming the surrounding environment. The Postal Services plans to construct a deep water pier extending 450 yards out into the ocean, which we can reasonably assume will harm the coral reefs and underwater sea life. In the case of the United States and the government of the Virgin Islands versus St. Thomas Beach Resort, Bolongo Bay even attempted to erect a fence that would close off access from the public to the beach, but were denied because it violated the Open Shoreline Act. While the fence, the floating bar and restaurant, and in this case, the deepwater pier, would still allow the public to go under, over, or around it, it still provides a similar obstruction for the public.
Okay, well, your time is up, so I gave you some time to conclude.
Okay.
So
Well,
you must conclude.
I would like to conclude after I pose opposing counsel with some questions, Your Honor. Is that fine with you all?
You have to conclude now.
Okay, thank you, Your Honor. In brief, Your Honors, if this acquisition of Great and Little St. James can stand, we risk potentially losing the trust and the respect of the people of the Virgin Islands by taking away their use of a public shoreline and beach. Additionally, we risk harming fish and wildlife for the development of a postal hub, which is not nearly equivalent. It is for the aforementioned reasons that this court should vacate the Moot Superior Court's ruling and install judgment in favor of my client. On behalf of my co-counsel and the estate of Presser et al., thank you.
All right, thank you. Judges, let me know when you're done with your score sheets, and I will get the people moved in from the waiting room.
In terms of score sheets, all I did was take the agenda with the names and I formatted it in such a way that I can grade in that margin. I'm using a 10-point scoring system. Was there a more formal score sheet sent out?
Yes, I might not have, I can send you an electronic one.
Okay, I'll try to format that or use that.
Adam, do you need me to send one? I have one that I can pull real quickly.
Oh, I have it. I'm sending it now.
All right.
I heard a beep which tells me that something came into my inbox, but I'm not seeing it.
All right, it looks like it just cycled out, so it should come through pretty quickly.
Okay. It's on my iPhone, but not on my, didn't get on my laptop.
Oh, okay.
I'm going to try closing out my mail and opening it again.
All right. Antilles, is anyone else that I should be adding to this, or are you all there
Okay.
to hear?
Here.
Okay.
Thank you.
Okay.
You ready to go, Judge McKee?
Yeah, I can fill this in as we're going, but I have it.
Okay. And Justice Cabret, you all set?
Yes.
And Judge Lewis, you all good?
Yes, I am. Thank you.
All right. Then please spell your name, the school you represent, party, and issue.
I am Kashish, K-A-S-H-I-S-H, Chinani, C-H-A-I-N-A-N-I. I'm from Antilles School, and I represent the appellees. Issue 1.
Are you ready, Attorney Shinani?
Yes, I'm ready.
You may proceed, Attorney Shinani.
May it please the court. Good morning, Your Honors. I am Kashish Chinani, and along with my co-counselor, Aisha Kimani, I represent the appellees, the U.S. Postal Service. I'll be addressing Issue 1, whether the Superior Court erred by denying the appellant's request for an injunction. Our position is that the lower court was correct and the injunction was unnecessary. The Postal Service will prevail under consideration of the 4 prongs which were established in the court case Rivera versus United States. The first prong is the likelihood that the moving party will succeed on the merits. The second prong is whether irreparable injury will befall the moving party if injunctive relief is withheld. The third prong is whether the injunction will cause greater harm to the non-moving party. And the fourth prong is whether public interest is furthered by the court granting the request for injunctive relief. The first prong, the likelihood that the moving party will succeed on the merits, fails because the addition of the post office is not in violation of the President Kennedy's proclamation or the Virgin Islands Open Shorelands Act.
Well, under that proclamation, how was their authority to convey title to these properties to the post office? Doesn't it specifically prohibit any agency of government from taking title or changing the natural use of the property?
So President Kennedy's proclamation says that no one should be limiting, restricting, or reducing the existing bathing and recreational privileges of the island. And with the building of the post office, the Postal Service is not reducing any recreational activity to the island because the beaches are still open and Turtle Beach has 95% of the island's recreational activity.
But it is limited, though. It's not the same, isn't it? By definition, it's more limited after the post office's activity than it was beforehand. And the proclamation it gives the Secretary of the Interior the sole right to supervise or manage and control the property. And
No, Your Honor, respectfully, we are not limiting any recreational activity on the island, and rather we are adding extra sources of recreational activity with the top floor of the facility on the post office. And the Secretary of Interior was within his authority to collaborate with the Postmaster General in the construction of this postal hub, which is within the postal powers, which were granted to the Postal Service by Title 39 of the U.S. Code, Section 401.
Isn't 80% of the island being cleared to build this facility?
Yes, Your Honor, 80% of the island is, sorry.
Go ahead. I'm sorry, you go ahead.
80% of the island is being taken over to build the post office, but the Postal Service is implementing a marine ferry as well, which would accommodate for 200 people every 20 minutes from St. Croix to Buck Island, which would increase public access to the island and provide the inhabitants with free access to Buck Island. Currently, only those who have access to private vessels or the funds to pay for expensive charters can access Buck Island, but with the marine ferry, everyone will be able to access Buck Island to receive improved mail and delivery services by 75% and enjoy all the recreational activities that the Postal Service is providing them and which Buck Island has.
Is this amount,
Go ahead, Judge.
is this amount of traffic back and forth, the ferries every 20 minutes, for example, going to affect the ability of residents of the Virgin Islands to go snorkeling, enjoy the fishing, the sea bathing? And what about the clearing of the island for purposes of building this facility? There was hiking that took place there. Isn't there quite a bit of the kind of activities that went on Buck Island going to be now much less than it was before?
No, Your Honor, all recreational activity will be preserved because we are not violating the Virgin Islands Open Shorelines Act either, because the visitors will still be able to snorkel, swim, lime, and hike, as Turtle Beach will still be open to all of the inhabitants, holding 95% of the recreational activity, and there is an underwater snorkeling trail, and the island will still be open to hiking, and rather this post office just provides them with 75% improvement of delivery, because before this, the Postal Service was facing severe financial, staffing, and operational challenges, which hindered the profitability of small businesses and prevented inhabitants from reaching essential medicines in a timely manner.
What about the piers? I cannot imagine building these piers without severely damaging the ecosystems.
Yes, the piers will be built, and they will not be damaging the ecosystem, and they'll be used to for vessels to come to Buck Island and provide the Postal Service with the improvement of delivery, as from Puerto Rico, the vessels will be able to access the island. And since Buck Island is so central to St. Croix, St. Thomas, St. John, and Water Island, all these islands and all the inhabitants will be benefiting with this with the implementation of the post office.
Well, I can't imagine that amount of traffic is not going to create a real problem.
No, Your Honor, it will not create a problem, but rather it would increase access for the inhabitants with the marine ferry, and the vessels accessing the island will provide them with improved delivery time as well as increased access to Buck Island.
Go ahead, Chief.
Won't all of this additional traffic restrict the use of the island for fishing? You know that that is one of the recognized rights in the proclamation.
No, Your Honor, the fishing and bathing privileges by the inhabitants will be preserved, as they will still have access to Buck Island and all the recreational activities and the ability to enjoy the island and its amenities.
Counsel, is it your position that there will be no change at all in the kinds of activities that individuals are allowed to enjoy now on Buck Island? But there will be no change?
It's our position that the recreational activity will be preserved, and rather the Postal Service will be adding extra sources of recreational activity, with the top floor of the facility providing 360 degrees of unobstructed views of St. Croix and the surrounding islands.
All right, well, I hear you arguing that the recreational activities will be preserved, but the proclamation says that they are not. That just tells me that you may have some recreational activity, but the proclamation by President Kennedy specifically says that the existing fishing, including the landing of boats and laying of fish pots outside of the marine gardens, bathing, or recreational privileges by the inhabitants of the Virgin Islands shall not be reduced or limited, restricted, or reduced. Isn't by necessity when I hear you speaking about all of this development, aren't these recreational activity going to necessarily be reduced?
No, Your Honor, these will not be reduced as the Postal Service is implementing the marine ferry and accommodating for the public to access these recreational activities as well. And Turtle Beach has 95% of the recreational activity where these inhabitants come to swim, snorkel, lime, fish, and enjoy their times. On Sunday fun days, they come with their own boats, and they will still be able to come and enjoy the islands with their own boats. We are not limiting or reducing or restricting any of their access.
I'm sorry, go ahead.
Rather, we are increasing their access and their ability to enjoy Buck Island.
What about the other 5%?
The 5% will still be accessible with the hiking in the island, and any loss will be extremely de minimis. So all of this falls under the Postal Service's postal powers from Title 39 of the U.S. Code Section 401, and these were strengthened in the U.S. Postal Service versus Council of Greenberg Civic Association Supreme Court case as well, where they ruled that the Postal Service is broadly empowered to adopt rules and regulations. In prong 3, this would also harm the Postal Service because without this new post office, they will continue to suffer severe financial, staffing, and operational challenges. Buck Island is the perfect location, and granting the injunction will indeed harm the Postal Service because they won't be able to build this post office. And the contracts have already begun. I see that my time has elapsed. May I please conclude?
Yes, you may conclude.
Thank you. The Superior Court was correct in denying the injunction because the appellants are not likely to succeed. Irreparable injury will not befall the moving party if injunctive relief is withheld. The U.S. Postal Service will suffer greater harm, and the public interest will not be furthered. The plan does not violate either President Kennedy's proclamation or the Virgin Islands Open Shorelines Act. In conclusion, on behalf of the U.S. Postal Service, we respectfully request that you affirm the lower court's decision to deny the appellant's request for injunctive relief. Thank you.
Counsel, before you take your seat, we talked a lot about the presidential proclamation. Could you just address for us the issue of the Open Shorelines Act and why this development does not violate that act?
Yes, Your Honor. The Open Shorelines Act says that no one should create any obstruction that would interfere with the right of the public individually and collectively to use and enjoy the shorelines. In our case today, this addition of the post office is not interfering with the right of the public individually and collectively to use or enjoy the shoreline. The Postal Service is actually helping them gain extra access to the island and to enjoy the recreation activities on the island with gaining an improvement of 75% of improved delivery time and mail services.
Thank you.
Thank you.
All right, let's get the next contestant getting ready while the judges complete their score sheet. Alrighty, I don't want to rush the judges. Where are we on the score sheets?
Okay.
I'm good.
I'm good as well.
All right, then, Ms. Kimani, please say and spell your name, school, appellant or appellee, and which issue.
Good morning. My name is Aisha, A-I-S-H-A. Last name is Kimani, K-H-E-M-A-N-I. And I'm from Antilles School, representing the appellee, U.S. Postal Service. K2.
I'm sorry, could you spell your name one more time for me?
A-I-S-H-A, and last name is K-H-E-M-A-N-I.
Thank you.
Are you ready to proceed, Attorney Kamani?
Yes.
You may proceed then.
Good morning, Your Honors. May it please the court, my name is Aisha Kimani, and along with my co-counsel, Kashish Chanani, we represent the appellee, the United States Postal Service, in the case before the court today. I will be addressing issue 2, whether the Superior Court erred when it found that the takings of Little St. James and the parcel of Great St. James were public uses within the meanings of the eminent domain clause of Section 3 of the revised Organic Act. Our position is that the lower court was correct in ruling that these takings were for public uses. The taking of Little St. James for the purpose of establishing a new postal sorting facility was for public use, as it would allow for faster and more efficient delivery of mail throughout the territory, and therefore would provide an essential service.
Help me understand your concept of public use. Don't we have to interpret the meaning of public use in context with the natural setting of the islands here?
So I didn't hear the first part of your question.
Okay, I'm saying, help me understand the concept of public use. You're saying that public use because it's going to be a post office. By that broad definition of public use, a landfill could be a public use because it would be facilitating waste disposal for everybody in the area. So don't we have to factor in the very clean nature of the island when we consider public use, and the fact that the public use was intended to facilitate enjoyment of the natural resources of the island, not just benefit the public in a more broad or more amorphous way?
The definition of public use we're applying here today is a public building in the grounds for the use of any town, village, school, or other governmental division for the benefit of all inhabitants.
So the natural habitat, the natural setting, the beaches, the fishes, the snorkeling, that's kind of irrelevant, you're saying, as long as there's an overall amorphous benefit to the public.
Yes, and here the benefit that we're arguing for is a more effective postal service.
Okay, so what if they were to put it in a landfill, and they were to take away Turtle Beach? Let's say they take away only half of Turtle Beach, and they turn it into a landfill to facilitate disposal of the garbage and recycling everything else in the islands. Would that be a public use in your definition of public use?
Yes, if it provides greater benefit to the people of the Virgin Islands.
An airport, let's say they do away all the natural beauty of the Buck Island and turn Buck Island into one large landing strip for commercial airplanes to land. That would be a public use also. That would be okay.
Respectfully, Your Honor, I'm talking about the taking on of Little St. James and Great St.
Okay, thank you. So let's forget Buck Island for a second and talk about St. James, Greater St. James, Little St. James. If they were to turn those into two large landing strips for commercial use for airplanes, that would be okay because that's a public use?
Well, if the benefits were for the people of the Virgin Islands and were essential. Because in this case, the reason the Postmaster General decided to exercise the eminent domain clause is there was severe, after facing severe financial problems, the Virgin Islands the Postal Service couldn't effectively deliver mail to the people of the Virgin Islands. And this included essential medicines. And
What about the language in the proclamation that talks about prohibiting any limitation of or restricting fishing, land far parts outside of the area, bathing, recreational privileges of the inhabitants, or charging a fee for admission? What do we get from that language in terms of the dedicated purpose of these islands?
Well, the dedicated purpose of this project would be to provide essential postal service.
Okay.
Could you expand on maybe what you're trying to get at?
Yes, what troubles me here is your use of the term public use, and you seem to be saying that as long as it benefits the public in any way, even in a commercial sense, that's okay. But as I read all the restrictions around all of these islands, your island, Buck Island, the public use here is supposed to be for some sort of recreational enjoyment, natural beauty, snorkeling, fishing, that sort of thing. Not for a commercial use like building a post office, which does benefit the public, but it does it only by destroying the intended purpose of the initial grant of Buck Island and St. James.
Well, as I said, the reason in this specific project was because we had this inefficient postal service that was greatly affecting the people of the Virgin Islands. Essential medicines weren't being delivered. Businesses were having their profits cut because they weren't able to deliver on time. And so according to Title 39, United States Code Section 401, the general powers of the U.S. Postal Service include the Postal Service's authority to exercise the right of eminent domain for the furtherance of its official purposes.
Well, so you seem to be arguing that one public use is more important than another public use. In other words, receiving mail in a timely fashion is more important than the inhabitants of the territory enjoying the shorelines and the open shorelines and all the amenities that go along with having open shorelines.
Well, regarding the issue of open shorelines, this shouldn't be a point of contention right now, since according to the VI Supreme Court, the case Rollfresh versus Henry, if the party doesn't present the issue to the lower court for determination or fails to make an argument during briefing, it is waived. And in this case,
but my question to you is, are you arguing that one use can be more important than another use?
No, that is not our position here today.
Okay, so what is your argument?
My argument is that this taking on a Little St. James is absolutely necessary, since there were severe effects that were debilitating to Virgin Islands residents. And the taking on Little St. James allows the Postal Service to establish a new postal sorting facility where the existing mansion is located on the island. This would help create faster and more efficient mail delivery service, speeding up delivery times by 75% as well, which would make it comparable to urban cities in the United States.
Let me follow up for a moment on the Chief Justice's question here. But aren't you, in effect, valuing one use over the other? In other words, you're saying that this was absolutely necessary because it's going to speed up the delivery of the mail, people can get their medicines and so forth more easily, and certainly there are those benefits. But aren't you completely ignoring the benefit that comes to the public from being able to enjoy the natural beauty of the islands and to enjoy the recreational activities that come from the nature, the ocean, the shoreline, etc.?
No, that is not our position, and we're not trying to diminish that, although we are stating that the Postal Service is a necessary, this is a necessary taking under that definition.
Well, Bill, you're saying that a land use, a landfill, would be just as viable and appropriate a use of the public use of the space as a nature reserve. And I'm looking at the steer management plan, and you can't help but look at that and be impressed by the fact that they were very concerned about preserving the natural beauty and serenity of the islands. The Nature Conservancy, it looks like, published this, and I see birds flying, I see gorgeous beaches. I don't see anything that would be consistent with a public use as you're defining it, i.e. a landfill. We're talking about preserving mangroves, seagrass beds, coral reef communities, nursery and fishery resources, compatible and sustainable use and enjoyment goes to all of those things. But yet you're saying they could turn this whole thing into a landfill, the public would be benefited, and that would be just fine.
Well, again, the reason the postal powers is different than a landfill is the post office, according to Title 39, United States Code Section 401, is given the right to exercise this right for the furtherance of its official purposes, according to this country. So furthermore, there will be a taking on Great St. James that would basically finance the project on Little St. James. It's estimated that this project would bring in an additional $780,000 in revenues through hotel fees, port fees, airport fees, and spending at small businesses in the Virgin Islands. The hotel would also employ various staff members from the Virgin Islands, including musicians, pool workers, mechanics, boat captains, and would create numerous job opportunities locally for the Virgin Islands. Our justification of this taking comes from the U.S. Supreme Court case, Kelo. Kelo states that taking of private property in accordance with an integrated economic development plan satisfies the public use requirement.
Yeah, but Kelo, go ahead.
We're not bound by that determination in defining public use as it pertains to the statute, are we?
Well, Kelo is a U.S. Supreme Court case, so it would be binding. Although, however, I would note that Kelo was interpreting the Constitution and not the Organic Act.
Right, and isn't it the case that even in Kelo, it said that there are greater restrictions that can be put on the definition of public use in various jurisdictions. And that's why I was asking you whether we're actually bound by that in interpreting our provision here in the Organic Act.
Well, it is persuasive, and I would like you to apply the analysis of Kelo when you.
But we're not bound by it, are we?
No.
Okay,
well, I'm sorry, Judge.
Go ahead, Chief.
Okay.
No, go ahead.
If we are not bound by it, are you asking us as the highest court of this territory to define what public use means?
Well, our position is that we're asking you to apply the analysis of Kelo.
Well, that doesn't help us. That doesn't help us a great deal. Also, Kelo dealt with a shopping mall, which is very different than what we have here. There, arguably, a public use that was a commercial use would be okay. But here, and that gets back to my original dialogue with you, I'm not sure that any commercial public use is consistent with the restrictions on these properties.
So although the facts may be different in Kelo, the eminent domain clauses are the same. And therefore, our position is...
But the uses are different, though. The public is very different. The use is very different. And that's why I'm not sure Kelo helps you here.
Are there any questions? So another U.S. Supreme Court case that says that gives the Postal Service all these powers is the U.S. Postal Service versus Council of Greenberg, which found the general powers of the U.S. Postal Service are very broad. Additionally, under Title 28, Virgin Islands Code, Section 411, it's stated that a government entity may exercise the right of eminent domain for specified public uses, which applies in this case.
But we would still have to have some definition of what a public use is, regardless of the breadth of the Postal Service's authority to use eminent domain as a means of acquiring land. We would still have to know what public use is under the circumstances here, wouldn't we?
Well, public use, according to Title 28, Virgin Islands Code, Section 411, is a public building for the grounds of, and grounds for the use of any town, village, school, or other governmental division that benefits all inhabitants. And right here, this taking benefits all inhabitants who would receive more efficient mail service.
What about the elite nature of the construction and the building that they're going to put up? How does that benefit all inhabitants? It looks as though they're planning on having a private beach. It's described as being a benefit for elite visitors. How does that benefit all inhabitants? It benefits a certain economic class, but not all inhabitants, does it?
So the benefits of having this, so they would employ various locals, from musicians, pool workers, mechanics, helipad workers, and more. Also, in addition, the U.S. Supreme Court case Kelo states that concerning the economic benefits, the court found that the government's pursuit of public benefit will always clash with the benefits of a private party. However, that won't interfere as long as the benefits, the central benefit is to all the citizens as a whole. I see that my time has concluded, Mayor.
You may conclude.
In conclusion, we respectfully request that this court affirm the decision of the lower court and find that the takings of Little St. James and the parcel of Great St. James were public uses within the meanings of the eminent domain clause of Section 3 of the revised Organic Act. Thank you.
All right, good job. Let us put in waiting room. Mitt. All right. All right. Seventh day, St. Thomas, seventh day, are you there? All righty. All right, Judge McKee, you look like you're good to go, are you?
I am. I'm just finishing up. I'm ready to go.
Justice Cabret?
I'm ready to go.
And Judge Lewis?
Just about.
All good? Okay.
All good.
Ms. Creaky, could you please spell your name, state the school you're from, whether you're appellant or appellee, and the issue you're arguing?
Cricky, spelled AMARAHCREQUE. Are you representing John Seventh-day Adventist School appellants?
I'm having some difficulty hearing you
Yeah,
clearly.
me too.
As am I.
One second, please. Your
Very
Honor.
well.
Yeah, I was gonna say that would make a difference. Now speak, Amara.
Can you guys hear me better?
It's a little better.
A little better. Maybe move the microphone a little higher still.
Yes.
I think it's just too far away. Higher up on your lapel.
Just need to move it higher.
Now speak.
Is it better now?
It's better.
Yes. Yeah.
Okay.
Are you ready?
Yes, ma'am.
All right, you may proceed.
Good day, Moot Chief Justice Cabret and Associate Justices Lewis and McKee. May it please the court, my name is Amara Cricky, and I, along with my co-counsel, Deandra Thomas, will be representing the appellants. Your Honors, may I first start by saying our islands are undeniably beautiful. Our lush greens, bright blues, and vibrant coral reefs attract many visitors curious for an island experience. Buck Island, a monument in our community, stands as a preservative for our history and beauty and enriches our culture. Destroying this gem, Your Honors, would not only endanger any
Well,
natural...
why would it be destroyed? Because almost all of Turtle Beach is being preserved, isn't it? The Sunday fun day opportunities will still be there. Where's the destruction coming from?
I'm sorry, Justice McKee, I couldn't really hear your question. You sound
Yes,
a little bit...
Okay, I'm sorry. I'm saying, why would this destruction be so total? Because almost all of Turtle Beach is being preserved. The special activities such as Sunday Fun Day will still be preserved. Isn't it a very narrow focus taking what we're talking about here?
Your Honor, thank you for your question. That in fact brings me into my next point. Your Honors, the Postal Service's plans to erect a post office on Buck Island included taking up 80% of the landmass to build their post office. Your Honors, the proclamation expressly warns all unauthorized persons not to appropriate, injure, destroy, deface, or remove any feature of this monument, and not to locate or settle upon any of the lands reserved for the monument by this proclamation.
Well, how is this inconsistent with the proclamation? Are you saying there's not even authority on the part of the post office to acquire title to the land?
Your Honor, while the Postal Service has the power to acquire title to the land under necessary and proper, this argument is not sufficient enough to determine whether the Postal Service's actions are appropriate. In fact, Your Honors, their plans infringe on the people of the Virgin Islands' existing recreational activities. Your Honors, the majority of what would have been an island for residents to explore and enjoy would now be a massive concrete structure. The plans also call for shipment of material for building, shipment of mail, and multiple trips of ferries transporting people coming to the island to retrieve mail. I ask that your honors take a
Well, are they coming to the island to retrieve mail, or are they being ferried back and forth? Usually activity. The ferry is running every 20 minutes.
Yes, Your Honor, the ferry does help people get back and forth to the island. However, the ferry is bringing the people to this island. An island that is now destroyed. 80% of this land is now taken up, Your Honor. Not much of it is left for the people to enjoy.
But the important part is left, right? Turtle Beach is left.
Turtle Beach may be left, Your Honor. However, I ask that we actually remember that 80% of this land, the land itself, Your Honor, this national monument, marine life, scientific significance, 80% of that will be destroyed, Your Honor. The residents, Your Honors, also might not be able to enjoy the island like how it once was.
See, what I'm having trouble with is not all of the island, not every square foot of the island is appropriate for leisurely activity. And it looks like the Postal Service is trying to do what it can to preserve intact almost all of the island that is appropriate and dedicated to leisurely activity in nature, and build on the other part, which is does not lend itself so readily to the kind of enjoyment that you're stressing. Why is that wrong? Or why am I wrong?
Your Honor, I respectfully disagree that not all of the island is appropriate for leisure. In fact, Your Honor, the land itself is important. Recreation also includes hiking by residents, Your Honors, which they will not be able to do if 80% of this land is destroyed. Your Honor, the proclamation already predicted that there will be attempts to do just what the Postal Service is seeking to do, as evidenced by the language of the proclamation, stating that, and I quote, "The unique natural area and rare marine life which are dependent upon it are subject to constant threat of commercial exploitation and destruction." Your Honors, we must act to safeguard this.
How much weight should we give that proclamation? It is the proclamation of one person, sure, it's the president, but should that be allowed to overturn what is basically an act of Congress, the elected representative of the people? Why should we allow one single proclamation by one person, who is the president? Why should we give that a priority over an act of Congress?
Your Honor, President Kennedy declared this proclamation through his 1961 Act, the power which was given to him by the American Antiquities Act of 1901. This power was given to him through Congress. Your Honor,
can Congress revoke, once the Congress gives the power, can they rescind it?
I'm sorry, Your Honor, you're a bit muffled. I didn't hear that last part.
Once Congress gives the power, can they rescind it, or is the power there forever and ever and ever and can never be taken back?
Your Honor, in this case, the power was not rescinded. Even if Congress does have the power to take back their power, that was not the case in this situation. Therefore, this proclamation still should hold weight.
Why shouldn't we interpret the arrangement between the Secretary of the Interior and the Post Office as, in fact, Congress taking back that proclamation?
Your Honor, the agreement between the Postal Service and the Department of Interior is not even correct under law. In fact, it's a violation of the National Park Service Act. On August 25th, 1916, Congress passed the National Park Service Act, specifically found in Title 16 of the United States Code, Sections 1 to 3. President Kennedy cited this act when he declared Buck Island a national monument. On December 19, 2014, however, Congress repealed Title 16, Section 1, and passed its replacement, Title 54, United States Code, Section 101, and its following sections. More notably, Your Honor, Section 102-901 of the National Park Service Act sets parameters for what properties are allowed to be transferred. Your Honor, Section 102-901 specifically states, and I quote, "With respect to any property acquired by the Secretary within a system unit or related area, except property within national parks or within national monuments of scientific significance, the Secretary may convey a freehold or leasehold interest in the property. This provision of the National Park Service Act unequivocally prohibits transfers of federal lands that have been designated as national parks or within national monuments.
So you're saying the transfer in and of itself is void and we should ignore it?
Yes, Your Honor, the transfer within itself is unlawful. Buck Island became off limits for transfer when President Kennedy declared it a monument in his 1961 proclamation. Thus, the interagency agreement between the Department of Interior and Post Office are null and void as a matter of federal law. Lastly, Your Honor,
That argument would go to your success on the merits prong of the preliminary injunction that you requested, of the injunction that you requested from the Superior Court. I'm interested in knowing how you argued irreparable injury to the Superior Court.
Your Honor, 80% of Buck Island will be destroyed if the post office is allowed to proceed. This 80% can never be replaced or put back after it's been destroyed. It'll be permanently gone. Therefore, that is irreparable damage. Your Honor, the plan for the post office, the Postal Service violates the Open Shorelines Act under Title 12, Virgin Islands Code, Sections 402 and 403. The Open Shorelines Act defines the shoreline as the area along the coastal lines of the United States Virgin Islands from the seaward line of the low tide running in a distance of 50 feet. Your Honors, the Post Office plans boldly violates this because it contemplates building a pier that extends 300 yards, or rather 900 feet along the shoreline into the ocean.
Is Buck Island, Council, is Buck Island considered federal property?
Yes, Your Honor, Buck Island is considered federal property.
However, let me finish my question then in light of your answer. Then how does the VI Open Shoreline Act apply to Buck Island?
Your Honor, under concurrent jurisdiction, the Virgin Islands legislator does have the ability to regulate or rule any happenings upon Buck Island. As mentioned in the Water Isle versus Contiki case, the district explained that the Virgin Islands legislator. Your Honor, I see that my time has elapsed. May I briefly conclude?
Yes, you may briefly conclude.
In conclusion, Your Honors, if the plans for this proceeds, we, the Virgin Islands, will be left with a mere 20% of Buck Island and 1/3 of the shoreline to enjoy. While the mailing distribution center and facility is important, it can be replaced. A national monument, however, cannot. This court should protect Buck Island and cherish the value it holds to the people of the Virgin Islands and the nation, just as Kennedy did. According to this court, accordingly, Your Honors, this court should reverse the ruling of the Superior Court in an injunction to preserve the beauty and historic value of Buck Island. Thank you for your time, Your Honors, and if there is no further questions, I will yield you to my co-counsel, Deandra Thomas.
All right, well, the judges are doing their scoring. Can we try and work out the issue with the volume on this microphone? She was still pretty quiet. It was improved, but it definitely wasn't as loud as it really should be. All right, Seventh Day, can you get on here so we can hear test volume and stuff?
Good day, Your Honors. Can you hear me?
You're still a little quiet.
Possible to just turn up the microphone?
Yeah, what it seems like is your transmitter or your microphone volume isn't very loud. I don't know what's going on there.
Technician is working on it, Your Honors. This is a test. Testing.
I mean, that's a little better.
This is Ms. Thomas.
I guess you could also just project more, maybe. Try to have just Judge Lewis hear you all the way from St. Croix from St. Thomas.
Right. Speak from your diaphragm.
Yeah.
Hello. Everything's all the way up. This Zoom is suppressing it. And I just changed everything and they're still saying they can't hear. I'm not sure why. So maybe you put it on low? Low background noise? That's why I took it off of. That's the first thing that was on. Testing. That's already past half.
That is improved. Like that is much better.
Okay. Please speak louder.
Testing.
Yes.
Can you hear me better?
Now you're frozen. Okay, yeah. Say that again.
Can you hear me better?
It was, and now it's not again. Say your name, please.
Can you hear me better?
I don't know. What do you think, judges? Is this good enough?
I think it's about as good as we're going to get.
All right then.
I can hear. I can hear all the while St. Croix.
All right, Ms. Thomas, please say and spell your name, the school that you are from, the appellant or appellee that you represent, and your issue.
ANDRA THOMAS. I represent St. Thomas St. John Seventh-day Adventist School, and I represent the appellants.
You may proceed.
Thank you, Your Honor. May it please the court. My name is Deandra Thomas, and I represent the appellant's estate oppressor. Property is where families are raised, where memories are made.
To that argument, there could never be a legal taking.
May you repeat, Your Honor?
Yes, you're saying according to that argument, there could never be legal taking because you can say that the taking is taking away a place where memories are made and people are born and families are raised.
Your Honor, what the Postal Service is trying to do with building a luxury villa for elite guests is unlawful taking.
Why?
It is unlawful taking because they are taking it only for economic and financial benefits, and that is not enough to justify public use.
Well, isn't the economic benefit going to the public, to the people of the Virgin Islands?
The luxury villa will be for, it will be mainly for elite guests. And Your Honor, elite guests sounds like a small portion of the Virgin Islands. And that should not be considered public use.
But isn't about $780,000 going to come into the coffers of the Virgin Islands?
Yes, Your Honor. It was said that, but it is all estimated, and it is only for economic and financial benefits, and that in alone by itself is not enough to satisfy public use.
What about the improvement in the mail delivery, including individuals who are receiving medications by mail, getting them more promptly? I'm hearing a very strong echo.
Yeah. With everybody's
Okay, maybe that's, I'll just go ahead. The benefit, isn't there a benefit to the Virgin Islands residents as a result of mail more promptly and efficiently?
Yes, Your Honor, the mail distribution will benefit the Virgin Islands, but there should be alternatives, Your Honor, to doing so. The Postal Service should have the alternatives that do not require taking private property.
So how would you help me with that? What would an alternative would not involve the taking of private property?
Your Honor, if there is some place that the Postal Service can go to that won't take private property, then that would be good for their case.
Where in the islands would that?
Your Honor, it can be anywhere that public use is satisfied, Your Honor.
Are we bound by the Kilo interpretation of public use? Their definition, their interpretation of it, the Supreme Court's interpretation? I think the screen might be frozen.
We seem to be having some technical difficulties. Adam?
Yes, I'll text the coach and see what is going on here. Here we go. This happened yesterday. They had to log out and log back in. Some things went screwy with the internet, so I was hoping it wouldn't repeat today. But all right, she just said their Wi-Fi went out, so they're adjusting.
Your Honors, can you hear me?
Yes.
Yes, we can hear
Sorry,
you.
Yes.
lost connection. May you please repeat your question?
Yes, I was asking you whether we are bound by the Supreme Court's decision in Kila,
Your Honor,
their interpretation of public use.
we are not bound by the interpretation in Kilo, Your Honor, because in Kilo, the court had a long-standing policy to defer to the legislature. And in our case, it is not the legislature of the Virgin Islands, but rather the Postal Service, who is
Isn't it the same thing?
you were a little muffled. Can you please repeat?
Sure. The grant of authority is being exercised by the Postal Service, but they're only because of a grant of authority from the government of the Virgin Islands. Why isn't that the same situation as Kilo?
Your Honors, in Kilo, the city had a comprehensive and integrated plan to revitalize their alien economy. Here in the Virgin Islands, we do not have a alien economy to revitalize. So therefore, Your Honor, that is not the case.
Well, you said is that in the Virgin Islands, since there's no economy to revitalize, that's different from the Kilo situation, where there is a plan to revitalize the economy.
Your Honor, you are very muffled.
Yeah.
So can you please repeat?
Yes, I recognize that we're having technical difficulties. I'm trying to reach our IT department.
I think the echo is coming because they have the volume in their location on, and that's what's interrupting.
I didn't understand you, Adam.
Shall I continue, Your Honors?
That was better.
Yes, that's
No,
much better.
that's better.
The Superior Court erred when it found the taking of Little and Great St. James were public uses because 1. The Postal Service's plans violate Section 3 of the Revised Organic Act.
Ms. Thomas, can I take you back to where, and I apologize for the difficulty here. So let me know if you don't understand the question. But I thought you said that the difference between our situation and the Kilo situation was that in Kilo, the taking was done pursuant to a plan of economic development, whereas here, there's no economy to develop. Is that what you were saying?
Yes, Your Honor. That is
What?
one of the main reasons.
Okay, wasn't that even more of a reason then for the taking? If there's no economy to develop, and they've come up with this plan to basically revitalize or vitalize, create economic activity, that would seem to be a strong argument in favor of the taking. They're putting up these mansions. There's going to be a lot of, quote, elite tourism. So there will be an economy. They're developing an economy.
That is true, Your Honor. But in Kilo, the court had a comprehensive and integrated plan to do that. In our case, the Postal Service does not have a comprehensive and integrated plan. Also,
Oh, shoot.
Yeah, boy.
All right.
How much time is left?
About 3 minutes and 24 seconds.
Yeah, boy.
So no, when you hold up the time signs, make sure you give the participants time to see them. Sometimes they appear to come down before the person has really had a chance to look at it.
All right, they're logging off and logging on again, so let's see if that works.
Okay.
Parts of it, at least. I don't know if the whole island is restored. Okay.
Your Honors. And there, I was like,
You may proceed. We can hear you.
Your Honors, I apologize.
Not your fault.
Not your fault.
Your Honors, the eminent domain clause found in Section 3 of the Revised Organic Act provides that private property shall not be taken for public use except upon just compensation ascertained in a manner by law. However, in 1968, Congress amended the Revised Organic Act to include enumerated provisions and specifically stated that the extended provisions shall have the same force and effect there in the United States or in any state. Thus, while not instructive, United States courts have addressed eminent domain and the standard of public use. And United States courts have often provided greater protections for its citizens in applying the standard of public use. In Norwood v. Horney, the Ohio Supreme Court found that the taking did not constitute public use. In Norwood, the court employed a heightened standard of review as it related to the ordinance that the city used to justify a taking. There, the city sought to improve deteriorating conditions and found the taking appropriate to support a shift in commercial activity in the area of the affected parcel. The court held that public use, as required in the eminent domain clause, was not satisfied where economic and financial benefit is the sole reason for doing so. Like the property in Norwood, the Postal Service seeks to condemn Great St. James not to promote public use, but rather to facilitate the construction of a luxury villa that will accommodate elite guests. Indeed, the plans to take Great St. James and transfer the land to Royal Mail Inn are not for public use. The appellants submit the facts in Kelo v. City of New London do not support this application in its instant matter, and thus this court should reject any proposal that Kelo governs. In Kelo, the Supreme Court allowed for a taking of private property after it found the city had a comprehensive and integrated plan designed to revitalize an ailing economy. In Kelo, the court stated that, and I quote, long-standing policy to defer to the legislature judgment as to what public needs justify the use of a taking power, end of quote. There, the city found that the City of New London, which is their legislature, had undergone thorough deliberations and the plans were comprehensive, so the plan unquestionably served a public purpose to satisfy.
So are you saying that whether or not it's public purpose is defined by the amount of planning that goes into it, not the use of the property, but the amount of thought that goes into the plan? Is that the definition?
Your Honors, Title 28, Section 411.3 defines public use as public buildings. Your Honor, I see that my time has expired. May I briefly conclude?
Yes, you may briefly conclude.
In conclusion, the Postal Service's plans within the meaning of the eminent domain clause of Section 3 of the Revised Organic Act and subsection 411.3 of Title 28 of the Virgin Islands Code do not constitute public use. The court did in fact err on this case. Therefore, Your Honors, I humbly ask that you reverse the ruling of the Superior Court and allow my client injunctive relief. Thank you for your time, Your Honors.
All right, St. Croix, are you in there? Let's do a volume check while we're waiting. Yes, we can.
Afternoon, sir.
Is there any feedback coming through from
not
me
getting
talking?
No.
Okay.
No, ma'am. No, sir.
All right. Judges, give me a thumbs up or let me know when you're done with your score sheets.
I'm ready.
Are you getting the feedback from me, Adam?
Nope, no feedback.
Okay, thank you.
I think it was specific to that room that they're in. Good. All right. All set? All right. Mr. Smith, please say and spell your name, school, appellant or appellee, and issue.
Good afternoon. My name is Eden, E-D-N, Smith, S-M-I-T-H. I'm representing the St. Croix Seventh-day Adventist School.
Are you ready to proceed?
Yes, ma'am.
You may proceed, Attorney Smith.
May it please the court, my name is Eden Smith, and I will be representing the appellee in stating that the Superior Court was correct in denying the injunction of the Buck Island Post Office proposal. May it be known, the Postal Service does not seek in any way to limit beach access, which if done, would violate the Virgin Islands Open Shorelines Act 12 VIC. But we do seek to modernize the island for the benefit of the community. Because the Postal Service is a branch of the federal government and Buck Island is federal property, the Postal Service seeks to repurpose a section of Buck Island for the building of a post office and the many amenities that come with such a project.
Yeah, it sounds like he's saying that intent is to repurpose it from the original protected use to a private use, which is specifically prohibited in the documents which established the original protected use. Isn't the very fact of repurposing the problem?
No, sir, we're not repurposing it for private use. The post office is going to be used by the whole community and benefit the community as a whole, not for private.
What about the natural protections of the
The
island?
natural protections can be coexistent with the post office, sir. I do not believe either or cancels out each other.
So you're saying that building this pier, two piers, I guess, erecting these mansions, turning the beaches into what appear to be private beaches, that is consistent with the intent to protect the natural enjoyment of the islands on behalf of the people of the Virgin Islands.
Your Honor, that is not what we seek to do on Buck Island. We simply seek to build a post office and may place an observatory on top of it.
Okay, that's true. That's for Buck Island, that's correct. And that will create a ferry coming every 20 minutes back and forth from carrying people from St. Croix to Buck Island. And that will not interrupt the natural beauty of the island?
No, sir. The pier that will be built is located on the northern shore of the island. And yes, it does seem like there's a reef there, but the reef has been compared to a coral graveyard. So we do not see the danger in placing a wharf there, sir.
Help me understand that. You're saying the reef is already basically dead? The coral are already dead?
In 19 Island. In 2007, the reviews of the reefs stated that the reefs were to be compared to coral graveyards, sir.
There's no hope of revitalization.
Yes, sir, there is hope of revitalization, but the wharf that is being built now is being built in the state of dead coral. If the coral is to revamp...
That's why I asked. Well, go ahead. I think you're going to finish your answer. Go ahead.
If the coral is to be revamped, it would grow on top of the wharf, as stated, and according to the article by DP Fiscal, Post-Hurricane Dynamics and the Status of Reefs in St. Croix, U.S. Virgin Islands, it is stated that minor water disturbances can actually jumpstart a reef. So building the wharf and having the ferry travel every 20 minutes could actually repair the reef quicker than just leaving it be.
Why is that a minor disturbance? This pier, ferries going back and forth all day long, you call that a minor disturbance?
Yes, sir. The undersea currents and things like that will be causing agitation to the corals, not serious waves like larger vessels, sir.
What does it mean when it is stated that 80% of the island will be cleared?
80% of the island, ma'am, will be repurposed for the post office and observatory.
You like the word repurpose, but the question was about clearing it.
Okay, so the clearing of the island is not necessary, yes, but for the building of the post office, you're going to need other stuff that come with it, say lavatories and other amenities. So like say you put in cisterns or stuff like that, those areas would need to be cleared. Then we would allow the areas to grow back after the work has been completed, sir.
So you're saying you're going to allow the post office to be overgrown by nature?
No,
In
sir.
15 years, it'll be overgrown, so we shouldn't worry about it.
We're not saying that, sir. What I'm saying is the section of where the post office would be maintained, yes, but the other areas that are not in direct contact with the post office, they would be left to regrow.
Oh, I see. So in other words, you're clearing 80%, meaning cutting down brush and trees and other vegetation in order to build the post office.
And then let it
and then you will let it grow back over hundreds of years.
We could replant trees, ma'am. Replanting trees, replanting the native brush.
I see.
Are you going to plant that in the private post office boxes? You're going to replant that in the lobby of the post office? I'm trying to envision, looks like a very beautiful futuristic library with mangroves growing out of the lobby.
Okay, Your Honor, sir, it may seem as if the post office would irreparably damage the environment, but as seen in other locations where major digging has been done, if you were to replant and replace the foliage and trees in the area, it should recover, sir. And as I stated before, the post office is the main area that will be maintained by the overgrowth, not the other sections that is not necessary.
So in other words, if there might be areas where residents of the Virgin Islands now hike, for example,
yes,
that would be cleared and they would be unable to engage at least in that activity while the 80% of the island is being cleared. And then they would wait until the areas have grown up again in order to start hiking?
Well, Your Honor, the sections of the path that people hike to use, I do not believe that it would be necessary to dig up those areas, ma'am.
Okay, so the current areas where hiking takes place would not be affected by the construction?
Not seriously, ma'am.
What does not seriously mean?
Small sections of it, no major unrepairable damage, ma'am.
Well, if you happen to be... Go ahead.
How would we know that? How do we know, as a court ruling on this, that there would only be small sections that would be affected?
Okay. How are you with the court? Can you repeat the question, please?
Sure. We are listening to the argument for purposes of making a ruling. And one of the issues, obviously, is the extent to which the construction will affect the current state of the island. So my question is, how do we know, how would we know what the extent of the damage at this point to the island?
Well, Your Honor, the building of the post office would not be the first time something like that has happened globally. Certain areas where mining and surface mining is done, once they have finished mining, they replace the foliage, they replace the trees, they replace the natural animals in their natural habitat, and you would come back and never believe that a mine was there.
Well,
I do not believe that.
Help me understand. You take the animals and you put them in a temporary holding facility, and then you bring them back and let them go. How does that work?
Good question, Your Honor. Well, the animals in the area, the island is pretty large. The animals in the area have been known to migrate from island to island. The animals, yes, are ecological necessity on the island, but there's a neighboring island called Green Key, I do believe, that we could put them on. Green Key has been used before for the replanting of certain species on Buck Island, sir.
So you're saying it's okay as long as the taking is temporary and you restore the land back to its pre-taking state. You're
Yes,
saying
sir.
that's okay or that's not a taking?
I'm saying it's okay to do that, sir, for the benefit of the community.
Was there anything within the language of the proclamation that would support that argument, or any of the cases that would support that argument, that if you disrupt an ecological system in a very large way, even though you're defining it as very minor, and then you put it back together, except for the 80% that's been carved out as the post office, but that's okay. Is there anything that supports that?
Your Honor, I do not have enough information to answer that question now, sir.
Okay.
May I continue?
Yes.
Yes, you may continue.
On Buck Island, we will maintain the island for scientific and community purposes. And in accordance with the case of the United States versus St. Thomas Beach Resorts, we will not be blocking the community from beach access. The appellate may state that this scenario may be compared to the case of City of Norwood versus Horny. Quite the contrary. We will be supporting the community and adding a more pleasant experience to a Buck Island excursion.
Why would it be more pleasant? They now get to go to a post office?
Well, Your Honor, with the bathrooms that should accompany a post office, it would give visitors the opportunity to go use the lavatory. Because if you
That's
visit
an
Buck
interesting
Island,
argument. Interesting argument. Why not just put up porta johns and leave the post office alone? Let take the post office someplace else, erect some porta potties on the island.
well, Your Honor, that has not already been discussed. So I do not see why why a bathroom should not be necessary, sir. A porta potty does need more maintenance, and with the porta potty would need a ferry that would, using your words, disturb the reefs and natural ecosystems, sir.
Okay.
In conclusion, I do not believe that the Superior Court was incorrect in denying the injunction of the Buck Island Post Office proposal. Thank you.
Very well.
We should take a quick break, run to the restroom. Maybe it was the discussion of the last argument, but the power
Yeah,
suggestion.
no, I was going to ask if we need it. It's about when we had scheduled it anyway, so we can take a 10 to 15 minute break here and but let the judges get some rest while we're going through this.
Okay, thank you.
Thank you.
We're going to recess the court, Adam?
We are. We're in recess for 15 minutes. No sound.
Hello?
Okay. And as I speak, we aren't getting any feedback, are we?
None.
All right. All right, then we will wait for Judge Lewis to return and get started. That's all for now, Mr. Nemerin. You can relax a little bit.
Great job, Mr. Nemerin.
people to try and make up that time. You can't account for technical issues in an island-wide power outage that resets the servers at the court and creates issues starting the live stream and all this stuff that we're experiencing today. And I really am sorry. Thank you for bearing with us. And with that, I would turn it over to Mr. Nemerin to spell his name, school, appellant or appellee, and issue. We can't hear you over there.
Good afternoon. My name is Joshua Nimwin. Josshua. Nimwin. Nemorin. I am from the St. Croix Seventh Adventist School, and I am representing the appellee.
I was muted. You may proceed, Attorney Nemerin.
Hey, please record. My name is Joshua Nimwin, and I represent the respondent, Government and Postal Services. This case is on appeal from the Supreme Court. The Supreme Court denied petitioner's request for an injunction holding the court did not err in granting the government permission to take Little St. James and part of Great St. James under the Eminent Domain Act 411 to 419.
Which court entered that ruling?
The Superior.
Okay.
Your Honor, this section of the code outlines that the government can take a private property or condemn an existing government property for a project that is of greater public use.
Does it say greater public use or public use?
Public use.
Okay.
First,
why is this a public use? The use that you're contemplating, why is that public?
Well, putting a post office on the island will serve everyone in the community. They will all receive their mail.
Won't it destroy the natural beauty of the island?
No.
Why wouldn't it?
On the island, there is already the necessary means to put the building there, and it's already equipped with a helicopter pad, so there won't be any necessary movements to destroy any parts of the island.
Once the post office is in place, it's going to be a very different location, ecologically though, isn't it? The beauty will not be the same. The natural preservatives there will not be the same. Fishing, snorkeling, all those things, hiking trails, won't all that be drastically altered?
It would be if we were building it there, but we're using a place that's already there.
You're going to put the post office on the helicopter pad?
No, we're gonna put the post office near the helicopter pad where another building is already set up for the use.
Okay, you're saying that the natural beauty of the island has already been destroyed?
Well, that building was already there.
But has the natural beauty of the island and the purpose for which it was established as a monument, has that already been destroyed?
No.
Okay, but it's okay to destroy it now because there's already a commercial use.
Yes.
Okay.
May I proceed?
Sure.
First, Your Honor, we know that the internet is the main means of communication today. However, we cannot send medication or other physical necessary items to the internet and during the hurricane season, or as the case in hurricanes and Irma and Maria. Vessels could not come to the island and our mail got held up and lost in Puerto Rico. It is too important to note that Little St. James was already equipped with a helicopter pad and the buildings to preserve to serve the postal service. Further, the property owner was already deceased, and full compensation to the value of the estate would make it easier for the family to appropriate while not inconveniencing anyone.
Why would it make it
But
easier?
Counsel,
Go ahead.
Counsel, the issue is whether this is a public use, right? Because you're exercising eminent domain, correct?
Yes.
Okay, so the question is whether the use that it will be put to is in fact a public use. Is that
Yes.
right?
Yes.
Okay, so why is that a public use if there are seemingly so many private uses of the space, like, you know, the hotel and the use for the elite guests, and the reserving of, I think there's a portion of the beach there that's going to be only for the guests. Is that not correct?
Correct.
Okay, so why is that a public use?
Well, it is true that the hotel put on there would be private, but the money the hotel is making will be used to build the post office. That way, the islanders would not be the one using their tax money to pay for it.
So does that make it a public use? And under what authority does that make it a public use?
Also, the money made from the hotel would be going towards the islanders. They could use it to build better roads, better schools, hospitals, and etc.
But Judge Lewis asked you, what authority are you relying upon to say that's a public use?
The court.
So if there's any revenue that's generated is committed to the people of the island, that makes the revenue generating activity a public use, no matter what the nature of that activity is. That's what you're saying?
Yes.
Okay.
I take it that you are advocating for a very broad definition of public use. Am I correct?
Repeat.
I didn't hear your answer.
Can you please repeat?
Yes, of course. You are arguing for a very broad definition of public use, are you not?
Yes.
Well, there's also the much narrower definition of public use, and that would be the traditional definition of public use, which is a use for such as building of railroads, roads, post offices. So, and this court has not defined public use. What cases would you argue, would you advocate for us to use in defining public use?
And do not have one prepared.
Okay, all right. You may proceed.
Second, Your Honor, the business's operations on the Greater and Little St. James provides work for the other sectors such as tourism and a greater source of income for the people of St. Thomas GPD. With respect to the first point, Your Honor, first, postal workers. But the islanders didn't want this to go as planned, so they used the excuse that it goes against the Open Shorelines Act, which they were not wrong because the government wants to take a piece of the island that was already prepared to have the post office and hotel there. But because the pier was in the way of the boat's passage, it went against the acts. But luckily for the government, there is another pier that can be used. putting the post office and hotel on the island will not only benefit the people on the island, but it will also benefit the island, bring in money, more enjoyable areas.
Well, isn't that the same thing? You're saying not only benefit the people on the island, but benefit the island. But it sounds like the way you're looking at the island, it's the people on the island you're saying who will be benefited.
Well,
not
yes.
the island per se.
Well, yes, the people would receive jobs of source of income. That's what I meant by the people of the island. And by the island, I am referring to the actual island. They can use that money to build better roads or construct things that they need, playgrounds for the children.
So any revenue generating activity would be a public use then?
Repeat?
Any revenue generating activity, you're saying, would be a public use?
Yes.
No matter how destructive it is to the island?
Well, yes.
Okay. I'm
So
sorry,
in my
Judge Lewis,
Repeat?
No, I thought I interrupted Judge Lewis's question.
No, that's all right. You can continue.
So in my opinion, and by the facts I stated, the government was right in taking the island and the court was correct in giving it. In conclusion, I believe that the Superior Court was right in denying the injunction of the construction of building the post office and the hotel on Greater and Little St. James.
Very well, thank you.
Good day.
All right. Can you let's see if your microphone's working, Mr. Hughes?
Can you hear me?
Yes. Is anyone getting any feedback when I speak and he's got his microphone on?
No.
Okay. All right, judges, let me know when you're done with the score sheet.
Okay.
All right. So before we get started, I do want to let just the Antilles know that you won't be put in a waiting room after this, and you don't have to log out. You can watch the rest of the competition now that both your teams have gone after this round.
Sounds good.
And sorry, I wasn't paying attention. Justice Cabret, Judge Lewis, you ready?
Yes, thank you.
All right. Then Mr. Hughes, please stay and spell your name, your school, whether you represent appellants or appellees, and the issue you're arguing.
Okay, good afternoon. I am Caden, K-A-D-E-N, and my last name is Hughes, H-U-G-H-E-S, and I am the appellant for issue 1.
You may proceed, Attorney Hughes.
May it please the court. Good day, Your Honors. I'm Caden Hughes, along with my co-counsel, Rate Shalwani, and I represent the appellants, the state oppressor and various nonprofit organizations. I'll be presenting issue 1, whether the Superior Court erred by denying the plaintiff's request for an injunction. My position is that the lower court was incorrect, that the taking of Buck Island should be enjoined. First and foremost, I would like to state the 4 prongs a court considers when asked to issue an injunction. I will use these as the backbone for my argument today. The first prong, the likelihood that the moving party will succeed on its merits. Second, irreparable injury will befall on the moving party if injunctive relief is withheld. Third, the grant of relief will not cause greater harm to the non-moving party. And fourth, public interest is furthered by the court granting request for injunctive relief. Following along with the first prong, the likelihood that the moving party will succeed on its merits, the Kennedy Proclamation stated that Buck Island constitutes a vital and necessary national land reserve, a trust dedicated to the greatest use and benefit of the public. In the case Rivera versus United States, which is
Why wouldn't some sort of development there be a greater use and a benefit, especially given the built-in protections from the hurricanes? Why wouldn't that be a greater use, allowing people to walk through the beaches and hiking trails?
Yes, Your Honor. The greatest use of the Buck Island is the natural amenities that come with the island itself.
Why is that?
It's
Why
because
is that better than a revenue generating activity that's going to benefit everybody in the area?
Because Buck Island allows for enjoyment and entertainment and relaxation and recreational activities that come with the natural island, such as the hiking trails that you mentioned, or the coral reef that sits on the cusp of the island, or the fish.
Turtle Beach is relatively unscathed, isn't it, by this plan?
Well, 95% of the recreational activity occurs on Turtle Beach, but there is still 5% of recreational activity that does occur on Buck Island itself. And that
How does that balance? Then that gets us to point four, the balancing and the respective interests. If such a small part of the recreational activity is going to be interfered with in return for a facility which is going to allow medicine to be delivered in a timely manner, packages and mail to be delivered in a timely manner, protection from hurricanes, and allow more access to more people by these ferries being operated, why doesn't that balance of the harms come out in the favor of allowing for the construction?
Well, Your Honor, the 5% of people are still people who want to enjoy Buck Island, and 80% of the island is being taken over, along with 2/3 of the shoreline is being obstructed as well.
In return for quite a bit of commercial activity, employment, protection from hurricanes, prompt receipt of medicines.
Well, Your Honor, going back to the first prong, the greatest use and benefit of the island stated by Kennedy is the natural amenities that come with the natural island itself, such as the coral reef, the hundreds of fish, and the hiking trails that sits on the island. Along with the Open Shorelines Act, and I quote, "No person, firm, corporation, or association or other legal entity shall create, erect, maintain, or construct any obstruction, barrier, or restraint of any nature whatsoever." The Postal Service directly violates several of these restrictions, therefore obstructing the shoreline and following suit under the Open Shorelines Act.
How is it that the Open Shorelines Act, which is a BI statute, applies to this federal property?
So the Open Shorelines Act comes from Title 12, BIC Section 403, and it applies because of the case Water Isle Hotel and Beachcomb Limited versus Kentucky St. Thomas Incorporated. And in that case, it was actually stated that the Open Shorelines Act is applicable to cases like ours today.
What do you mean by cases like
Based on what?
Based on the injunction that they received, when they had their case alone, it was stated that the Open Shorelines Act is applicable to theirs as well as other cases.
Okay.
Moving along to the second prong, irreparable injury will befall on the moving party if injunctive relief is withheld. 2/3 of Buck Island shoreline will be built up to create a deep water pier that will extend from the north shore of the island 300 yards into the ocean. Now, this construction will not only obstruct the shoreline and violate the Open Shorelines Act, but it will also cause tremendous danger to the vibrant coral reef that sits on the cusp of the island. This coral reef, recognized by former President Kennedy, along with hundreds of tropical fish, is a rather popular attraction. Many people, from foreigners to locals, come to swim, snorkel, and fish and take in the wonders of the deep blue ocean. But the construction
Well, they'll still be able to do that, though, won't they? There'll be some reduction in terms of the amount of land open to doing that, but they'll still be able to do that, won't they? The post office is not taking over the entire island and all of the beaches.
2/3 of the shoreline is a rather great amount for the postal office to take over of the shorelines itself.
But the most important part of that shoreline in terms of recreational activity is relatively unscathed. It's what we talked about a few minutes ago.
That might be true, but coral reefs, such as the ones that sits on the cusp of the island, with the construction of this deep water pier, it has the possibility of being damaged or destroyed in a total. And so if that happens, recreational activities such as snorkeling and swimming and looking at the coral reef might be scathed as well. Progressing on to the third prong, the grant of relief will not cause greater harm to the non-moving party. Buck Island is a 176-acre island that sits about 1.5 miles north of St. Croix. The Buck Island development proposes that 80% of the island would be cleared. Now, Buck Island is already a compact island. However, the people who go to it find it an acceptable size to enjoy their day. With the construction of a postal office, 80% of its already minuscule stature will be taken over to build this structure. This gives those who come to Buck Island not to sort mail a limited space to enjoy. Finally, moving along to the fourth prong, public interest is furthered by the court granting request for injunctive relief. Events such as Sunday Funday, when hundreds of locals come to have fun and relax on the white sandy shores of Buck Island, will be postponed until further notice if the construction of this postal office is granted.
But that's a temporary postponement, isn't it? I thought the post office was being very careful to not permanently interfere with that activity, to allow for Sunday Fun Day to continue.
It might seem temporary at face value, Your Honor, but as we've seen that they're also going to be building a 360-degree observatory on the top and a structure that can withstand superstorms, that's going to take a grand amount of time. And because of this inexorable wait time, events such as Sunday Fun Day will be postponed.
Well, what is wrong with the residents of the island postponing their Sunday leisurely activities for us for 2 or 3 years in return for protection against the hurricane that might devastate their livelihoods and their homes for a much greater period of time? And in the interim, they're deriving economic benefit by the commerce that is being brought by this construction, and even perhaps greater enjoyment of nature because of this observatory. Wouldn't that enhance the ability to observe nature? You'll be able to see Puerto Rico from the observatory?
So, like you've stated that it might happen for 2 to 3 years, the construction time, at the moment we need natural locations such as Buck Island to enjoy our day because we can't stay inside due to COVID. And so, as we have these natural amenities, stuff like the 360-degree monument become obsolete when you have an island that you can walk around yourself.
But aren't you looking at the short term as opposed to the long term? You know, yes, it's going to take some time for the construction, but over the long term, you will have the benefit of the enhanced postal service delivery, which is quite important, wouldn't you agree, given the fact that there are delays that affect people's health, for example, with regard to the inability to get medicines in a timely fashion, and the economics of the island in terms of the inability of merchants to get their merchandise in a timely fashion. What about those benefits?
Respectfully, seeing as though hundreds of locals come to Buck Island for Sunday Fun Day, that also falls under our second prong. Irreparable injury will befall on the moving party if injunctive relief is withheld. If the injunctive relief is withheld, hundreds of locals are not granted the opportunity to come to Buck Island and to enjoy their day and to enjoy Sunday Fun Day. It's almost as a local holiday, if you will. So if the construction time takes a grand amount of time, it's going to cause a lot of delays for hundreds of locals who want to enjoy their time. I see my time has concluded. May I please conclude?
Yes, you may conclude.
Thank you, Your Honor. In conclusion to my argument, representing the state oppressor and various nonprofit organizations, respectfully request you to reverse the lower court's decision. Thank you.
All right, Mr. Alwani.
Good afternoon.
Are the judges ready? I think it looks like it, but
Yeah.
all
We're
right.
ready.
All right,
Yes,
Mr.
I'm ready.
Please spell your name, your school, state your school, whether you represent appellants or appellees in the issue you're arguing.
First name Radesh, R-I-T-E-S-H. Last name Alwani, A-L-W-A-N-I. And I represent Antilles School on the behalf of the estate of Presser on issue 2.
Are you ready to proceed, Attorney Alwani?
Yes.
Then you may do so.
Good afternoon. May it please the court. My name is Radesh Alwani, along with my co-counsel, Caden Hughes, and we represent the appellants, the estate of Presser and the nonprofit organizations. I will be addressing issue 2, whether the Superior Court erred when it found that the takings of Little St. James and the parcel of Great St. James were public uses within the meanings of the eminent domain clause of section 3 of the revised Organic Act. Our position is yes. The Superior Court did err when it made this finding, and the takings were not within the eminent domain powers of the U.S. Postal Service. Here, the United States Postal Service intends to take private property of the estate, specifically Little St. James, where the existing house would be converted into a postal sorting facility and would include a luxury apartment for the postmaster of the Virgin Islands. In addition, the U.S. Postal Service would take a parcel of Great St. James, also currently owned by the estate, in order to build a luxury hotel that will exclusively service elite visitors of the Virgin
You
Islands.
seem to be stressing the fact that it's taking private property, but all takings under the eminent domain power are takings of private property. So why is that important?
Well, Your Honor, the intentions of the estate of Presser and the nonprofit organizations are not for the land to be taken, but for it to preserve its natural beauty as an essential island in the United States, in the Virgin Islands.
Above all other considerations?
Can you please explain that question, Your Honor?
Sure. Does that mean that the preserving the natural beauty takes precedence over any other possible consideration?
Well, no, Your Honor. In the eminent domain clause, the government has the power to take private property only if one, the private property shall not be taken for public use except upon payment of just compensation, and 2, it has to be a public use.
Why isn't this a public use? Won't the public benefit much more so than the way the land is now? It's basically just laying fallow. I mean, you can snorkel and hike and swim there, but the land is really not generating any revenue for the people of the Virgin Islands. It's not protecting them from hurricanes the way the construction that's being planned would.
Well, Your Honor, on Great St. James, they plan on making a luxury hotel that will only exclusively service the elite visitors of the Virgin Islands.
Who will work there?
The inhabitants of the Virgin Islands.
And I assume they'll be paid, since we have the 13th Amendment now, these people will be compensated for the labor, right?
Right, they will be paid.
Why isn't creating jobs for people in the area, it seems to me to be a pretty significant economic benefit?
Well, the Court of Appeals in Maryland v. Baltimore v. Balsamaki and the Supreme Court in Iowa v. Putney v. Iowa both more or less deemed that economic development doesn't solely constitute a public use.
Well, is it that it doesn't constitute a public use, or that it just does not justify a taking, or is that the same thing?
No, it does not justify a taking.
What would justify it?
To justify a taking, it would have to include a public use, and by definition, Title 28, Section 411, it is a public building and grounds for the use of any town, village, school, or other governmental division for the benefit of all inhabitants.
What if the use doesn't benefit the people, but the very presence of the structure does benefit the people? I'm talking now about the protection from hurricanes and delivery of medicines.
Well, Your Honor, the postal hub being constructed does not benefit every single inhabitant of the U.S. Virgin Islands, as there is a...
The way it is now, it doesn't benefit every single inhabitant of the Virgin Islands. I am not certain, but I'd be willing to bet you that every Virgin Islander can swim. Not every Virgin Islander cares about snorkeling. Not every Virgin Islander wants to hike. Some people may be afraid of poison ivy. Does it have to benefit every single Virgin Islander?
Well, Your Honor, the greater majority of the public is being benefited by not creating this postal hub and this luxury hotel on Great and Little St. James.
Why is that, and what is that based on?
That is based on public use, and the greater majority must be benefited more than the lesser majority.
And
what is the basis for saying that the greater majority would not benefit from having the mail delivered more efficiently and more promptly?
Well, Your Honor, it does not only not benefit the greater public more, but it is also, the building of this postal hub is also not in the powers of the Postal Service and their eminent domain powers. It does not constitute. It is not a necessity for them to create this postal hub.
What is the authority for saying that? What is the authority for the proposition you just articulated?
The postal powers of the the Postal Service is not that broad in that they cannot do whatever they think is. They cannot do whatever they deem necessary. It has to be inside of their postal powers.
And what about this project is not within their postal powers?
Yes, Your Honor. Getting me to my next argument, the eminent domain clause of the Organic Act, which established the territory of the U.S. Virgin Islands, provides that private property shall not be taken for public use except upon payment of just compensation. Under Title 28 Virgin Islands Code, Section 414, requirements for taking include: 1, a showing that the use to which the property is to be applied is a use authorized by law, and 2, the taking is necessary to such use. The taking of private property to build a luxury hotel is clearly a taking in violation of the eminent domain clause. This luxury hotel will consist of only 2 mansions and 12 bedrooms total, with amenities that will be available exclusively to the hotel guests, such as jet skiing and powerboating, ultimately occupying the entirety of Christmas Cove. Moreover, the U.S. Postal Service determined that this land would be given to a private company called Royal Mail & Co. to develop this luxury hotel, which in turn would profit from said construction.
What if the Department of the Interior was going to develop it? So the Department of the Interior was going to develop it and then allow the post office and this private company, these mansions, the same kind of activity, but instead of being developed by the developer that is now in place, the Department of the Interior was going to develop it and put in place the mansions and the water kind of activities. Would that make any difference?
Well, Your Honor, what I am trying to get at is any kind of private company trying to develop this hotel would in turn some private benefit, which is not a public use.
But hasn't the law moved towards that direction to allow the taking of property to benefit some private individuals as incidentally, as long as there is a public use?
Well, Your Honor, in this case, there is no public use being presented.
No public use?
Yes.
What about the benefits that are accruing as a result of the Postal Service uh, uh, constructing this facility and improving the effectiveness and the efficiency and the timeliness of postal delivery? Why is that not a public use?
Well, Your Honor, the taking of these two islands in specific is not a necessary in that they have so many other options to boost this this delay that they've created for themselves. They do not have to take these two islands.
Do they have to show that there's a less restrictive or a less harmful way of achieving what they're trying to achieve?
Yes, Your Honor.
Why do they have to show that?
Well, they have to, in Title 28 Virgin Islands Code, Section 414, prong 2 says that taking is necessary to such use. So they have to prove that their taking of wherever they're taking is necessary to such use.
Well, what is that? How is that interpreted? Is that interpreted as absolutely necessary?
Yes.
Where?
For Title 28 Virgin Islands Code, Section 414.
It says absolutely?
Where does it say absolutely?
Well, it says that the taking is necessary to such use. So whatever use that they are providing, it has to be necessary for that use.
Well, you know, it seems to me, I don't know how else they achieve it. They're trying to accomplish a number of things. They're trying to provide protection against some of the hurricanes. They're trying to effectuate a situation whereby people can get their medicine as opposed to medicine getting to people in an untimely manner, perhaps reaching them before it's too late. I don't understand why what they're trying to do is not necessary to accomplishing that.
Well, Your Honor, the taking of Little St. James is convenient as the U.S. Postal Service has a postal hub on St. Thomas and St. John already. The taking of Little St. James is merely convenient, but not necessary to create a mail delivery service plan in the U.S. Virgin Islands.
Isn't it necessary to making it more efficient to getting the mail from Puerto Rico, which is a real problem now?
Well, Your Honor, as it may be a problem, they have other options that they can branch out to rather than taking these two islands in specific.
What are those options?
Well,
what are those other options?
One option would be to create branches off of their already constructed postal hubs on St. Thomas and St. John.
How would they? I assume that would mean construction, wouldn't it?
Yes. Next, it is also I see that my time has elapsed. May I please conclude?
You may conclude.
Thank you. In conclusion, on the behalf of the state oppressor and the nonprofit organizations, we respectfully request that this court reverse the decision of the lower court and find that the taking of Little and Great St. James was not within the eminent domain powers of the U.S. Postal Services.
Thank you.
Right. Ms. Alphonse, I have you and Ms. Parija on here. Is anyone else from your school going to be logging on that I should look for? I didn't hear you.
No, Your Honors.
Okay, thank you. Also, we were able to get into communication with Delegate Plaskett's office, and the arguments that finish, the team that finishes closest to 3:15 but before is when we will have it, because she's available at 3:15. And so I just wanted everyone to know that it is happening, and there will be a slight change in the schedule at around 3 o'clock, 3:15, depending on when those arguments finish. And with that, sorry, I wasn't paying attention, judges. Are you guys ready, or?
I am ready.
Yes,
Yeah.
yes.
All right, Ms. Alphonse, please spell your name, state the school you're from, whether you represent appellants or appellees, and your issue.
Good afternoon. My first name is Kiana, Keanna. My last name is Alphonse, Alphonse. And I represent the Synchro Educational Complex High School, and I represent the appellee team. I will be addressing the issue of whether the Superior Court erred in denying the injunction to build a post office on Buck Island.
Thank you. Attorney, are you ready to proceed, Attorney Alphonse?
Yes, Your Honors.
You may proceed.
May it please the court, my name is Kiana Alphonse. I, along with co-counsel Nancy Parija, represent the appellee postal service. I will be addressing the issue of whether the Superior Court erred in denying an injunction where the Postal Powers Clause clearly permits eminent domain actions by the Postal Service. The U.S. Postal Service provides Synchro with the service of receiving imports and exporting goods, and denying the injunction of building the post office on Buck Island is not putting the community's stability as a top priority.
Do they have to, where is it written that they have to put community stability as a top priority?
The honors is not necessarily written, but in the Postal Powers Clause, it is stating that to take the land to build this post office, the land will have to be beneficial to the public.
Why isn't it going to be beneficial to the public? I would think any post office would be beneficial to the public.
Yes, Your Honors, any post office is beneficial to the public. However, this post office has a special reason.
The reason is not preventing hurricanes. The islands, providing employment to people on the islands, isn't that sufficient to make it a public use?
Yes, Your Honors, but not only is it a public use, but it is a public purpose.
Why wouldn't all those things be a public purpose? And what's the difference? If something has a public use, wouldn't that use in fact be a public purpose?
Your Honors, a public use is not directly benefiting the public, but in this case, the post office is benefiting the public with having the sufficient supplies and necessary supplies to ensure that our community has a stability and a safe backup plan. May I proceed?
What about the other side of that, though? In terms of the damage that would be done to the ability to enjoy Buck Island?
Your Honors, the ability to enjoy Buck Island is not necessarily being destroyed because we're creating a safe backup plan for the community, however, while still allowing recreational activities and fun times for the community.
So are you saying that the same degree to which individuals can now go to Buck Island and enjoy fishing and swimming and snorkeling and hiking will remain, notwithstanding the construction of the postal facility?
Yes, Your Honors, it will remain, and I will speak about that more later in my argument.
No, I'd like you to address it now for me. So are you saying that it will be the same? In other words, there is this construction of this facility, but the natural beauty, the ability to enjoy the shoreline, all of those things will remain the same. The fishing, the swimming, the surfing, etc., will be the same.
Your Honors, it would not necessarily be the same, but however, it will still remain so that it can be just like the same, just not exactly the same.
What does that mean?
As you know, that they will be taking 80% of the land to build a post office, and we are left with 20% of the land where most of the recreational activities take place. Then that's that 95% also as Turtle Beach. It will be left untouched. However, for the other 5%, it is not stated in the fact pattern what takes place there. But I do know that they will be able to snorkel, swim, and fish freely on that percent that they have left untouched.
Isn't clearing the land by 80% a significant change?
Yes, Your Honors, it is a significant change, but it comes with a beneficial purpose. And not only that, they're gaining something else to that island.
What is that?
As we know that the tourist plays a large industry in this island, they're gaining another tourist attraction. On top of that,
Post office? People will be coming to look at the post office?
They will not be coming to look at the post office directly, but there will be a 360-degree observatory on top of this facility, and where they will be able to see the surroundings of St. Croix, and on clear days, they'll be able to see St. Thomas, St. John, Water Island, and the Spanish Virgin Islands.
To what extent are you arguing you can interfere with the intended purpose of a national monument if you provide some kind of collateral public benefit? If that benefit destroys the purpose for which the monument was established. I may have confused with that question. Do you understand what I mean?
I'm not hearing you too clearly. May you please repeat
it? Sure. Wasn't a very good question. The islands in the proclamation by President Kennedy is pretty clear to me are there for the ecological purpose, for the purpose of allowing people to enjoy nature and to protect nature. You're saying that there will be a benefit by some commercial activity for the island that would not otherwise exist. And I'm trying to figure out how great a destruction of nature is allowed in return for some kind of commercial benefit. For example, if they were put in a landfill, implying that it employed hundreds of people from the island, but totally destroyed the beauty and the natural reserves there, would that be a public use in your mind?
Unless it's necessary, it's not going to be a public use.
Okay, necessary for what?
Unless it's necessary to ensure that the public really needs this and be a safe plan, then it's not necessary.
Well, doesn't the public need this postal facility?
Yes, it does. So in this case, it is necessary.
And you can destroy any amount of the islands because it is necessary.
Not necessarily what I'm stating, Your Honors, but however, we're not trying to destroy all of the island. We're trying to create a solution where we still have our beautiful monument and still have a safe plan for our community. May I proceed?
May proceed.
The Kennedy Proclamation is being overridden by the postal powers, but it does not, because it says that the U.S. Postal Service has a right to take the land through eminent domain if the land has a more beneficial purpose to the community. But
that's what I'm trying to get at. The nature of that benefit is exactly what I'm trying to get at. And it seems to me the benefit has to be interpreted in terms of the documents that create the national monument and the purpose of the national monument and the restrictions on the national monument. Would you agree with that?
Yes, Your Honors.
But yet you're saying that you can greatly detract from the natural enjoyment of that land to which it was designated a national monument, so long as you provide some kind of a commercial benefit that goes to the benefit of the people.
that's not what I'm directly saying. I'm trying to state that, you know, I understand that we're taking away 80% of the land, but however, we're not just taking this land for taking its sake. Like using the Rivera case to distinguish my case to it. In the Rivera case, they wanted to shut down the beaches for the government's budget, but that did not reach much of a factor in to deny the injunction because you can't just shut down the beach without a beneficial reason to the public. It has to be a reason to ensure that the public is safe or to ensure its stability. So, however, in my case, I am arguing that this post office will ensure that our community gets its necessary supplies during natural disasters. You gain a tourist attraction, you gain an educational purpose, and you get economics from this facility.
How big could the facility be, given your logic, and still pass your public use test? Could it take up 90% of the island?
No, Your Honor. Based on the fact pattern, I will agree with the 80% because I'm not sure what takes place on that 80% of the land, but we're still left with our 20% that we usually have our fun on. So therefore, having that 80% just to build this postal facility to ensure our community's safety, then yeah, I agree with it.
I mean, isn't this a unique situation here, though? You know, in the proclamation, Buck Island is described as one of the finest marine gardens in the Caribbean Sea. It's described as of great scientific interest and educational value. There is a concern that this unique natural area and the rare marine life are subject to constant threat of commercial exploitation and destruction. And that's why there is this restriction such that there can be no rule or regulation or requirement limiting, restricting, or reducing the existing fishing, bathing, or recreational privileges. How is it that this project is consistent with that presidential proclamation?
First off, Your Honors, I understand what President Kennedy is saying. However, the Postal Powers Clause overrides the Kennedy Proclamation because this land is beneficial to during natural disasters, as I've previously stated, but its location would be easier to facilitate emergency packages and shipments between St. Thomas, St. John, and Water Island instead of going out.
Well, how could it override the proclamation when the proclamation seemed to put on that land a limitation of any entity to convey title to the land or to use the land in any way which is contrary to that proclamation, setting it up as a national monument? If you're right, national parks are endangered, aren't they? Because anybody can come along and say, yeah, I know it's a national park, but that doesn't mean anything. We've changed our mind now. We're going to develop here.
Your Honors, it overrides the Kennedy Proclamation because the Postal Powers Clause is written by the United States Constitution, and that automatically overrides any other case there is because it is the heights. And as for the marine life, there will be seagrass beds created so that when constructing this post office and boats are going back and forth, the animals will be able to go in it and be safe so that they will not be getting destroyed.
So the powers that the Postal Service has overrides everything else?
It overrides the two arguments I'm arguing in this case. However, Your Honor, I've seen that my time has exceeded, so may I have permission to please continue with this question?
You may conclude. Yes.
In closing, Your Honors, therefore, the appellee respectfully that this court affirms the decision of the Superior Court to refuse the injunction. Thank you for the opportunity court today.
Thank you.
All right, Ms. Parisha, yes. Can you unmute yourself and speak? We'll do a sound check here. Didn't hear you.
Good afternoon.
Okay. And is there any echo coming from my speaking in this?
Nope.
Okay. All righty. Okay, Judge McKee, looks like you're finished.
I am.
And Justice Cabrera, it looks like you were finished.
I am.
Judge Lewis? Okay.
Yeah, I'm good.
All right. Ms. Parisha, please stay and spell your name, your school, the whether you represent appellees or appellants, and the issue you're arguing.
Good afternoon again. My name is Nancy Parija. That's N-A-N-C-Y. And then my last name, Parija. That's P-A-R-R-I-L-L-A.
Okay, you may proceed, Attorney Parilla.
Do you still need my school and whether I'm an appellant or appellee? I am a part of the St. Croix Educational Complex High School on the appellee team, arguing whether the taking of Little and Great St. James constitutes a public use.
Very well.
May it please the court. Good afternoon. My name is Nancy Parija. I will be addressing the issue of whether the Superior Court erred when it found that the takings of Little St. James and the parcel of Great St. James were public uses within the meaning of the eminent domain clause. When creating this storm-resistant postal hub and sorting facility, together with the other connected advancements, is a clear public purpose for the takings and a necessary public use urgently needed for the people of the Virgin Islands. For years, the people of the Virgin Islands have constantly been troubled with backed up mail, out-of-date packages, and the inadequate condition of newly received imports. These problems have been due to overworked staff, overwhelming
To
amounts.
what extent do we have to define public use in the context with the limitations of the Kennedy Proclamation?
Well, Your Honor, my co-counsel just addressed the Kennedy Proclamation and the Open Shorelines Act. However, I would be addressing the eminent domain clause. And I
Well, under
understand
eminent
that,
domain, you have to take it for a public use, though, don't you?
yes, so I understand that you're asking for the definition of the public use.
Right, and whether or not that public use definition is informed by the limitations on the islands coming out of the Kennedy Proclamation.
Well, Your Honor, public use is interpreted in various ways. In the Virgin Islands Code says that there are certain specified public uses
What
included
does
in
the
any.
Proclamation say about it?
Well, the Kennedy Proclamation defines Buck Island as a national monument and states that the environmental purposes and scientific purposes of it should be kept.
Okay, and don't we have to have that in mind when we look at this taking to determine whether or not the eminent domain authority was properly exercised?
Well, Your Honor, in this case, because it was a private institution that owns the island, we can take into mind the environmental accounts. However, we must take into mind how
But there'll always be a private ownership. Otherwise,
Yes,
you
Your
don't get eminent domain. So that doesn't help us, does it?
I didn't hear the last part.
That doesn't help us. The fact it was taken from a private owner, that's always going to be the case.
Yes, Your Honor, I'm just simply distinguishing how the Kennedy Proclamation applies in the Buck Island situation. However, in this case, we can use Kilo versus the City of New London and the Virgin Islands Code.
Okay, why does Kilo help you?
Well, Kelo versus the New London case is a U.S. Supreme Court case, and so it is binding on our authorities and is the most precedent case that we have.
But why does the reasoning there help you? That was a commercial development of a shopping mall. And there was no other consideration, such as whether or not constructing the mall would destroy the purpose of the land on which the mall was sitting. That's the kind of consideration we have here.
Well, Your Honor, in Kelo versus the City of New London, yes, it was a blighted community that was used, and so they built it to help this blighted community. However, the plan was projected to create thousands of jobs and increase tax revenues, which is the same case that is happening at this moment. Although it may not be in the same circumstances, the postal office and the luxury hotel serve as public purposes and create immense benefits to the people of the Virgin Islands, which is the reason that we should apply this case.
How is that, from all the description of it, I couldn't afford to stay there more than a night or two. How is that possibly a public purpose, erecting this enclave that very, very few people will be able to afford?
Well, Your Honor, we must note that they are not checking bank statements or credit scores at the entrance of the island. So it is open to
taking credit cards,
as all hotels are. But it is open to all classes, and the job benefits that are given are open to all classes as well.
Could a homeless person afford to check into either one of these two hotels? Just to get in from the rain.
Excuse me, Your Honor, can you repeat one more time?
Could a homeless person check into one of these facilities to get out of the rain? What I'm trying to get at is you seem to be saying that the fact that there's any economic benefit benefits the public because it's an economic benefit, which would suggest to me that if they put in a landfill that employed hundreds of people but totally destroyed the beauty of the islands, that would be okay because that's a public benefit.
Your Honor, we must take into account that a landfill and this case that we are in right now have two different facts. This landfill is
we call that a hypothetical. And if you can
yes, it is a hypothetical. Okay. However, you are asserting that the landfill is there as a public benefit as it allows people with these jobs and certain things, but it takes away the beauty of the island. However, we are not taking away the beauty of the island, and this postal service serves the people with their efficient mail and adequate job opportunities and more benefit than this landfill that you are proposing.
I'm not sure it would. I'm not sure. If we get into weighing the benefits, we've got a situation where you've got two mansions that hardly anybody can afford to use, jet skis that hardly anybody can afford to use, unless you check into the mansions. Yes, there are some jobs, but that pales in comparison to the kind of benefit the islands would get by creating a facility that would allow them to more safely and effectively dispose of waste and maybe create more jobs in the process. And I'm troubled by this concept that as long as there's some economic benefit, the taking is okay, no matter what. Go ahead, I'm sorry.
Economic benefit is not the only benefit at this point. Yes, you are saying that the landfill would provide all these benefits. However, we are giving the people a facility that will sort and efficiently maintain the needs of our mailing needs, as everyone in the Virgin Islands uses these mail. And although it does have economic benefits, it has more factors than stated in other cases. As Kelo and others only have 1 to 2 benefits, we have faster mail, jobs, tourism, our main industry, recreational use, tax dollars, and that is more factors than you are simply taking into account.
You have referred to the Kelo case. Are we bound by the Supreme Court's interpretation of public use in that case?
Well, Your Honor, this U.S. Supreme case, we are bound to the taking, and it is binding on our front. So we should take into account how they use public use and that they do administer that they had long ago rejected any literal requirement that the condemned property be put into use for the general public. And we do use the more broader natural interpretation of public use because it proved to be impractical, given the diverse and always evolving needs of society.
Didn't the Kelo case itself, however, make very clear that the states, and we're not a state, but we're a territory, could define public use in a narrower way? Because you're correct. The Kilo definition of public use is a very broad definition. But isn't the territory free to define public use? And if so, what do you suggest that what cases do you suggest that we use to define it? Well, you're advocating for Kilo.
Oh, Your Honor, through the revised Organic Act, we do have the same constitutional rights as the states do have. And there is a use of public use in the Virgin Islands Code where it includes that any public use defined by Congress. And we must note that Congress has affirmed that the postal services are a justified public use.
Well, not anything the Postal Service does would be a public use, though, would it be? We'd have to look at what the Postal Service was actually doing and its impact on the land and the context in which it was effectuating the taking, wouldn't we? You're saying that anything the post office does would be a public use?
No, Your Honor. What I'm saying is the Postal Service has three justifications: to protect mail revenues, to facilitate efficient and secure delivery of mail, and promote the privacy of mail patrons. And through the Postal Reorganization Act, they transformed the Post Office Department into a government-owned corporation called the United States Postal Service. And they are directed to plan, develop, promote, and provide adequate and efficient postal services, which is what they are doing in this case by having this postal hub and sorting facility on Little St. James. It is efficiently...
Yeah, I don't think anyone is questioning the authority of the Postal Office, of the Postal Service, of the Postal Department to erect post offices. That's not what we're concerned about. We're concerned about this particular taking in order to achieve that purpose and whether or not the taking is legal. And it seems to me that's a very different question. So it doesn't help me simply to say that the Postal Service can do what it has to do to deliver the mail, because there's a more finite question here, and that is this taking. Does that make sense?
I believe what you are asking is whether this taking is justified by the powers of the Postal Service.
That's right.
And this taking is justified because, as I listed, we need this postal service because we are so backed up on mail. And as Your Honor mentioned how we are a territory, we are already backed up on several important information. And this postal service is going to be able to facilitate all our needs. Everyone is looking for their stimulus checks, college applications, college acceptances, job acceptances. This postal service will be able to efficiently house these needs, along with easing all the congestion on our ports and making more room for the tourism industry and the different cruise ships that are already being backed up on our ports by moving this mail to a place where it can solely sort and accommodate our mailing needs.
But is there really two issues, though, and two separate issues? One, what the authority of the Postal Service is, what its role is, what its responsibilities are, and separate from that, and certainly they have to be performing their responsibilities that they are charged with. But separate from that is the question of whether or not it's a proper eminent domain taking. Don't they have to satisfy both? In other words, it's not necessarily the case that simply because the Postal Service is performing or the construction satisfies the delivery of mail, more efficient delivery of mail, which is one of the responsibilities of the Postal Service. That doesn't necessarily mean that it equates to an appropriate taking on the eminent domain. Is that right?
That's a more artful way of asking the question that I was trying to ask you.
Well, this Postal Service, I think I see my time has concluded. May I finish answering your question? Or
you may answer the question if you can answer it very briefly.
Your Honor, this taking does constitute a public use by, as I mentioned, the faster efficiency of mail. And although that does facilitate what I said about the postal office requirements of doing so, it benefits the people of the Virgin Islands through the public purpose definition of public use by giving them the efficient needs, goods, and services through this mailing hub.
Thank you.
Thank you.
In closing, Your Honors, seeing as my time has concluded, may I proceed to my closing?
One sentence.
Okay. Therefore, the appellee respectfully prays that this court affirm the decision of the Superior Court and hold that the takings of Little St. James and the parcel of Great St. James were public uses within the meaning of the eminent domain clause. Thank you for the opportunity to appear before the court today.
Thank you as well, Attorney Perina.
I apologize. Ms. Parisia, Ms. Alphonse, do either of you have a classmate with you at your computer? Sorry, I couldn't hear you. You're alone?
No, I didn't hear the question. Can you repeat?
I'm sorry. Yeah, I was just asking if you or Ms. Alphonse have any classmates with you, or are you by yourself? Or any teammates, I should say.
Are by ourselves.
Okay, then you two can continue watching. But if your teammates were around you, they wouldn't be able to watch. So you're welcome to stay and observe everything from here on out now that you've participated.
Thank you.
All right. Mr. Stadelman.
Sorry, sir, but there's been a confusion. I argue issue 2. My co-counsel Pierre Joseph does issue 1.
All right. I apologize for that and my scheduling error. Mr. Joseph, then, can we get you unmuted and you can speak? Let's see if your microphone is working.
Hello, testing.
All right. And is there any feedback coming when I speak?
No. No, sir.
And is there anyone from your team that I should be looking to admit so they can watch right now?
I guess you could add my coaches if they're in.
I don't see any of them online.
Oh, okay. Yeah.
At least I don't, because you have Attorney Hurst, Attorney Payton, and Attorney Harrington and Michael Charles, right? Mr. Charles?
Yes.
All right. Okay, then we're all set. With that, then, judges, are you done scoring? I don't want to jump ahead.
Ready.
All right.
Yes.
Mr. Joseph, please spell your name, your school, the appellants or appellees, whether you represent them, and the issue you're arguing.
Okay. My name is Pierre Joseph. Pierre, and the last name is Joseph, and I represent the appellant, and I'll be taking issue 1.
Are you ready, Attorney Joseph?
Yes, Your Honor.
Proceed, sir.
Chief Justice and Associate Justices, may it please the court. My name is Pierre Joseph, and I represent the appellant, which is the Environmental Association. I'm here today because my client strongly believes that the U.S. Postal Service should not do their obstruction in Buck Island because it will be in violation of the Virgin Islands law. Before I give a brief explanation of my points, let's discuss
what aspect of the Virgin Islands law would it violate?
It would violate the Open Shorelines Act, the Revised Organic Act, and basically Kennedy's presidential proclamation.
Why wouldn't the eminent domain power, which the Postal Service has, be sufficient as long as the elements of the taking to fall within eminent domain can be satisfied, why wouldn't that be sufficient to get around those problems?
May you clarify your question, please?
Sure. I'm saying that you're citing me to certain statutory provisions that would say that there cannot be a taking. What I'm asking you is, but there's another authority that says under certain circumstances, a governmental entity can take property. And I'm asking you, why wouldn't that authority, the eminent domain authority, be sufficient to justify this taking, even though otherwise the Open Shores Act and the statutes you've referred to in the Kennedy Proclamation would suggest it couldn't?
Well, because Kennedy's presidential proclamation expressly provided that the federal government cannot interfere with the existing bathing and recreational privileges enjoyed by the people of the Virgin Islands, Your Honor.
An act of Congress cannot supersede that?
Oh, well, I believe so, Your Honor, because in the Open Shorelines Act, it states that no person, firm, corporation, association, or other legal entity shall construct any obstruction across or within the shorelines of the United States Virgin
Okay, does that
Islands.
apply to a federal taking?
Yes, Your Honor.
Why would it apply?
Well, like I said, in the presidential proclamation, it provides that the federal government cannot interfere with it.
Yes, but why does the Open Shoreline Act apply?
Well, the Open Shorelines applied because the U.S. Postal Service are basically a legal entity, and what they're trying to do is to obstruct Buck Island, which is prohibited in the Virgin Islands law, in Title 12 BICC.
How can Virgin Islands law supersede federal law?
Well, can you clarify your question, Your Honor?
Sure, you're saying that a Virgin Islands statute prohibits a branch of the federal government from doing something. And what I'm asking you is, why wouldn't federal law supersede the limitations in the Virgin Islands Open Shores Act?
Well, then again, it's clear that it don't want them to cause any obstruction in the shorelines at Buck Island.
But do they have the authority to stop them?
Well, not really, Your Honor. But throughout this argument, I might stop them.
Okay, so you're conceding that basically the other side is correct.
No, Your Honor.
Okay.
Because
I misunderstood you. I'm sorry.
I said no, Your Honor.
Okay.
Before I give my points, let's discuss whether the Superior Court erred by denying the plaintiff's request for an injunction. We strongly believe that the Superior Court erred by denying the plaintiff's request for an injunction because the answers for all the elements of the injunction were very reasonable and were very strong. And I'll be answering all the elements for you. In the first element, are we likely to succeed on merits? We will likely succeed on merits because of Kennedy's presidential proclamation and the Open Shorelines Act. In Kennedy's presidential proclamation,
Do those two laws conflict with each other?
Basically, Your Honor.
I'm sorry?
I said yes, Your Honor. Basically.
They conflict with each other? Do they have different objectives?
Yes, Your Honor.
They have, well, what is the objective of the Open Shores Act?
Well, Open Shorelines Act is mainly for a shoreline area, and the Kennedy's presidential proclamation is for the whole of Buck Island.
But what is the purpose? What is the purpose of both of us? Don't they have a common purpose?
Yes, Your Honor. They both provide that the public shall have the right to use and enjoy the shoreline area.
Okay. All right, you may go ahead.
Now, in the second element, will there be irreparable injury? Obviously, there will be an irreparable injury because of its huge effect on the environment. For example, if Buck Island gets bulldozed, that means female sea turtles can no longer go on shore to lay their eggs.
But I thought the Turtle Island, as it's called, the area where they go, would be basically unscathed, untouched, and left alone. That's not part of the development, is it?
Well, if Buck Island is a 176 island, then taking 80% can cause some limitations towards it.
Well, not if the 20% that they don't take is the 20% that the turtles use.
Well, I personally don't think that's enough.
What would be enough?
I could say maybe 50%.
And what's your authority for that?
My authority?
Mm-hmm.
Can you clarify the question, please?
Yes, I understand that you're advocating the law according to Pierre Joseph. What I'm trying to get is the law according to a statute, a Supreme Court case, a Virgin Islands Supreme Court case, something like that. Something other than the well-intentioned and well-thought-out authority of Pierre Joseph on Virgin Islands law.
Well, if they are going to construct something in the coastal zone of the Virgin Islands, then it must abide by the law, by like the Open Shorelines Act and the Revised Organic Act, and etc.
But what we're trying to get at is, why does the federal government have to abide by Virgin Islands enactments? Let me give you an example. If New York State were to have a statute that precluded an airport being placed on a certain piece of land, couldn't the federal government come in and still take that land as long as it complied with the requirements of a governmental taking, eminent domain?
Well, yes, as long as it has a public necessity, Your Honor.
Okay. So then the Open Shores Act and those Virgin Islands enactments are not controlling here. What's controlling is whether or not the eminent domain authority was appropriately exercised. Isn't that right? Whether or not there's a public purpose.
Yes, but relying to the case of Pitani versus Iowa Utilities Board, the Court of Iowa stated that it cannot be economics cannot be indirectly benefit for the public, Your Honor.
Okay.
Now, on the third element, the balance of interest. Imagine on a scale, on one side is the Postal Service, and the other side are the residents of the USVI. Let's say that the Postal Service are denied to do their construction in Buck Island. The only effect that will happen to them is that they won't get to speed up their shipping. Now, let's say that the Postal Service are allowed to do their construction in Buck Island. How would the residents of the USVI would feel? The residents will have a greater effect because as a Virgin Islander, I know that many people that live here will be very devastated if this happened. Many people love Buck Island because Buck Island is a very awesome place. Buck Island has been here for many decades, being known as a place where all friends and family are able to enjoy.
But your argument, hold on, your argument sounds as if you're saying that the speeding up of the mail delivery is just sort of a benefit to the Postal Service. You sort of said, well, the only thing is that, you know, they get to speed up their mail. But isn't it the case that the more efficient, more timely delivery of mail has a discernible impact on the residents of the Virgin Islands? That is to say, there's an indication, for example, that people's medications come through the mail. Obviously, that's very important with regard to health. There is an indication that merchandise that would be sold by you know, store owners and other merchants here are not timely delivered. That affects the economic situation in the Virgin Islands. So isn't that a little bit more important than you're giving it credit to be?
Not to me, Your Honor, because bulldozing a place like Buck Island, I don't think the residents will be very happy for that.
Which residents?
The residents of the USVI, Your Honor.
But again, consider their happiness, if you will, in conjunction with the question that Judge Lewis just asked you. They're going to be getting medicines more promptly that they may not be able to get now, getting their mail, getting their packages, greater protection from hurricane damage. And you're saying that the residents of the Virgin Islands wouldn't be very happy with that? They wouldn't care about that?
Well, yes, Your Honor, that may be true, but bulldozing a place like Buck Island might not make the residents happy.
Well, the island will still be there.
Can you rephrase what you said, please, Your Honor?
The island will still be there. You make it sound like the island will be gone when you say bulldozing a place like.
Yes, but it's still limiting the island, Your Honor.
What do you say about making the residents happy? I mean, what really is the test here? It's not sort of a measure of the happiness of the residents, is it? It's whether it's a legitimate public purpose, public use.
Yes, that may be true, Your Honor. But if you care about the public, then you should care about how would they feel about it, Your Honor. May I continue?
Yes.
My first point, the action of obstructing Buck Island by the U.S. Postal Service will violate Kennedy's presidential proclamation because his proclamation states that the condition of the United States, including any, Your Honor, may I have a little time to finish that point and then conclude?
You'll need to finish that point very, very quickly and then conclude, all right?
All right, thank you. The proclamation states that including any agency or instrumentally thereof shall not adopt or attempt to enforce any rule, regulation, or requirement limiting Buck Island. To sum up everything that has been stated so far, the U.S. Postal Service should not do their obstruction in Buck Island because it will be in violation of the Virgin Islands law. A demonstration conflicting with the Revised Organic Act, the Open Shorelines Act, and Kennedy's proclamation appears to be a huge violation of the Virgin Islands law. This activity wouldn't simply be wrong, it would disregard what the Virgin Islands law represents. One of the significance of the Virgin Islands law is to build up justice. This action will clearly be injustice. Thank you, Chief Justice and Associate Justices, for listening to my argument.
Thank you as well.
Mr. Stadelman, can you unmute your microphone and let's do a sound check here?
Okay.
All right. Just say your whole name or testing or something.
Testing.
All right. And is anyone getting any feedback when I speak and he's got his microphone on?
Nope.
No.
No.
All right, then you're good to go. We'll wait until the judges are finished with their score sheets. All right, Justice Cabret looks finished.
Yes.
Judge McKee, you look done. Okay. And okay. All right, Mr. Stadelman, please say and spell your name, the school that you're from, whether you represent appellants or appellees, and the issue you're arguing.
My name is Caleb Stadelman, spelled C-A-L-E-D, and my last name is A-D-E-L-M-A-N. And I am from St. Clair and Paul Catholic School, and I represent the appellants.
Are you ready to proceed, Attorney Stadelman?
Yes, Your Honor.
You may proceed, sir.
My name is Caleb Stadelman, and I'm here to represent the appellant, along with my co-counsel, Pierre Joseph. I'd like to start by stating that the Superior Court erred in its taking of Little St. James and Greater St. James. The reason the Superior Court erred in its taking is because the definition of public use was incorrect. The Supreme Court used economic benefit as a public use from a case that has no connection to the Virgin Islands, the case of Kilo versus New England. This case shouldn't have much control of the Virgin Islands Court due to the revised Organic Act. Instead, I would like to use the definition of public use determined in the case of the City of Norwood versus Homey.
Why wouldn't the statutory, the constitutional authority of eminent domain still control the Virgin Islands, no matter what the Virgin Islands legislature says?
Can you please clarify the question, Your Honor?
Sure, the federal authority, the federal power of eminent domain, which is recognized, I think you'll agree. Why wouldn't that authority apply, no matter what, or control, no matter what the Virgin Islands legislature might say? Because of the supremacy clause, why wouldn't the federal law take precedence over the local law? You're saying KO does not apply because we've got our own law here in the Virgin Islands.
Well, I would say as well that the federal law would not apply because of the revised Organic Act, which does have its own main clause, which is much stricter. We had definitions of public use that we use here in the Virgin Islands.
So you're saying that you could have a definition of public use in the Virgin Islands that would be controlling, regardless of what the federal government might say?
Yes, Your Honor.
And what authority do you have for that?
The revised Organic Act, Your Honor.
So you're saying that the legislature of the Virgin Islands can adopt legislation giving itself greater authority than the federal government has, and saying, we recognize a use this way. We don't care what the federal government may say. Here in the Virgin Islands, we do it this way. Is that what you're saying?
I wouldn't be exactly playing it that way, Your Honor. I would say that the Virgin Islands Revised Organic Act puts more strict measures than it does in the federal law.
It's more what? I'm sorry, I didn't hear part of what you said.
It's more strict. It has more meaning. Well, I wouldn't say meaning. Like as I said, it's more strict than federal law. Because federal law has its own meaning, and the Virgin Islands Revised Organic Act interprets it that way in the Organic Act, Your Honor.
So basically, you're saying the Virgin Islands legislature can enact a law that amends the federal statute, insofar as the federal statute is applying in the Virgin Islands. It doesn't matter what the Congress says or what the Constitution might say. It's what the Virgin Islands legislature says. So in effect, the Virgin Islands legislature has the authority to amend a federal statute. That's what you're arguing.
Yes, Your Honor.
And your authority for that?
The Revised Organic Act, Your Honor.
Okay, well, it's circular. I understand what you're arguing.
May I continue?
Sure.
In this versus Homey case, it was stated that economic benefit cannot be the only reason why economic benefit cannot be the only reason why we must use public use. It must come with another reason, and it could be any of those reasons listed in the Virgin Islands Code in Title 28. Thus, using economic benefit under City of Norwood definition would be a violation to the Title 28. And the reason
is there another use here beyond just or another benefit other than an economic benefit? Given what the Postal Service is trying to do in terms of the more efficient delivery of mail?
Well, Your Honor, from what I saw in the fact pattern, the only definition I could see the post office using would be economic use, as they plan to create more jobs and bring in more tax revenue, which fall under the economic use. I do not see them following any other definitional reason other than economic use, Your Honor.
You don't see whom following any other definition?
The post office, Your Honor, and their plans for building the postal hubs on.
But isn't the whole reason for this project, isn't the genesis of this project the notion that the post office not only is in financial straits, but also the operations of the post office has suffered in terms of the prompt delivery of mail, for example, and that this construction of this facility would allow the Virgin Islands to be getting mail as promptly as in the continental United States. And isn't that a benefit that is different from just an economic benefit?
Well, Your Honor, I would say it is another benefit, yes, but that benefit is not listed in the Virgin Islands Code of Title 28.
What are you looking at? You mean that specific benefit, or is that what you're referring to?
Yes, Your Honor.
Are you saying that Title 28 has to have in particular purposes, like there has to be a provision that says, the more prompt delivery of mail in order for this to pass muster?
No, Your Honor, not the more prompt delivery of mail. I believe that what you were asking was if the use of I believe you said the faster mailing and the suiting to the needs of the public on a matter that does not fall within the Virgin Islands Code, because in the Virgin Islands Code of Title 28, the public use will only fall under things such as building construction that would be used for public, or the buildings of pipelines and such other things, which constitute to being a public use. But with that, the use you're saying of it going directly towards a person in a personal matter, I would believe in the Virgin Islands Code of Title 28 that would not be a use.
So your interpretation of Title 28 is that it has to be an actual use as opposed to as a benefit that is being derived. It has to be an actual use, like a use of a building.
Yes.
Is that your interpretation? Okay. All right.
As I've said before, the definition of public use in the city of Norwood case, I would like for that to be applied in this court, as it would only, as it stated that economic benefit cannot be the only use. Moving on, in the Kilo case again, I would like to bring to light the dissenting opinions by Justices O'Connor and Thomas. Their dissent stated that even though economic benefit is a public use, it is not a public necessity. This can be interpreted as saying that even though economic benefit can be a public use, is it truly necessary for the public to have?
These are dissents. We don't. How much weight should we attach to a dissenting opinion that could not garner the respect and agreement of a majority of its colleagues?
Can you please clarify, Your Honor?
Yeah, you're citing from a dissenting opinion, which is not law, and that dissenting opinion wasn't sufficiently persuasive to command a majority of the court. How much attention should we pay to it?
Well,
there's another word for the dissenter. The dissenter is also the loser.
Well, Your Honor, I would like to see that all opinions stated by the justices in the Kilo case will be held by the same weight, even if they were not a popular opinion held by the rest of the justices. as I said, would these postal hubs be needed for St. Thomas? And then would these villas they plan to build there also be needed? The villa resort that they plan to build on the Greater St. James is to finance the project. Land taken from St. James would be given to the Royal Mail and to construct the resort. The resort will include 2 mansions with 6 rooms and a saltwater pool for each mansion to company them, including exclusive access to 1/3 of the southern part of Christmas Bay. I see it. My time has expired. Your Honor, may I please conclude?
You may conclude.
In conclusion, we argue against decisions to do public use and could use a definition from the Norwood case that economic benefit cannot be the only reason. We also argue the Villa Resort plan for the islands will not be public use and violate Title 28 of the Virgin Islands Code. The court does not find my argument appealing. Then my client wants the just compensation they were owed from the takings of their property. Thank you, Chief Justice and Associate Justices, for hearing my argument and for allowing me to present it.
Thank you as well.
And just for the record, St. Peter and Paul, you're done competing, so you can stay on and watch and observe. You don't have to log out or anything. All right.
We want to have one more student and then break for Delegate Plaskett.
Yes, I don't see her attempting to log in or anything, so we might as well do one more person and then get to her. Okay, St. Thomas 7th Day. Can we get your video feed and speaker up? Unmute your microphone, please.
Your Honors, can you hear me?
Yes.
Yes, we can.
Is there any feedback coming through to the judges or the competitor?
I didn't hear any.
Okay. Good to go. All right. Let me know when you're done with your score sheets, please. Okay. And Judge McKee, are you still going, or are you good?
Just finished.
All right. All right. Mr. Charles, right? David Charles, that's you?
Yes, Your Honor.
All right. Please say and spell your name, your state, your school, whether you represent appellants or appellees, and the issue you're arguing.
My name is David Charles. D-A-V-I-D-C-H-A-R-L-E-S. I'm representing the Seventh-day Adventist School, and I am an appellee for the United States Postal Service going for building the postal hub on Buck Island.
Are you ready to proceed?
Yes, Your Honor.
And you may proceed, sir.
Good afternoon, Chief Justice and Associate. May it please the court. My name is David Charles. My co-counsel Simoy Benjamin and I represent the appellee, the United States Postal Service. Irma and Maria, 2 Category 5 hurricanes back to back. COVID-19, a global pandemic that overall debilitated the world, progressing efficiently. These tragedies have highlighted the disadvantaged status of our people in being able to access resources in a timely manner. The Superior Court recognized this and correctly denied the appellant's motion for an injunction, to stop building the postal hub on Buck Island. Your Honors, I ask that you affirm the ruling of the Superior Court.
Don't we have to look to the impact that your construction and use has on Bucks Island, and also look to the legislation and the proclamation which were enacted and proclaimed to protect the natural beauty and the natural resources there?
I think there might be,
You lost connectivity?
I think he dropped off.
Did we? Okay.
Yeah, I know that their electricity had gone out and they had switched over to generator, and if it switched back on during this, it could have created an issue.
Mm-hmm.
Another example of the disadvantaged status of the people.
Yeah, you got to get a post office down there.
All right, Mr. Charles, you cut out when Moot Justice McKee was asking you a question, so we'll go back to that question right there. And
Yeah, I'm not sure if you heard the question, but you have very elegantly argued for the benefits that will be derived from having the post office built. But in doing so, you haven't mentioned or considered the impact of the post office and the construction. And what I'm asking you is, to what extent do we have to look to the purpose of establishing a national monument there in the proclamation and the subsequent legislation that has been acted to try to protect the natural resources of Buck Island? To what extent do we have to look to that, to those things, in assessing the cost and whether or not that cost justifies the countervailing benefits, such as to make it a public use?
Your Honors, we have that power under the United States Constitution, Article 1, Section 8, Clause 18, that states that as long as the postal hub plans are necessary and proper, we have the power. And under the general powers of the Postal Service, which states that, under Section 6, that states that the Postal Service has the power to construct, lease, maintain buildings, and make improvements.
No one doubts, and it goes all the way back, I think, to that wonderful statement in Miracle on 34th Street. No one doubts the majesty or the power of the United States Postal Service. What we're trying to get at is whether or not this is an appropriate use of that power, given the efforts that have been put in place to try to protect the natural beauty and the natural resources of Buck Island. You've got the power, no doubt about it. That does not mean that it was legally exercised here. Would you agree that there can be an illegal use of authority that you otherwise have?
Can you phrase the question,
Sure.
Your Honor?
A couple of questions, and I apologize for that. Let's start out at it this way. Do you agree that there can be an improper or illegal use of a governmental authority, even though in other circumstances the government could exercise
use is illegal?
Well, I'm asking really to try to help me understand why this use is appropriate, given the protections of the natural resources on Buck Island and the damage that your project is going to do to Buck Island.
Your Honors, the use is necessary as it enhances mail and is better for the people of the Virgin Islands. It would enhance mail by 75%, which is detrimental, as there has been a lack of resources, medicine, and other amenities to the people of
Well, but you know, the people of the Virgin Islands spoke in enacting legislation which was designed to protect the natural resources of Buck Island. So I think in terms of what's on this record, that is the will of the people of the Virgin Islands. So I'm not sure that you're in arguing that the post office is consistent with the will of the people of the Virgin Islands is very persuasive, when it would seem to me the will of the people of the Virgin Islands is embodied in the statutes.
Your Honors, the will of the Postal Service is not in concurrent jurisdiction to the will of the Virgin Islanders or the local government. The local government wants Buck Island to be used purely for recreational use. The federal government wants Buck Island to be used for the building of the postal hub. In that sense, Your Honor, the federal government trumps the local government, as they are not in the same concurrent jurisdiction.
How is the desire of the Postal Service consistent with, one, the presidential proclamation by President Kennedy, and two, the Shoreline Act, the Open Shorelines Act?
The Kennedy Proclamation, Your Honor, states that no bathing activities or property is to be hindered in a way that reduces the usage of the island's recreational activities. The plans do not violate the proclamation due to the fact that there is no physical restriction that prohibits anyone from enjoying any recreational usage. 95% of such recreational activities are held within the famous Turtle Beach. There is no solid proof that states that the 5% is being reduced, as we have no clue what it's actually being used for. For the Open Shorelines Act, Your Honor, it states that no limitation is to be made to the shoreline through construction or obscurities. Our pier, Your Honors, should not be considered as a limitation. It should be considered as an access point, Your Honors, as it would bring accessibility for ships that house both tourists and locals to board the islands with ease.
The piers that you refer to, is there any impact on the coral and the natural life under the ocean, the fish, the fishing, the ability to fish, and those things of that sort?
No, Your Honors. The building of the pier will not damage or infringe on any fishing activities for the island. However, if any damage is to actually be inflicted upon, it'll be minimal, and it'll be for the betterment for the people of the Virgin Islands.
Why? You come back to the betterment of the people of the Virgin Islands. And you're saying that, look, we got to get a post office in there because that's going to be for the betterment of the people of the Virgin Islands. But that's not true if it's prohibited by the Kennedy Proclamation or the Open Shores Act, is it?
Can you rephrase the question, Your Honor?
Yeah, you keep coming back to, look, basically it's the big father approach. We're doing what's good for the people of the Virgin Islands. What we're concerned is whether or not what you're doing is prohibited by the Kennedy Proclamation, the Open Shores Act, or any other thing that might limit your authority to seize the property, to engage in eminent domain. And it's not helpful simply to say it's for the betterment of the people.
Your Honors, building the postal hub on Buck Island does not violate the Kennedy Proclamation.
Well, why doesn't it?
It does not violate the Kennedy Proclamation because it's not restricting any bathing activities or any recreational activities that are being held on the island itself. In fact, if anything, it is increasing the recreational activities with our 360-degree observatory, which on clear days you could see Puerto Rico, St. Croix, Calibre, and Vieques, which would entice tourism, which is another main income source for the Virgin Islands. For the Open Shorelines Act, as previously stated, there is no actual physical restriction that prohibits anyone from boarding the island. There is an
where the pier is going to be built, that's certainly going to limit fishing in that area, or the area of the pier. Where the post office is being erected, that's going to not limit but preclude the natural kind of activity, hiking, that kind of activity, where the post office is, won't it?
Your Honors, the pier is there to help. It is there to help with ships and with fishermen, as the fishermen can easily board and fish freely without any limitation or obscurities.
The pier is not an obscurity?
No, Your Honor.
Is this an invisible pier? What kind of pier is this?
It's
a physical structure supported somehow by supports going down into the waterbed, which may well interfere with the coral reefs that are there. And it takes away the total area that would otherwise be available for fishing and boating, doesn't it? Boats are going to have to go around that pier.
No, Your Honor. The pier is there for ships to dock. Saying that you'd go around the pier would be obscuring the pier in general.
But the fact that it is there for ships to dock does not mean that it is not disturbing the coral below, does it? I mean, I hear what you're saying with regard to there's some purpose for the pier, but the fact that there might be a purpose for the pier under this plan by the Postal Service doesn't mean that it is having some adverse impact on something else, like the coral that would be below, like the ability to, you know, fish or swim or snorkel as readily, does it?
Your Honor, we believe that the building of the pier would not cause any damage to the coral reef itself. And if damage is to actually be inflicted upon, it would be very, very minimal.
What about the 80% of the land that's cleared on the island? Why isn't that going to have an effect on the kind of recreational activities like hiking that's now done there?
Your Honor, 95% of the recreational activities are on Turtle Beach. The other 5%, such as hiking, we do not know where it actually took place. And instead of reducing the amount of recreational activities, we are adding on another recreational activities, which would, again, entice tourists and locals.
What other recreational activities are you adding on? You're talking about looking out of the observatory?
Yes, Your Honor.
Well, I'm still at a loss to understand why your planned activity does not limit or reduce the existing fishing, recreational privileges by inhabitants. I'm not quite understanding that. You're saying it's going to be a reduction. No, you're not even conceding it's a reduction. You're saying you're going to increase the recreational activities because of this observatory. I'm not quite sure that's what the proclamation had in mind. People can go into a tall building and look out the window.
Your Honor, the observatory gives you clear access of islands that in other places would not be clearly visible at. To say that the postal hub being reduces recreational activities, Your Honor, I see that my time has elapsed. May I answer your question and briefly conclude?
Yes.
Okay. Seeing that the postal hub, Your Honor, is being built away from where the recreational activities are actually being held, where 95 of the recreational activities are being held, 5% is unknown. So us not knowing where 5% of that recreational activity is actually being held, we cannot say that it was used for X, Y, and Z, or Y, or that it was reduced in any sort or any manner. Your Honors, these islands are absolutely beautiful. Our efficiency should match our beauty, not just for tourists, but for the benefit of the people of the Virgin Islands. Therefore, I ask that you affirm the ruling of the Superior Court. Thank you for your time.
Thank you, Attorney Charles.
All right. Interrupt the arguments for a second here and open the floor for the U.S. Virgin Islands delegate to Congress, Plaskett. I would ask the judges if you could take this opportunity to send a updated batch of score sheets if you haven't been sending them in real time. We'd appreciate that. And with that, I turn it over to our delegate, who in the last 3 months became an internet meme that's known nationally, and for her to share her comments and inspire all of you.
Thank you so much for allowing me the opportunity to come and speak with you all. And I'm so honored to be in front of the esteemed judges that are visiting and spending time and working with the young people of the Virgin Islands. It means so much to me to see Judge McKee, Judge Lewis, and Justice Cabret available for our young people, offering your amazing experience and intelligence and your expertise to help them hone their skills and maybe consider the legal profession later on in life. So thank you so much, first of all, for doing that. And thank you to the Virgin Islands Bar Association for the invitation to deliver this address to you all. I'm so sorry that I am not at the allotted time. I am grateful for you all to make time for me to be able to come and speak with you in a sliver of time that I have available. As you just heard, my time has become exponentially busier than I would have anticipated in the beginning of the January when I was sworn in on January 3rd. It has become a very different term for me. And so I'm grateful for the time. I always want to make time for our young people. And so I'm happy for the opportunity to speak with you all right now. I'm encouraged to see the participation, and I was able to watch a little bit of the last argument, and bravo to you all for continuing to press yourself and push to be better advocates for the ideas and express yourself more effectively. As some of you may know, I graduated from American University Washington College of Law and worked as an assistant district attorney in the Bronx District Attorney's Office as a prosecutor, handling many different types of cases, arraignments, night arraignments. The New York City justice system has 24-hour court, so grand jury trials, and eventually narcotics. So I can appreciate the value of a moot court experience now. Moot court provides an invaluable time for high school students to sharpen their reasoning, writing, and oral advocacy skills. Throughout your preparation for this event, you've gained a deeper understanding of legal and constitutional issues, acquired important standards-based social studies knowledge, performed critical analysis, and examined the historical and current issues of the Virgin Islands of the United States. All of these skills have been instrumental in my success and will be pivotal in your lives as well. I noticed the fact pattern for this year's moot court draws on the complicated relationship between the Virgin Islands of the United States and the U.S. federal government. As you may have now learned through your preparation, under the Virgin Islands Organic Act of June 22nd, 1936, the government of the Virgin Islands obtained direct control of Buck Island through U.S. federal government maintained control of the submerged lands. In 1948, the government of the Virgin Islands established Buck Island and its surrounding reefs as a territorial park. As outlined in the fact pattern, in 1961, control of Buck Island was transferred to the National Park Service, and later that year, President John F. Kennedy, in recognition of the need to preserve for scientific and educational interests one of the finest marine gardens in the Caribbean Sea, established Buck Island Reef National Monument by presidential proclamation. This proclamation included provisions to protect for free and uninhibited access of Virgin Islanders to Buck Island National Park. This is a right that many individuals in the Virgin Islands, in particular on St. Croix, steadfastly fought for. The original monument encompassed approximately 850 acres, 176 land, and 704 water, and was zoned to include the marine garden on the south shore of Buck Island as a no-take marine reserve. The boundaries were expanded by 30 acres in 1975 to include additional submerged lands and expanded again in 2001 by 19,015 acres, with new regulations making the entire monument a no-take and restricted anchor zone. Now, it's important to highlight that while the designation of Buck Island as a national monument has protected the vulnerable ecosystem, disputes frequently arise as a result of this federal designation. First, Buck Island National Park also includes the surrounding submerged monument. There are stringent fisheries regulations in place. As a result, fishing is prohibited in the designated areas. Many Virgin Islands fishers have expressed their displeasure at Buck Island designation as a no-take marine reserve because they are unable to fish in this area. Additionally, commercial disputes arise frequently as there are only 6 concessionaires that are authorized to offer trips to Buck Island, which impacts commercial operations. There are also jurisdictional problems that arise as a result of the Buck Island National Monument designation. While the National Park Service is tasked with enforcing the regulations that protect the environment, the Virgin Islands Police Department and U.S. Coast Guard also ensure the public follow local territorial laws as well as boating regulations. Oftentimes, this leads to jurisdictional issues as there are 3 separate entities monitoring the area. Finally, imposing federal restrictions and the bureaucratic process cause special requests or local concessions and concerns to take longer or to be sanctioned by federal law. In my role as delegate to Congress, I've maintained pressure on the Department of Interior and the federal government to protect the rights and interests of Virgin Islanders, and to, in some part, try and act as a go-between to support the relationship with the National Park Service in particular. The National Park Service, I believe, must be a partner with the people of the Virgin Islands, not the Virgin Islands people a partner with the National Park. Earlier this year, we saw several instances of disorderly and violent behavior at Buck Island National Park. I want to mention this because the careless and irresponsible acts of violence committed by a few have the potential to endanger the rights and privileges of the entire community. Indeed, the work that our ancestors really fought for to ensure that we had access to Buck Island. This behavior dishonors the work of our forebears and the work that we continue to do to ensure that this national treasure remains our local treasure. In response, my office worked with Governor Bryant and the federal partners to provide additional resources to ensure the safety of those visiting Buck Island. Just recently, on March 31st, the Virgin Islands observed the 104th year of transfer from the Danish rule to possession of the United States. Our relationship with the United States is still one of an unincorporated territory, and Denmark has still not formally acknowledged the atrocities and economic extractions within the Danish West Indies. The issues of inequity and discrimination that have endured for generations still continue to include our limited citizenship rights, our inability to vote for president, although we proudly serve in the armed forces in greater numbers per capita than our stateside counterparts. Indeed, we as Virgin Islanders need to determine what we desire our future mature relationship with the United States to be. For the last 3 consecutive Virgin Islands legislatures, the 32nd, the 33rd, and the 34th, I have written to consecutive Senate presidents to impress upon them the need to educate and put aside funding for not just the education, but really discussions among Virgin Islanders for us, for once and for all, to come to a determination of what we as a people believe our mature selves should look like. Independence, statehood, commonwealth, or remain with status quo. That should be at the direction of the people of the Virgin Islands, and I await continued discussions on this so I know in Washington how to advocate for that type of relationship. More than 3.5 million Americans are denied full enjoyment of the right to vote simply because they happen to live in one of the 5 U.S. territories: Puerto Rico, Guam, the Northern Mariana Islands, American Samoa, and the Virgin Islands of the United States. This is equivalent to the population of the 5 smallest states combined. More than 98% of territorial residents are racial or ethnic minorities, a fact that cannot be a mere coincidence as our continuing disenfranchisement extends well past the century mark. While America has from the very beginning included U.S. territories, the Constitution's promise to citizens in territories was long understood to be that they were on the path to full political participation through statehood, and that in the meantime, the Constitution would fully protect those rights. That promise was broken after the United States began acquiring island territories in 1898. Bending to political pressure, as well as racial mores at the time, the Supreme Court, in a series of highly fractured and controversial decisions known as the insular cases, invented an unprecedented new category of, quote, unincorporated territories whose residents were not on a path to statehood and could be denied even basic constitutional rights. Which territories the courts determined were unincorporated turned largely on the justices' view of the people who lived there, people they labeled as, quote, half-civilized, savages, ignorant and lawless, and alien races was the language that was used in those cases. While racially grounded Supreme Court decisions from that era, like Plessy v. Ferguson, have long been overturned, the Supreme Court has yet to turn the page on the insular cases. I believe the framers of the Constitution would have been philosophically offended by how the insular cases set aside America's foundational constitutional and democratic principles. A century-long denial of voting rights and equality in the territories. The legal precedent set by the insular cases continue to disenfranchise or remove territorial residents today and contradict the democratic values that are heralded as the foundation of American society. Based on zip code alone, otherwise eligible citizens of the territories are denied supplemental security income, leaving our most vulnerable seniors, blind, and disabled people to fend for themselves. Other federal programs are either capped or denied altogether. Last year, in the case the United States versus Vallejo Madero, the U.S. Court of Appeals for the First Circuit unanimously found it unconstitutional to deny low-income elderly, blind, and disabled residents of Puerto Rico the same access to federal support enjoyed by other Americans living in the states and certain other territories. Last month, the United States Supreme Court announced it would be reviewing this ruling and seeking to recover $28,000 in supplemental security income payments that Jose Luis Vallejo Madero received after moving from New York to Puerto Rico. The United States is also seeking reversal of 2 other cases where federal judges have ruled in favor of equality for U.S. citizens living in the territories. In Shaler versus U.S. Social Security Administration, currently pending before the U.S. Court of Appeals for the Ninth Circuit, a federal district court judge in Guam reached a similar ruling that the denial of SSI benefits to a disabled woman in Guam was unconstitutional. And Peña Martinez versus the U.S. Department of Health and Human Services, currently pending before the First Circuit, a federal district court judge in Puerto Rico ruled unconstitutional not just the denial of SSI benefits, but also the exclusion of Puerto Rico residents from the Supplemental Nutrition Assistance Program, SNAP, and the Medicare Part D Low Income Subsidies, LIS. With the Supreme Court granting review in one of those cases, President Joe Biden and the U.S. Department of Justice are now put in an awkward position. Unless there is a shift in the position of the government, residents of Puerto Rico and other territories. Such second-class treatment is not just unfair, it's un-American. As the delegate to Congress for the Virgin Islands, with limited voting and no voting privileges when the Republicans are in the majority, I have to work twice as hard advocating for territorial equity. I have full voting privileges in committee, and in the 117th Congress, vote in committee on the whole on the floor, which means I vote on amendments, but not the final passage. While these voting restrictions block some political avenues to correct territorial inequities, my advocacy has positively impacted the Virgin Islands. H.R. 1 is usually the bill that's reserved for the Speaker of the House, and H.R. 1 in this Congress is the For the People Act of 2021, which is key legislation that addresses voter access, election integrity, security, campaign finance, and ethics for the three branches of government. H.R. 1 is now S.R. 1, which is now the Senate bill since H.R. 1 was passed on the House side and has been sent over to the Senate for consideration. H.R. 1 includes in there an entire section, a provision that calls for the creation of a congressional task force on territorial voting rights to examine the impediments to full and equal voting rights for territories in federal elections and in the House of Representatives, and to come up with recommended changes to allow for inclusion of the territories and its citizens to be able to vote. I have also called for the Virgin Islands legislature to start the dialogue with the people of the Virgin Islands, as I stated briefly before, regarding the political status of the territory and to recognize its progress. The Virgin Islands must chart its own course for self-determination. In this session in Congress, I became the first member from a territory to serve on the House Ways and Means Committee. The Ways and Means Committee is the oldest and most exclusive committee in Congress, meaning that it has the least amount of members. Indeed, in the 1970s, House lore is that members of leadership got together to agree that no individual representing any of the territories would ever sit on the House Ways and Means Committee because of its importance. It has jurisdiction over all of our taxes, revenue creation, and is a key economic policy issue like tax, trade, and healthcare issues. It is the only committee that is discussed in the Constitution. Being on this committee gives the Virgin Islands, and indeed all the territories, finally a voice with full voting rights in that committee to advocate for territorial equity. I was nominated to the committee as a result of the vigorous lobbying efforts and work of our office and commitment to developing relationships with other members of Congress, raising my hand frequently to volunteer for things that people do not see, and to just have, I believe, one of the greatest staff to advocate on your behalf. As a result, the Virgin Islands is poised to have a strengthened retirement security system, social safety net, and critical infrastructure development. The bill that President Biden is working on now, Build Back Better, the infrastructure bill, 70% of that bill will be drafted in the House Ways and Means Committee, the committee that I sit on. It says a lot about America that an African Caribbean girl who split her childhood in housing projects in Brooklyn and on St. Croix can grow up to become a member of Congress, prosecuting the impeachment trial of a former president, as well as sitting on the most powerful committee in the House of Representatives. It also says a lot about America that I stood before 100 US senators to set out the case to convict and disqualify Donald Trump, and that at the time, I was the only Black woman in the room. We still have a long way to go. Virgin Islanders also still remained unable to vote for president, nor was I able to vote on that final passage for the impeachment. As I emphasized during the impeachment trial, our country has been given a collective opportunity to ask ourselves who we are as a people and who is America. We must also push ourselves to ask how these same questions should inform America's responsibility to U.S. citizens in the territories, most of whom are people of color. Like all Americans, in the territories deserve nothing less than full rights of citizenship, including the right to vote. I encourage all of you to seriously consider our relationship with the U.S. government and the matters of our status and self-determination. We must remove the rose-colored lenses from our view of history and see the truth of our experiences and the truth of our present. What changes do we want to see in our relationship with the U.S. government over the next years? What kind of Virgin Islands do we want for our future? As I leave you with these questions, I want to commend each and every one of you for participating in this year's Moot Court competition. I had the opportunity to read the fact pattern, and while intricate, it was not far-reaching given the persistent issues with the U.S. Postal Service, the federal restrictions that impact the U.S. Virgin Islands. Thank you so much.
Thank you so much, Delegate Plaskett. That was really just remarkable. It's like you watched the Attorney General's speech from yesterday and broke it down and made it more understandable and more applicable today, and it really follows well and it fits in. And it's funny that you say that you don't think the fact pattern is that crazy, because we specifically wrote it to be crazy. And as I was saying, commenting to Justice Cabret earlier this week, is the competition has worn on. I've come to think of it as far less outlandish of a fact pattern that we created than we initially thought we were creating.
Life is better than fiction.
No joke there. I see that my co-chair is on. Did he want to say something?
I was going to say that also overlooks the draft where I had it as the Delegate Plaskett post office at Buck Island. So I don't know if that would influence the support for the proposal, but we decided to take that little detail out.
Well, thank you so much, and we are just thrilled that you had time for us and made yourself available. It makes a huge difference.
If you would, at some time, I'd love to have the opportunity to have discussion with the young people and to be able to ask them to ask questions, as well as to hear from them what their thoughts are about where we should be and what our status should be, and their own thoughts about what they would like the Virgin Islands to be in the future.
Okay, I will make a note of that and make an effort to coordinate an online discussion.
Yes, in this virtual world, we maybe meet more often than. And thank you so much. It's so wonderful to see the judges here. It's just, I'm honored to be in their presence as well.
I'm
enormous respect for each one of them.
We have spoken on the phone years ago.
Yes.
This is the first time we have, quote, met, but but we were going to, as I recall our conversations, we were going to try to grab lunch one time when I was in Washington.
I know.
When COVID subsides, when I'm in Washington, I'm going to pursue that.
And Judge, I will make sure that you get a good Virgin Islands Crucian meal when you come to my office.
I'll settle for a Caesar salad. I'll settle for bread and water. But I do like paneer quite a bit.
Okay.
Lechon, I love. So, but
and I do that very well, so
okay.
Don't worry.
Okay, bread and water will be fine.
Congresswoman Plaskett, good to see you. Keep up the good work.
Yeah.
Thank you so much,
Yeah.
Judge Lewis. Thank you.
Make us all proud.
Thank you. Tennessee and has a little son.
Yes, I know. I spoke to him not too long ago.
Oh,
Yeah.
great.
Give him my
Good.
best.
I will. Thank you all so much.
Thank you.
And take care. And
Bye-bye.
Paige, just say hello. Paige, just so your students know, Paige is in my office here in St. Thomas. Paige is from St. John. Paige started as an intern while she was just finishing high school.
Yes.
Then did an internship in our DC office while she was in college at Dartmouth. And after graduation has come and worked full time with us. And we'll have her until she starts law school.
Nice to see everyone.
So again, just so the students know, there are summer internships offered in our office in the St. Croix, St. Thomas office, and also in DC.
And if you have any questions, just give us a call. I'd recommend it.
Thanks so much. Take care, everyone.
Mr. Benjamin, can we get you online and ready to go? All right.
No pressure following that.
Right. Could you say your name so that we make sure you have functioning sound?
Hello, can you all hear me?
Yes. It doesn't sound like there's any feedback. Yeah. So if you could say and spell your name, the school, whether you represent appellants or appellees, and the issue you're arguing for the judges.
My name is Simoy Benjamin, CYMOIBENJAMIN. And I will be an appellee arguing on the Little and St. James issue.
Are you ready to proceed, Mr. Benjamin?
Yes, Your Honor.
Please proceed.
Good day, Chief Justice and Associate Justices. May it please the court. My name is Simoy Benjamin, along with my co-counsel and I, David Charles, represent the appellees, the United States Postal Service, and I ask that the court affirm the ruling of the Superior Court. Your Honors, we are blessed to live in paradise. Stunning beaches, remarkable views, year-round perfect weather, and friendly people. But behind these lush greens and blue seas, our people are suffering. Suffering at the heels of delayed resources, medicines, quality goods, and cost-efficient merchandise.
Before you go too far down that line, let me ask you, to what extent is what you're trying to argue now in terms of the beneficial use that makes this an appropriate public taking, to what extent is that limited by the restrictions imposed on the property in the Kennedy Proclamation, the Open Shores Act, and the other attempts to restrict the use of the islands?
Your Honor, it is a public use. In order to define a public use, the court should look to the case of Kilo v. City of London, because it outlines how the court embraced the broader and more natural interpretation of public use as
but Kilo is not helpful, at least from my thinking, because in Kilo, the Supreme Court was concerned with the building and construction of a shopping mall, and it did not have to factor in the kind of countervailing consideration we have here, particularly the Kennedy Proclamation.
Your Honor, Kilo is important to us because it is where it defines public use. Therefore, in the court repeatedly and consistently rejected the narrow view that our appellants are proposing. The court.
But are we really bound by the interpretation by the Kilo Court of public use? Isn't it the case that various jurisdictions can, in fact, have more restrictive interpretations of public use?
Your Honor, we should use the case of Kilo v. City of London because it defined public use.
That doesn't answer the Judge Lewis's question. You're going back to your initial statement, but you're not answering her question.
Your Honor, no other court has ruled on the issue of public use. Therefore, the Supreme Court of the United States, in the case, ruled on the issue of public use and public purpose. Therefore, we should use the highest ruling of the court, which is the Supreme Court, which defined public use.
But did the Kilo Court say that jurisdictions can in fact have narrower definitions of public use than the very broad definition utilized in Kelo. And if isn't that the case, and shouldn't we have a narrow definition here?
No, Your Honor, we should not have a narrow definition in determining public use, because further along in the case, it also stated that public use cannot be classified as a public use, but rather as public purpose, because of the evolving needs that our society is facing.
At least that's it.
Oh, go ahead.
Go ahead. I was going to say, at least that's the definition that the Supreme Court gave under the circumstances there, which aren't the same here, right?
Yes, Your Honor. Although it's not the same as here, no court in the Virgin Islands has actually ruled on this issue. Therefore, we should use the Supreme Court's ruling into this issue of public use.
Well, within this factual context, wouldn't it be better to have a narrow definition of public use so that our natural environments could be better protected? And not only just our natural environment, just private property.
No, Your Honor, we should not have a narrow view, because it's evolving in our needs for society. And you mentioned private use. Your Honor, it's for public use, and it's for the benefit of the people of the Virgin Islands. Your Honors, the Postal Service has developed a plan that will benefit the people of the Virgin Islands. Firstly, we are building the postal hub that would increase mail to the Virgin Islands by 75%. Secondly, the additional plans that would accompany the post office is estimated to bring in an estimated $1 million to the government. Also, there will be new jobs. Tourism, our greatest strength in the Virgin Islands, will be increased.
Why will the tourism be increased necessarily by taking away part of that which is attracting them?
Your Honor, tourism will be increased because the takings of Great St. James, where there will be the hotels, would need people to accompany them. Therefore, people would be interested in coming to our islands. They will have places to stay as they travel throughout our beautiful Virgin Islands.
Where you are arguing that we should adopt the public use definition in Kelo, which was a plurality opinion. But let me ask you, where in the Organic Act or where in the United States Constitution, especially the Fifth Amendment, is there the word public purpose? Don't both of those documents use the word public use as opposed to public purpose?
Yes, Your Honor, they both use public use as public purpose. But the Supreme Court is the highest court in the United States. Therefore, we should use the highest court's ruling to define public use or public purpose.
Just let me read something for you. In that Kelo case, it says, in affirming the city's authority to take petitioners' properties, we do not minimize the hardship that condemnations may entail, notwithstanding the payment of just compensation. We emphasize that nothing in our opinion precludes any state, here a territory, from placing further restrictions on its exercise of the takings power. Indeed, many states already impose public use requirements that are stricter than the federal baseline. Why shouldn't we do that here? Why shouldn't our eminent domain authority here incorporate a more strict definition of public use, particularly in the context of this situation where we have the natural beauty, the natural resources, the proclamation by the president, the Open Shorelines Act, etc. Why shouldn't we have a narrower interpretation of public use? Uh-oh.
Lose him?
Yeah, and that was quick because his image was moving. They'll probably log on real quickly here. There they are. Did you hear all of her question?
No, may you please repeat it, Your Honor?
Okay, so let me shorten it here. The Kelo opinion says, we emphasize that nothing in our opinion precludes any state from placing further restrictions on its exercise of the takings power, and that many states have already imposed such restrictions on the definition or interpretation of public use. My question is, in light of the countervailing circumstances that we have here, the natural resources that need to be protected being a prime one here, why should we utilize a more restrictive definition of public use?
Your Honor, we should use a more scripted definition of public use because there is no such definition where it actually talks about what is public use, but rather it defines what is public purpose. In the case of Kelo, it stated that public purpose is it can benefit the people. Therefore, Your Honor, the Postal Hub the Postal Service has an integrated plan that would service the people of the Virgin Islands, would increase revenue to the Virgin Islands, jobs, and lastly, our greatest interest, tourism.
But you know, the way public purpose was used in Kelo, they were talking specifically about whether or not the city's development plan served the public purpose. Here, if we take an analogous situation, it seems that the restrictions based upon the natural resources in the Virgin Islands would serve a public purpose. And if that's the case, then I'm not sure that the taking that you're trying to engage in would be something that we could define as a public use, because it would be contrary to the public purpose as set forth in the Kennedy Proclamation and the various statutes that control here. Does that make sense to you, that question? They're frozen again.
Yes, I think they froze again.
They may have a button they hit whenever there's a hard question to freeze.
Oh, right. They freeze the screen and then they think about it. Right.
Did you hear my question, Mr. Benjamin?
I'm sorry, Your Honor, but I did not hear the question. May you please repeat?
Sure. I was talking about public purpose and public use, a distinction which you very, I think, adroitly made. And I was saying that in Kelo, they talked about the public purpose being enhanced because the use or the taking was consistent with and furthered a plan of development. The shopping center was consistent with the city's development plan. That development plan was the articulated public purpose. Therefore, a taking which was consistent with that was a public use. You with me so far?
Yes, Your Honor.
Okay. What I'm saying is that here, we could say there's an analogous situation in that the Kennedy Proclamation and the various Virgin Islands statutes designed to protect the natural beauty of the islands, that is a public purpose. And so it would seem to me that your use, your anticipated use and your taking would have to be consistent with that public purpose. And I'm not at all sure that it is.
Your Honor, our plans are for public use or for a public purpose. Your Honor, the main purpose of the and the main purpose is the meal. Your Honor, it has been, Your Honor, we have been prolonged with long waiting days, weeks, months for medicines, for prescriptions, Your Honor. The people of the Virgin Islands need this. That's why we have developed a plan that will service the people of the Virgin Islands.
Well, you developed a plan, but we're not talking about you developing a plan. We're talking about what was in Kilo, the city's development plan, not the takings plan. We can't have a situation where we look to the plan of the governmental taker, because then all the governmental taker has to do is draw up a plan that will legitimize its taking. So that can't be the situation. So the purpose here has to be one of preserving natural resources and natural beauty, and I'm not hearing how your proposed taking advances that public purpose. And if it doesn't, it isn't a public use under Kilo, is it?
Your Honor, the reason we're using Kilo to define the reason we're using Kilo versus CTMD London is to define the public purpose. We're not really looking into the plan that the city had, but we're looking into the purpose that we have that incorporates its definition. Therefore,
but that's the problem, because I'm saying in Kilo, the court did look to the city's plan, because that plan was an articulation of the public purpose. What you're saying is that doesn't work here. We have to look to the public purpose of the taking entity. I'm saying that can't be right, because then every taking would be justified. The taker would just come up with a plan that would allow it to take whatever it wanted.
No, Your Honor. We are the Postal Service. Congress gave us the power to take property and use it for public use.
Irrespective of the purpose.
Yes, Your Honor. It was stated that in the case of McCullough vs. Maryland, that the federal government has the power to do what is necessary and proper to adopt the means by which it can carry out its powers. Therefore, Your Honor, the power that we have to take and use the property, that's why we're taking Little and Great St. James to service the people of the Virgin Islands.
But it still has to satisfy the public use standard, though, doesn't it?
Your Honor, it does satisfy the public use standards. Your Honor, the main purpose of it is to service the people. The postal hub, it would increase jobs to the Virgin Islanders. Income, close to $1 million would be awarded to the government annually, and tourism will be increased. Therefore, it is a public use.
Counsel, if we adopted a narrower interpretation of public use, would the post office then lose?
No, Your Honor, we would not lose if we was to develop a narrower view. Because although you developed a narrower view, Congress gave us the power. So that, I see that my time has expired. May I finish answering a question and briefly conclude?
You may finish.
Your Honor, we have the power from Congress. Therefore, we can't take the property and use it for the benefit of the people. The people have been suffering long, Your Honor, and it is time that we make these moves in servicing them. And I conclude, Your Honors, it is a time that we move forward in servicing the people of the Virgin Islands. We have accepted the slow delivering for many decades, but it is time that we stop. We have numerous resources available, and we should use them to our advantages in servicing the people of the Virgin Islands. And I humbly ask again that the court affirm the ruling of the Superior Court as we set forth into our future and betterment of our beautiful Virgin Islands. Thank you.
Thank you as well.
All right, we're doing pretty well with time. Things have smoothed out a bit here. So we have St. Croix Seventh Day. Ms. Roy Ann Blossom Filbert will be going next. Can we get her on the screen, please? Oh, they're still connecting. There we go. All right, Ms. Filbert. Right. Can you speak? So, yeah.
Hello.
Hello. You're not getting any feedback from me?
No, not at all.
Sorry, judges, I wasn't paying attention. Are you ready, or do we need to wait a bit?
Well, I'm ready.
I'm ready.
Ready as well.
All right, Ms. Filbert, please say and spell your name, the school that you're from, whether you represent appellants or appellees, and the issue you're arguing.
My name is Royan Blossom Filbert. That's ROY capital ANN hyphen BLOSSON. Filbert, PHILBERT. I'm from the St. Croix Seventh-day Adventist School, and I'm representing the appellants.
What issue will you be arguing?
Buck Island.
Very well. You may proceed.
May it please the court, my name is Royan Blossom Filbert, appearing on behalf of the appellant, Buck Island Environmental Agencies. Your Honor, my colleague and I are saying that the court erred in denying the injunction. I will speak on behalf of Buck Island, and my colleague will speak on behalf of Little and Great St. James. Your Honor, the building of a post office on Buck Island is in clear violation of the Kennedy Proclamation and the Open Shorelines Act. We ask that you overturn the decision made to deny this injunction. Buck Island is home to many birds and exotic animals and home to the only pristine garden in the United States. It is also a place where Virgin Islanders go to enjoy the environment and wildlife. Your Honors, in the case of the United States versus St. Thomas Beach Resorts, they built fences that blocked the public from using the beach. This clearly violated the Open Shorelines Act, which states...
But here they're not blocking the beach. They're not taking away use of the beach. And it looks like they're very carefully trying to narrow or focus their activity so that things like Turtle Beach are not drastically impacted, so that most of the natural resource part of the island is preserved.
Your Honor, in the case of the St. Thomas Beach Resorts, they were in violation of the Open Shorelines Act
because they blocked the beach. They're not blocking the beach here.
Your Honor, in this case of the Buck Island, they're not blocking off the entire beach. They are cutting short, they're taking the shorelines that in the proclamation says that any obstruction or barrier, restraints of any nature whatsoever across or within the shorelines is in violation of the Open Shorelines Act.
Well, couldn't they still, if they could show a public use, an appropriate public use, wouldn't that still be sufficient to allow them to accomplish the taking? If not, why not?
No, Your Honor, because in the Open Shorelines Act, when the act was created, what they write in it they mean what they say. And in the act, it says that no person, firm, corporation, or legal entity shall create, maintain, erect, or construct anything on the island itself, on or within the shorelines.
Why wouldn't the exercise of a federal power trump that? I hate to use that term. Why wouldn't it supersede that local statute?
Your Honor, the federal government and the Virgin Islands have concurrent jurisdiction.
Okay, elaborate on that for me.
They have concurrent jurisdiction, which means that the laws of the federal government and the Virgin Islands government, they interact with each other in a way that it will not overthrow what the federal government says, and the federal government will not overthrow what the United States Virgin Islands government says either.
But if we read the Open Shores Act and the Kennedy Proclamation in a way that says that there shall not be any of those uses or limitations unless it is pursuant to a public use, wouldn't that be a way of harmonizing both the eminent domain authority and limitations imposed by local law?
Your Honors, in this case, the use of public is not only referring to Virgin Islanders alone. It refers to the turtles and the wildlife around Buck Island.
So the turtles are members of the public?
Buck Island is home to these turtles. So
the habitat's not being disturbed, though. Isn't they specifically carved out Turtle Beach? They're not impacting that.
Your Honor, the 95% of Turtle Beach that we use, if we use Turtle Beach because that's the only beach that we have left on Buck Island, if the post office is built, the turtles won't come back because turtles won't just wait until we leave to come back. They just won't come back again.
How do you know that? Is there some authority, some study that you're relying upon for that?
Your Honors, as I was doing research in one of my classes, they stated that turtles always go back to where they were.
Who's they?
In my textbook, I was doing research. In the textbook, it stated that turtles, no matter which species it may be, always goes back to where they were born to nest. Your Honors, if these turtles nested on Turtle Beach and we take over Turtle Beach, they'll have nowhere to nest.
My colleague, Justice McKee, was asking whether or not the federal and the local authorities, laws, cannot be harmonized, both used. And I'm not sure I understood your response. And the harmonization that Justice McKee was talking about was saying that, certain uses were not appropriate, or certain things that are referenced in the presidential proclamation could not be done unless there was a public use. Would that be a way of harmonizing both the local and the federal authorities?
I'm sorry, I didn't understand your question.
Let me try again. Let me try and make it a little clearer. Justice McKee asked whether or not the proclamation and the eminent domain, the federal, could be harmonized. And I did not understand your response to that, because I thought your argument initially was that the local, that would be the Shoreline Act and the presidential proclamation, would be trumped, or would trump the federal. The question is whether the federal and the local laws could be harmonized.
The federal and the local law can be used interchangeably because we both have concurrent jurisdiction, Your Honor.
And how would they be used together?
Your Honor, the Kennedy Proclamation states that the Kennedy Proclamation turned it over to the Secretary of Interior. But in the Open Shorelines Act, they also stated that, but in the Kennedy Proclamation, they stated that neither the Department of Interior or any other federal agency or instrumentality of the United States shall adopt or attempt to enforce any rule, regulation, or requirement that limits the Virgin Islanders.
So if there is a legitimate public use, of property, are you saying that an entity that has eminent domain authority could not take the land and use it for legitimate public use?
No, Your Honor, this is not in the case of eminent domain. Your Honor, in this case, the government is taking Buck Island, which is a national monument that's reserved for the wildlife and that lives on and around Buck Island, and making it for public use of the Virgin Islanders. When, Your Honor, in all fairness, yes, we do need a post office, but it doesn't have to be on Buck Island.
Okay.
May I continue?
Yes. Thank you.
Just like how in the St. Thomas versus Beach Resorts, they were violated the Open Shorelines Act, similarly, the building of a post office on Buck Island is in violation of the Open Shorelines Act as well. It is clear that we need a post office, as I stated. Your Honor, in the United States versus Rivera case, they wanted to close down all of Buck Island because of budget problems. The government argued that it had authority to close down the beach, but the court held to the fact that the Kennedy Proclamation states that the government not interfere with the bathing and recreational activities on Buck Island. Your Honor, recreational activities do not only mean chilling on the beach. It involves diving and snorkeling in order to see and enjoy our pristine marine gardens.
Well, the post office on the land will not interfere with snorkeling and diving, will it?
Your Honor, yes, it will, because the pier extends 300 yards into the ocean, which means that you'd have to dredge up the coral reefs that surround Buck Island. Your Honors, I see my time has run out. May I conclude?
May conclude.
In conclusion, I state again, yes, we need a Buck Island. We need a post office, and it doesn't have to be on Buck Island. So, Your Honors, I ask that you overturn the decision made to build a post office on Buck Island. Thank you.
Thank you as well.
Very good. Mr. Reynolds, you're in a different location, so let's, all right. Can you speak and we can test your microphone and make sure we're hearing you?
You hear me?
Yes, and you're not getting any feedback from me?
No, I'm not.
Right, and no one else is?
No.
No, sir.
All right. Sorry about that. Let me know when you're ready to go, judges. I wasn't paying attention again.
Ready.
Ready.
Yep, me too.
Okay.
Great. Please say and spell your name, the school that you're from, whether you represent appellants or appellees, and your issue.
My name is Kajani Reynolds, Kajani Reynolds. I am from the St. Croix Seventh-day Adventist School, and I am representing the appellant on the issue of Great St. James and Little St. James.
Are you ready to proceed, sir?
Yes, I am.
You may proceed.
Thank you very much. Your Honors, I believe that the lower court erred in its decision of granting the post office the right to take Great St. James and Little St. James. First, I'd like to begin with the fact that the eminent domain clause says public buildings and grounds for the use of any town, village, school, district, or any other governmental division. Basically, what that means, when the government takes something, it has to be for the use of the public. Now, this luxurious hotel that the postmaster is planning to bring with royal Danish architecture, large ball halls, billiard rooms, and so on, this is not for your average person. This is for the elites. the top 1%
Who's
of
going to be working there?
Who's going to be working there?
Right.
Oh, well, people, Virgin Islanders, and so on.
Not the elite.
Excuse me?
Not the elite, right?
Well, I didn't hear you say.
It'll be providing jobs for the people of the Virgin Islands.
Well, yes, Your Honor.
Why isn't that a benefit, a public benefit?
Well, Your Honor, that would be considered I will refer to the Keeler versus New London case. Justice O'Connor dissented and said that secondary benefits, such as jobs, extra tax revenue, and so on, if that alone was to be considered a public use so that government can transfer one person's private property to another,
But she was dissenting. There's a reason why she was dissenting. The court did not agree with that position, that full position. The plurality opinion is to the contrary, isn't it? That's why she dissented.
Well, yes, Your Honor. But would you agree that jobs and so on, wouldn't you agree that that is sort of an economic benefit?
I agree that it's a benefit to the public.
Well,
are you saying it can't be an economic benefit? Is that what you're saying? That the benefit
it can be economic. Oh, sorry. Go ahead.
No, go ahead.
Look, it can be an economic benefit, but it cannot be an economic benefit alone. In the Wayne v. Hashcock case, it was said that a pursuit of profit by a private entity is not a public use for constitutional taking simply because it may provide some jobs and money and so on, but that alone cannot be a public use. So public use would be something like a road where people use, a power plant which generates power, and so on. This hotel that is generating profits and is serving elite guests, the top 1%, is not a public use.
Promoting tourism for the islands, that also, you're saying that promoting tourism would not be a public use because that's just a mere economic benefit.
Well, it is an economic benefit, sir. So it is that in and of itself is not public use.
So what would be a public use here that would be sufficient?
Sufficient. Something in which the public can use. So some sort of a, not just a mere convenience like a hotel, but a necessity. Roads, as I said, power plants, and so on. That can be considered a public use.
So they could take the islands and put up a power plant and totally obliterate the natural resources of the island. But putting a power plant there would be a public use. That's what you're arguing?
Because the power plant is benefiting the majority. This hotel will benefit the people who are staying there and the few people with the skills such as cooking, cleaning, and so on. That is benefiting a percentage, not the general public.
What about the monies that are going into the coffers of the Virgin Islands government?
Excuse me?
What about the monies that are going into the coffers of the Virgin Islands government? They say some $780,000.
Was that
$1,000.
Well, Your Honor, that is, as I said before, an economic benefit. It is money. It is helping, and that is helping the economy. And as I stated in the Wayne v. Hashcock case, it cannot be a sufficient public use just because it helps the general health of the economy.
What about that together with the increased efficiency and timely delivery of mail?
Well, when it comes to the timely delivery of mail, Your Honor, I was going to get to that, but we all know that in the Virgin Islands, we have the three main islands, St. Croix, St. Thomas, St. John. But there's up to 50 islets and cays, many of which are not owned by any specific individual, are owned by the government. And one of the reasons they chose Great St. James and Little St. James is because it was between St. Thomas and St. John. I have some cays here, Grass Cay, Congo Cay, Stephen Cay, which are owned by the government. no private entities using it, and it is situated between St. Thomas and St. John, which is one of the reasons in which they chose Great St. James to live in St. James.
I'm not sure that answers the question. I'm not sure that answers the question. Help me understand what you're saying in response to Judge Lewis's question. She's asking you why, if you're putting aside the economic argument, that's not sufficient. What about the expedited delivery of mail, medicine, and packages? Why wouldn't that be a public benefit?
Well,
such that you would end up with the conclusion that this is not, such that you would end up with the conclusion that it's not solely an economic benefit, it's an economic benefit plus.
Well, Your Honor, eventually I didn't have a response for that, but they plan to build deep shore piers. They plan to close off certain beaches, and that goes against the Open Shorelines Act because the stakeholders have stated that some people like to swim, they like to snorkel and sunbathe. You know what we Virgin Islanders like to do with the beaches that is for our enjoyment and has been stated should not be obstructed by any means.
Well, I'm still not sure I understand why expedited delivery of medicine and packages and mail is not a public benefit. It seems to me that's analogous to putting a power plant there. Putting a power plant there, and you can see that would be an appropriate taking. And that would mean that people of the Virgin Islands were able to have reliable power. The fact they have reliable access to the mail and medicines would seem to be equally beneficial to the public, and I'm not sure there's a distinction there. I may be missing something. If there's a difference, let me know. Maybe I'm overlooking it.
Well, Your Honor, when it comes to eminent domain, I certainly believe that there should be some boundaries drawn.
Well, there are very clear boundaries. There has to be an appropriate taking for a public use. That's the boundaries, and we're still trying to grapple with why this is not a public use, a public purpose.
Well, on some part, yes, the post office is a public use, but would you agree that the apartment for the postmaster and the luxurious hotels and so on, would you agree that that is a public use, Your Honor?
Well, you're asking me the question. That I would say is not a public use, but the collateral benefits may well be. The mail delivery, the enhanced opportunity for jobs.
Well, Your Honor, I do not have a response for that.
Okay.
Well, as we close off this, as I begin to close off my case, Your Honor, the hotel and so on is generating economic benefit, and that goes against what's said in the Wayne v. Hashcock case. They are going against the Open Shorelines Act by closing some beaches. They said they'll close part of Christmas Cove Beach, 1/3 of it, and 1/3 of beaches to the southern and western ends of the island, Your Honor. So, as I close, because my time is running out, I would like you to overturn the decisions made by the lower court and grant the estate holders the right to have their land back, Your Honors. I rest my case, and I thank you for hearing me out.
All right, so St. Croix, you can stay on. You have no more arguments to make. And there we go. I was wondering where Mr. Richardson was. They're joining now. Okay, Mr. Richardson, can we get Ms. Thomas on the screen with her microphone on? Okay, Ms. Thomas, could you speak so we can make sure your microphone is working and everything?
Good day. My name is Michaela Thomas.
All right, and you're not getting any feedback from me, Ms. Thomas?
No.
All right. Okay then. Oh shoot. Judges, are you ready?
Ready.
All right. Judge Lewis, you ready?
I'm all set, thank you.
All right. Then Ms. Thomas, please say and spell your name, the school you're from, whether you represent appellants or appellees, and your issue you're arguing.
Good day. My name is Michaela Thomas. It's spelled M-I-K-A-Y-L-A-H. Thomas. School, and I will be representing the appellee side for the United States Postal Service.
Are you ready to proceed?
Yes, Your Honor.
You may proceed.
Good day, Chief Justice, Associate Justices, and may it please the court. I am Michaela Thomas, and I, along with my co-counsel, Jeb Diadon, represent the United States Postal Service in the matter before the court today. Your Honors, present before the court today is the United States Postal Service seeking to carry out its functions by using the powers constitutionally provided to it, and a legal challenge that seeks to maintain a status quo that harms the people of the Virgin Islands despite clear benefits.
What is the status quo maintaining the beauty of the island? How does that harm the people of the Virgin Islands when the Virgin Islands population has enacted legislation to do exactly that, to preserve the beauty of the island?
Could you please repeat your question, Your Honor?
Yes, you're saying that the status quo harms the people of the island, but the people of the island have enacted legislation to protect the beauty and integrity of the natural resources there. So how could honoring their wishes through that, through the Open Shores Act, how could that harm them?
Well, Your Honor, since we don't have faster mail, some people, the specific medicine that are needed for some people, they're not receiving that medicine. For example, every year people of our inhabitants flew out to the States because the Virgin Islands don't have the resources that we need for them. In that way, they would have to go to the States and go through the expenses to get these resources needed for them. It would be to our best interest if we provide these resources for these inhabitants, and that way we're harming them.
Well, are you asking us to basically amend the Open Shores Act and amend the Kennedy Proclamation by reading into it a clause that says, notwithstanding any of the above, if there is a use which facilitates people on the islands getting medicine and mail, then it's okay to destroy the natural resources?
No, Your Honor, we're not amending anything or destroying anything. Can I go into my first point, Your Honors?
Well, hopefully your first point will answer the question. Go ahead.
Okay, to my first point, the Postal Service under 39 USC Section 401 is broadly empowered to adopt rules and regulations designed to accomplish its functions and directives. The United States Postal Service versus Council of Greenberg Civic Association states this plainly. The opinion of the court in that case notes, when the United States Constitution was ratified in 1789, Article 1, Section 8 provided Congress the power to establish post offices and post roads and to make all laws which shall be necessary.
No one is denying the fact that the Post Office Department has the authority to build post offices. What we're concerned with is whether or not you're precluding from the taking that you're trying to accomplish here, whether or not it's consistent with or contrary to the restrictions in the Kennedy Proclamation and the Open Shores Act.
Your Honor, the Proclamation 344 also says that or any agency or instrumentality shall not adopt or attempt to enforce any rule, regulation, or requirement limiting, restricting, or reducing bathing or recreation privileges of the inhabitants of the island shall not charge fees to access the area. Right. This proclamation clearly gives Buck Island the ability to have a postal service only if it follows these conditions and guidelines. We're not restricting them from any bathing or recreational privileges, Your Honor.
You're not limiting or restricting fishing?
Your Honor, we're not restricting that either.
What about the presence of the pier? Doesn't that limit fishing?
It's an environmental damage, yes, Your Honor, but we're not limiting them. We're only enhancing the access.
But you just said there's environmental damage. The Kennedy Proclamation is intended to prevent environmental damage, isn't it?
Yes, Your Honor, but in the case of Putney, the benefits was outweighed by the cost, and to compare the two cases, a potential oil leak from one state to another would be far more dangerous than a meal spill in the ocean. I'm simply saying, Your Honor, that this is a balancing test. We do acknowledge that there will be environmental damages. However, we know that it's our responsibility to provide the least amount of damages because we too care about our marine environment.
But you say it's your responsibility to limit the damage. Doesn't the Kennedy Proclamation prevent you from inflicting any damage?
Could you repeat that, Your Honor?
Doesn't the Kennedy Proclamation prevent you from inflicting any damage? You're saying that you have an obligation to limit the damage, but you have a prohibition against inflicting any damage, don't you?
I'm saying that it does. That we would be we would be violating some of the environmental damages. However, in our case, it's minimal.
You spoke about a balancing.
Yes, Your Honor.
What would you be balancing, and what would be the result of the balancing?
Well, Your Honor, many of us have grandparents and other family members whose life depend on faster meal services in order to get that specific medicine that we don't have here in the Virgin Islands. This facility would definitely help save lives and continue to put our community's needs first. Yes, I understand that there will be environmental damages, but Your Honors, let's be honest. The territories are not treated the same when it comes to medical aid. So that is what it will be balancing.
Can you walk me through an injunction and the steps of the injunction and why the injunction here was either correct or wrong?
Your Honor, I don't quite understand your question. Could you?
Well, there was a motion, the natural resources folks were trying to enjoin what was going on and get an injunction. Maybe it would be helpful to me to just outline what are the steps, what is the showing that has to be made in order to get an injunction or for the court not to impose an injunction. Is there a test that has to be applied? And was the test correctly applied here or incorrectly applied here?
Your Honor, are you asking me to list the elements in an injunction?
I'm asking not just to list it, but to walk me through the facts here and how the facts would apply to that test, to those elements.
Well, in 28 VIC, it says that the first part of an injunction would be the likelihood moving party succeeds on the merits. Irreparable injury occurs without relief. Relief will not cause greater harm to the non-moving party, and public interest is furthered by granting injunction. Your Honor, where satisfying relief will cause greater harm to the non-moving party, and public interest is furthered by granting injunction. My intent is that I'm saying that the opposing counsel does not satisfy all four.
Do they have to satisfy all four?
Yes, they do. May I proceed to my second point, Your Honor?
Yes.
This brings me to my second point, Your Honors. If we add to the proclamation to the language in 12 VIC, section 401 to 403, the Virgin Islands Open Shorelines Act, the public, individually and collectively, has and shall continue to have the right to use and enjoy the shorelines of the United States Virgin Islands. The postal plan does not limit or reduce this right. Instead, it enhances access and recreation. For example, it allows them to still be able to attend the beach while having faster meals simultaneously. The Virgin Islands are also known for their historic sites, and this would definitely make history if we are able to pull off having a postal service on the beach while still not restricting the inhabitants from utilizing the beach. The public will not only be enjoying the shorelines, but also enjoying other benefits that Buck Island has to offer. Your Honors, we feel that when Kennedy was writing the proclamation, it was not in his intention to disapprove of a postal service that could potentially save lives, improve the education of our students, improve mail by 75%.
But don't we have to get his intention from what he said in the proclamation? And there's no language in there to say none of this limitation applies if a change that would negatively impact the natural resources will help improve lives or speed up mail delivery. And he knew about mail delivery even back in his time.
You wasn't very clear, Your Honors.
Okay, well, I apologize for that. No, what I'm saying is you're asking us to read a limitation on this prohibition. You're saying that, well, when Kennedy wrote this, he wasn't really thinking about something that would improve mail delivery. And I'm saying to you, what I hear you arguing is that we should put in here language which would say none of this limitation applies if if the limitation on natural resources will enhance mail delivery or speed up law delivery. Does that make sense? Is that clearer?
Yes, Your Honor. Okay. And my answer to that is yes. I see that my time has elapsed. Can I please conclude?
Okay, well, you can answer. Go ahead. I'm sorry.
Your Honors, if this course tries to balance what is lost and what is gained, there are far more gains. The Virgin Islands shorelines remain open with greater access. The proclamation conditions remain satisfied, and added to that is mail service comparable to a major city in the mainland. It is for the aforementioned reason that this court should affirm the Moot Superior Court ruling and rule in favor of my client, the United States Postal Service. I yield the floor to my co-counsel, Attorney Diodon, and thank you.
Good afternoon.
Good afternoon. Are you getting any feedback as I speak or anything?
Yes, I am.
You have background noise filtering?
Oh, no, I'm not getting no feedback. Sorry. That's
Okay, good. Sorry, I was busy dealing with score sheets. Judges, are you ready?
Yes.
Ready.
Okay.
All right. Mr. Dudon, please say your name and spell it, your school, whether you represent appellants or appellees, and the issue you're arguing.
So my first name is Jeb, J-E-B. My last name is Jordan, D-I-E-U-D-O-N-N-E. And I represent the appellees. And I'm from South Amalia High School.
Are you ready to proceed?
Yes, I am, Your Honors.
Well, then you may proceed.
Good day, Chief Justices. Good day, Chief Justice, Associate Justices, and may it please the court. I am Jeb Jidan, also representing the United States Postal Service in the matters before the court today. Your Honors, before the court is the denial of request for injunctive relief by the petitioners in regards to the exposed potential future development of the Postal Service. Although they are plans, Your Honors, these postal hubs would benefit the citizens of the public in the United States Virgin Islands on an unquestionable scale. We intend to establish that the most superior court was correct in denying the plaintiff's request for injunctive relief, and that the plan was for Great and Little St. James was public use, and that ruling should be affirmed for the following reasons. Point one, Your Honors, the Postal Service have the power to acquire Great and Little St. James by utilizing eminent domain under the revised.
But here again, we're not doubting the power. We're doubting the exercise of that power. And I'm not sure how you can justify exercising the power here in a way that doesn't seem to me to have any real public benefit. It benefits both the developer, but it doesn't seem to, and it'll benefit wealthy tourists, but it doesn't seem to benefit the people of the Virgin Islands.
Yes, Your Honor, that's a good question. It will benefit the public of the Virgin Islands because it's a postal office, a postal sorting hub for the citizens within the territory itself. And under the Revised Organic Act of 1954, it says that property cannot be taken for public unless they provide just compensation. And it also said that in the Fifth Amendment of the U.S. Constitution. And since we are in the local territory, we will go with the Revised Organic Act of 1954.
How are you defining public use?
Well, Your Honor, public use in Kello, it says that public use does not necessarily mean that it have to be used by the public, as long as it have a public purpose, or a public benefit, Your Honors.
And that's the Kelo decision?
Yes, that's in the Kelo case.
Are we bound by that in our determination of the issue here?
Yes, we are, Your Honor. We are bound by the Kelo because it's a Supreme Court case, but also Kelo noted that states can require more than just economic benefits, which we meet. The Postal Service does meet it. And the other states updated their constitution, and the United States Virgin Islands did not update their constitution. Even though we don't have a constitution, it did not state it in the Revised Organic Act of the Virgin Islands, nor did the legislature said that. So that's
you're saying that what is appropriate for the court to apply here is a definition of public use that is actually narrower than what the court adopted in Kelo?
Not necessarily, Your Honor, no. Because the post office is a instrumentality, extreme instrumentality. Before they had carriages or cars, there was postal service. Before the Civil War, there was postal service. So that's what the Postal Service is, a powerful instrumentality, Your Honor.
And therefore what? It's a powerful instrumentality. It has certain powers and authorities, and therefore your conclusion is what?
Yes, that's why we are sticking to Kelo.
But I don't think
I'm not sure I understand the connection. It has powerful. It's a powerful, agency. It has certain authorities. We recognize all of that, and therefore that's why you're sticking to Kelo. How is that connection made?
That the public use was required at that time in Kelo, and in the Postal Service it provide more. And in Kelo it said that the economic development plan, economic benefit qualified. That's why the public use was authorized by the taking, for the taking.
And is that the standard that you're asking this court to adopt? That if there's an economic benefit, then the taking is legitimate?
Yes, Your Honor. But the other constitution, we will meet that too, even though the United States Virgin Islands is not updated yet. We will meet it because we are providing just more than economic benefit. We're not providing economic benefit alone.
Okay.
So I'm sure I want to understand what you're arguing. You're saying that as long as there's economic benefit to the population, the taking is justified? Is that what you are arguing?
In the court in Kello says that yes, but if you're providing more, in the other
what else are you providing?
We're providing an economic benefit that's with the Royal Mail Inn Company that's bringing in like $750,000 to the economy. We're improving the mailing by 75%, Your Honor. And we will also provide greater access to the islands of Great and Little St. James.
It strikes me that Carlo was very different because there they looked to a public purpose as defined by the city's development plan. And this shopping center was consistent with the city's development plan, therefore it was a public use. Here it seems to me what we have to look to is the Kennedy Proclamation and the Open Shores Act, so that the public purpose here would be preserving the serenity and the natural beauty of the islands. And I don't see how interfering with that by putting up two mansions would be consistent with either a public purpose or a public use.
Can you repeat that again, Your Honor, please?
Yes, you're relying upon Kilo, which to me is a very different case because there the public purpose was defined by a municipal development plan. And that was therefore the shopping center that was consistent with the city's development plan was a public use. Here, the equivalent of the city's development plan, it would seem to me, is the Kennedy Proclamation and the Open Shores Act, because they set forth the intent of the use of the islands. And the intent is to maintain the pristine nature of the islands. If that's the case, your taking seems very inconsistent with a public purpose and a public use, and contrary to Kylo.
Yes, but Your Honor, the thing is that in Kello, not in Kello, I'm sorry, I misspoken. The thing is that the proclamation is for the Buck Island. Although the Open Shorelines Act applies to Great and Little St. James, the Postal Service is not in violation of it, Your Honor.
No, but what's happening at the St. James Islands is that the natural beauty is being compromised by two very exclusive mansions, one of which would be the residence of the postmaster for the area. I don't understand how that could possibly be a public use or an appropriate taking.
But Your Honor, look at it this way. That's a good question. Look at it this way. The luxury apartment, I would not really consider it to be a luxury apartment because that apartment is already existing. They're just taking the existing mansion and transferring it into a place where the postal workers and the postmaster could stay in case a dangerous storm might pass by. And that way we will not stop the mail sorting process on the island, Your Honor.
Now, why is that an appropriate taking then? You're saying it's already a very exclusive mansion and you're just transferring title to that mansion. You're using the power of the government to transfer title from person A to person B. That doesn't seem like much of a public use or a public purpose to me. Am I missing something?
But may you repeat that again, Your Honor? I didn't really pick it up.
Yes, I may be missing something, but you're saying that there's already a mansion there, and you're just transferring it so that someone else will be living in the mansion, the postmaster. How is that a public purpose?
Well, Your Honor, that's just the incidental benefit of the Postal Service. We have to look at all the other benefits that the Postal Service has, which is the economic benefit, the enhanced mail, and greater access towards the island. That hotel will only be the funding source of the postal hub that's on Great and Little St. James.
Is there a portion of the beach as well that's going to be restricted to those who are at this exclusive elite guest hotel?
Well, according to the facts, yes, Your Honor. But we realize that the Royal Mail Inc. company is not in front of the court today, it's the Postal Service. So if we are in front of the court, we realize that the, excuse me, Your Honor?
No, I was going to let you finish.
We realize that what the Royal Mail intentions are not what the Postal Service are. That's not what the postal intentions are. So we realize that the plan is not fully solidified. There's still changes that can be made. And
but isn't that part of the Postal Service's plan? Isn't that part of the entirety of the plan? Because the Postal Service will then be getting monies from the Royal Mail Company to fund some of the activities that it wants to be promoting, right? So I mean, it's not like this is something separate that the Postal Service is before us today, but Royal Mail is not. Royal Mail is integral to this entire plan, is it not?
Well, Your Honor, yes, the Royal Mail will be a part of our plan, but they had separate rules when it comes to their hotel. But we as a Postal Service, realize that those plans that they are doing will be going against the citizens' right to use the shorelines. Because in the court case, or where in St. Thomas Beach Resort, they build them the fences to keep the citizens out, but that's not what our intentions are. Our intention is to use the access.
But aren't you responsible for whatever they're going to do as part of this plan that is being effectuated through eminent domain? In other words, doesn't the taking, the entirety of the taking, because the entirety of this is private land that's being taken, right? So that's why the eminent domain power is being used. So the entirety of the taking has to be for public use when you look at it in its entirety, doesn't it?
Yes, Your Honor, but according to Kello versus New London, the sovereign may transfer private property to private parties acting the same common carrier and public utilities who will make the private property available for public use. But even though there may be incidental direct benefit to the private parties under Title 28 VIC, Section 411, numbers 3. Even though the Postal Service will provide an essential service to the people of the Virgin Islands, there may still be incidental benefits to the private parties, Your Honor.
And so your position is that what is happening here with this Royal Mail company is incidental?
Yes, Your Honor.
What if in Kylo they'd have taken the property, given it to the same developer, and he turned it into a very exclusive golf range? Would that have been okay, do you think, under the reasoning of Kylo?
Well, Your Honor, it will not be a golf range because that's not in the facts. That was what, not, that's not.
That's in my question. What if in Kylo, rather than the property being taken and being given to a developer for a shopping mall, it had been given to a real estate developer to develop a golf range, which would have benefited a very, very few rich individuals, the same way that this project is benefiting a very, very few rich individuals. Would that have been okay in Kylo, do you think?
That would, to me, Your Honor, in my opinion, that would still be an incidental benefit because if you look at it, the mall up in Tutu Plaza, which bring in a major source of income within the economy. And Your Honor, I see that my time has elapsed. May I please finish your question and conclude, please?
Yes, you may.
Yes, the mall bring in a large amount of revenue to the Virgin Islands. And even though if the Postal Service were to make a mall on Little St. James, or on Great and Little St. James, it will still bring additional revenue to the Virgin Islands. And if the Royal Mail intentions are to fund the Postal Service hubs, it will still do that and it will still be an additional benefit, Your Honor. In brief, Your Honors, the taking of Great and Little St. James is a constitutional taking that will benefit the United States Virgin Islands. The future foundation of this establishment imposes no threat to the citizens within the territory, and it is self-evident that the territory is in a desperate need of a new enhanced postal sorting and distribution center to improve the delivery time and packaging. It is for the previously mentioned reason that this court should affirm the most superior court just and correct ruling. Your Honors, what my clients intend to do will only benefit the public, the citizens of the United States Virgin Islands. Your decision today, Your Honors, can ensure that benefit. On behalf of Attorney Thomas and I, along with the Postal Service, we thank you for your time, Your Honors.
Thank you as well.
All right, Mr. Simpson, you are in a different location, so please unmute yourself and speak so we can make sure your microphone is working.
Testing, testing.
All right, and am I coming through clearly? It's not creating any feedback for you or anything?
No feedback.
All right, then, justices, when you are ready, please let me know.
Okay.
Ready.
Same here.
Okay.
Right. Okay, Mr. Simpson, please say and spell your name, the school you're from, whether you represent appellants or appellees, and the issue you're arguing.
Good evening. I am from the St. Croix Educational Complex High School. My name is Benjamin Simpson. This is spelled BenjaminSimpson.
Who are you representing, Mr. Simpson?
I am representing the appellants along with co-counsel Adriana Aldanza for today's case, of which that is on the matter of whether the Superior Court erred in denying an injunction where the postal plan may have violated the Kennedy Proclamation as well as the Open Shoreline Act.
You may proceed, sir.
May I proceed with my, thank you. And it is because of the facts and the logic that I've brought to you today that I can say with full certainty that the Superior Court abused its discretion by denying the injunction for both of the articles mentioned prior and are guaranteed to be violated by the proposed plan of the United States Postal Service. There will certainly be irreparable harm if this plan is allowed to continue, and money would not work as suitable compensation in regards to damage that will be done to the natural environment and the public. Let me begin by addressing the two articles being violated, starting with Proclamation 3443, established on December 28, 1961, commonly referred to as the Kennedy Proclamation. More specifically, I will be addressing the 76 statute, sections 1441 and 1442, in which Buck Island is established as being a national monument. In stating this,
What
the proclamation
here is why can't the government exercise eminent domain as long as it has a public use? Shouldn't that be our only inquiry, whether or not it's a public use? Because the federal authority of eminent domain clearly takes precedence over a local statute of the Kennedy Proclamation, doesn't it?
Well, the federal, the Eminent Domain Act isn't even relevant here, for the land we're dealing with is not private property. It is federal property. Therefore,
Which land are you referring to? Which land are you referring to?
Buck Island.
You're saying that eminent domain doesn't apply because it's already federal property. It's because it was constituted as a monument pursuant to the Kennedy Proclamation, but there's still a transfer of use and title, isn't there? Under the transfer, didn't the Secretary of the Interior transfer this to the Postal Service for developing a post office?
That would be if it was enacted. However, that was not enacted as of yet.
How was what enacted?
The postal plan, the Postal Service's plan to build the hub on Buck Island.
Well, isn't that the thing which gives them the authority to undertake that plan and build the post office there, to transfer to them?
It is.
Okay. Isn't that then equivalent to, maybe it remains not the right term, but isn't it equivalent to the government's authority to take property or to transfer property? Put it that way, not take, but to transfer property. And it has to have a showing, a justification to effectuate or to legitimize that transfer, doesn't it?
That would be the transfer to become private property. However, it is not that as of yet. It's still currently
For
federal
any
property.
transfer, in order to transfer the Secretary of the Interior to transfer it to the Postal Service, doesn't have to be some showing. You're saying there doesn't have to be any showing at all on the part of the Postal Authority for that transfer to take place.
There has to be showing, and that's the case I'm arguing on behalf of today, not on the case of the transfer.
But what is the showing then that has to be made?
Well, first of all, you have to find out if it abides to all of the articles, that being the Open Shoreline Act and McKinney Proclamation.
But that's my point. Why does the Open Shoreline Act, a Virgin Islands enactment, why does that control the authority of the federal government? Isn't the authority of the federal government paramount?
In most scenarios, yes. But in the Rivera case, more specifically, and how they determined the Rivera case, the case that was determined by the Third Circuit and Water Isle Hotel and Beach Club versus Kon-Tiki St. Thomas Incorporated, they state, quote, no federal considerations existed that were adverse to the exercise of concurrent jurisdiction by the Virgin Islands. Going forward with that, they continued to, Congress granted to the Virgin Islands in the Revised Organic Act of 1954, and by its grant of concurrent jurisdiction, the United States permitted the Virgin Islands to regulate the usage of federal property where the usage was consistent with the federal government's purpose for the property, and the Virgin Islands law did not contravene federal laws that applied to the Virgin Islands, which in Rivera's case, as well as today's case, it was consistent with federal purpose. It did not contravene with federal laws, and the federal considerations, i.e. the Postal Clause, does not stand as a valid adverse argument.
I'm not sure I understand the last thing you said. Can you repeat that for me?
For a more clear explanation, may I reference another quote from that argument?
As long as it answers the question, sure.
Yeah, so it says, quote, these revisions of the Organic Act reveal that Congress intends the territorial legislature to have power to regulate and conduct activity occurring on federal property located in the Virgin Islands to the extent such exercise of authority is not inconsistent with the federal use of this property. Hence, we must inquire whether the application of the Open Shorelines Act to, in that case, Water Island, but in this case, Buck Island, infringes on the United States' current use of this property, which would be listed under Kennedy's Proclamation.
Okay. And help me understand why it's not inconsistent with the Kennedy Proclamation.
Oh, no, it is consistent with the Kennedy Proclamation.
How is it?
Oh, sorry, can you clarify your question, please?
Yeah, you said it is consistent with the Kennedy Proclamation. I'm asking, how is it consistent with the Kennedy Proclamation and the restrictions of the Kennedy Proclamation? The statement you just made was pursuant to the postal plan. I thought you were saying the postal plan is consistent with the Kennedy Proclamation.
All right. My apologies, I misheard that then. No, it is inconsistent, and this is because it violates the ideals and statements made within the Kennedy Proclamation, of which I can read for you now.
I've got it in front of me.
You would like.
I have it in front of me.
So moving on to the Open Shoreline Act, which is discussed in the Virgin Islands Code Title 12, Sections 401 through 403, and established in 2019. It essentially states that no legal entity shall create any obstruction or restraint of any nature whatsoever within the shorelines of the United States Virgin Islands, which would interfere with the right of the public individually and collectively to use and enjoy any shoreline. And as I have talked about, and you may have heard prior, the Postal Service plans to use 80% of Buck Island shorelines, which is clearly in direct violation with that rule stated for obstructing and restricting that percentage of the shoreline, thereby interfering with any individual or collective's ability to use it.
Is it the place where 95% of the recreational activities actually performed remaining intact?
Well, any restriction is a restriction under the law, and that's important to acknowledge. Though it is also a belief that over time this will spread out, and that is just the current percentage, for people generally tend to gravitate towards more area, and we would be restricting this possibility of more area. And there's
Well,
also the consideration.
That can easily be resolved by simply an order that says that the taking is approved, but it is restricted to the current plan. It shall not exceed what the current percentages. That's easy to resolve.
Restate the question. My
Well, it
apologies.
wasn't a question. It was just a response to your statement. You're saying, basically talking about mission creep. You're saying once they get the foot in the door, they're going to expand more. So the fact that now it's limited, to a very small percentage of the recreational land doesn't mean anything because it's going to expand. That's the way people are. I'm saying there's a simple solution to that. We simply word the relief in such a way that it prohibits any expansion of the contemplated use.
Well, that would still be restricting the peoples of the Virgin Islands to use that area then.
But the question I thought you were being asked by Judge Lewis was that the restriction here is a very minimal restriction.
In that regard, yes. However, as I was about to bring up too, there's also the educational aspect of it, which is not mentioned, of how people may explore and acquire knowledge by going there, and that may be in the 5% and highly benefit the Virgin Islands as well as people outside of the Virgin Islands. If that answers the question.
Well, I understand your point, yeah.
Right. So to sum up those points, the plan proposed here is in clear violation of the articles through direct claims as well as the rulings made surrounding them. Furthermore, if we allow for further action with the plan, there will certainly be irreparable damage in the form of construction and hazardous material. The plan proposed is also defined.
Where's this coming from? Hazardous material, where's that coming from?
Hazardous material, meaning that creating this postal hub will also result in ferries and boats and such coming towards the island and therefore creating hazardous waste that will damage the environment over time.
But the boats are already coming, aren't they? That's part of the attraction of the island. You can't have it both ways. You can't say that people are using the island for recreational purposes. There's the Sunday Fun Day. That's both people not swimming there from St. Croix. So can you have it both ways? Can you say, well, it's a tourist attraction, people are coming to learn, but if we facilitate people coming there, it's going to mean more marine traffic?
In theory, yes, but it is under my belief that the moving and acquiring of mail will require more types of crafts moving back and forth, including planes, boats, as I said. Though even if that is not true, there is still the irreparable damage in the form of the construction that cannot be backed up on. The plan proposed is also defined of the public's interest in regards to the education, economical, and recreational values it provides, i.e. The income through tourism, i.e. the education I mentioned, and the recreational value that was also mentioned. Seeing that my time is up, may I proceed to my closing?
You may proceed.
Thank you. So, in closing, Your Honors, this plan is in clear violation of these articles and quite frankly can be considered insulting to the island as well as the people who have lived near for years now. Therefore, the appellants respectfully pray that this court reverse the decision of the lower court in order that the injunction be issued immediately. Thank you for the opportunity to appear before the court today.
Thank you as well.
And Mr. Simpson, you can stay on. You're not competing anymore, so you can continue watching. Ms. Aldonza.
Good afternoon.
Afternoon. Are you getting any feedback when I speak?
Any feedback?
All right. You're coming through well, so I think we're good. Justices, please let me know when you're ready.
I'm ready.
Ready.
Ready as well.
All right, Ms. Aldonza, please state and spell your name, the school you're from, whether you represent appellants or appellees, and the issue you're arguing.
Good afternoon. My name is Eldrina Aldonza, spelled L''Drina, and my last name is ALDONZA. I'm from the St. Croix Educational Complex, and I represent the appellants on the case of Little and Great St. James.
You may proceed.
May it please the court, my name is Audrina Aldonza, and I represent Appellant Team 2. Your Honors, the Superior Court erred when it found that the taking of Little St. James and Great St. James were for public use. Firstly, the taking of Little and Great St. James was unnecessary and does not serve a public use. Secondly, because Great St. James is being used solely for the purpose of economic benefit, the taking of this island is not public use. With respect to my first point, within the plan,
Why is it only, let me take you to your second first. Why is this only an economic benefit if in fact it is assisting members of the population here in the Virgin Islands to get mail more timely and delivered more efficiently?
well, within the fact pattern, it's stated that only Little St. James will actually be dealing with postal work, with Great St. James being where the resort is located. And with the resort, the only thing the resort is doing right now is providing jobs, which is an economic benefit, and it's providing funds to maintain and deal with the construction of the postal office, which is economic benefit. So the only thing that Little St. James could offer is economic benefit.
So the fact that these monies are sort of entangled with the entirety of the project, that is the ability of the Postal Service to construct this facility, is it still considered solely an economic benefit under those circumstances?
Had this money, well, with the beginning of this money is being for the construction, so the whole of the fund may be for the post office. But as time goes on, and that fund money being only used to maintain the upkeep of the post office, had they said in the fact pattern that that money would go towards charities in the Virgin Islands or schools there, then it would be more than economic benefit. But with the only thing that it can provide is funds to build it and maintain the upkeep, it's purely economic benefit.
What about employment, jobs?
Jobs is considered economic benefit because it deals with the taking and handling of money.
Isn't it sufficient here, though? Because it's connected to a postal service, which means delivery of mail and the kinds of things that you just asked about. So it's not just money, but in addition to facilitating delivery of medicine, people are becoming employed.
Well, I would disagree, Your Honor. In the court of Hakka v. Wayne, where there was a...
What part are you disagreeing with? Are you saying that in addition to being delivered, people will be employed?
I'm disagreeing with the employment being more than economic prospects.
Well, I coupled it with medicine. I coupled it with the delivery of medicine.
Well, the delivery of medicine would happen with or without this postal service. This postal service is not ensuring the arrival of this mail, but ensuring the fact that it may arrive faster.
Well, if you're waiting on your medicine, that's huge. If I'm waiting on my blood pressure medicine to come, and it comes a week after I need it, that's called a stroke. I mean, that's important.
Well, to take this into consideration, these postal facilities are trying to ensure the arrival of these things. It's not ensuring the arrival, it's ensuring that it would arrive faster. However, if you take into account that when these mails come in, they have to go to Little St. James and then to Great St. James to be sorted and then arrive to the island of Great and Little St. Buck Island and the rest, you have to take into account that now you're extending the time that you needed this medication. So, for instance,
it's still faster. It doesn't matter. It's still faster. It will still get them more reliably and faster than if they did not engage in this project.
Well, when you're extending the time you're taking to get here because you're increasing the amount of places it has to go to get sorted. And when you add in another sorting facility, you're adding a risk that your mail could be lost. Because there's no guarantee that when your mail arrives at this sorting facility that it gets lost, it gets misplaced, it gets sent to another island. Those are
You're saying that what we have been given is not the case, that this facility would increase the delivery, the reliability and the speed of mail delivery. You're saying that's not true?
Well, the reliability of mail is always something that we cannot directly count on because of the many factors. We can't account on the fact that if a power outage happened, that the mail wouldn't be delayed. We couldn't account that with the.
But can we count on that mail will be delivered more expeditiously and more reliably with this facility than without it? Now, maybe it won't be perfect. It's not to say that a package will be lost now and then. It is to say, I thought, and I thought this was not contested, that in terms of mail delivery, the speed of it and the reliability of it is better with this facility than without it.
No, because
That's not true?
no, I would disagree because before this postal facility was acquired, what would happen is the mail would come to Puerto Rico and then it would go to a port on St. Thomas where the mail would be sorted there between St. Thomas and St. John. And the issue there was that the ports would be taking up a lot of time and it would just take up much time. But with the new plan to take it to Great St. James and build a pier between Great and Little St. James to transfer the mail to Little St. James, where they would then sort the mail, and then from the sorted mail on Little St. James, they would take a boat ride to either St. John or St. Thomas. And with all of that moving back and forth from one place to another, not including the sorting and the time it takes the helicopters to get to Little St. James and the boats to go to wherever it needs to get to, you're adding more time.
You know, I'm reading from the facts. Recently, the Postal Service has been facing severe financial staffing and operational challenges, which has resulted in delayed delivery of mail, specifically package delivery, throughout the entire United States, including the Virgin Islands. These delays have prevented essential medicine from reaching citizens in a timely manner. You're saying that this will not be improved. It was determined, the postmaster for the Virgin Islands has determined that it was necessary to exercise the Postal Service's power of eminent domain and condemn certain outlying islands to construct postal hubs and the amenities thereto to establish a system of mail distribution, etc. I don't want to take off your time reading this, but you're saying that that's not the case.
I'm saying that we're adding time onto this. Now, there could be a faster way had we use helicopters both way and increasing the time, but when we're adding more locations and more steps to the problem, we're only adding additional time. Now, on some days, it may be true that it would increase the time as they spend less time at the port, spend time struggling to sort the mail between the two islands on one little pier. It may be true that that would happen, and it may be true that the medication would reach its citizens faster. But it's also true that when you add more things into the equations, things are more likely to go wrong. Things are more likely to take time.
Okay.
With respect to my first point, within the plans of Little and Great St. James, only Little St. James is being used for postal work, with the average size of a postal facility being comparable to a large grocery store. The island of Little St. James should suffice. Additionally, the creation of this facility for sorting is unnecessary. Building a facility might decrease the traffic. The actual time it takes islanders to receive packages is longer. The Court of Hackett v. Wayne held that the taking of private land must serve a public necessity. If there is no such necessity, any taking constitutes as fraud, error of law, or abuse of discretion. It is found in that case because the plaintiff failed to establish the taking as a public necessity. It was abuse of discretion. The taking of these islands does not serve a public necessity. If the issue that led to the creation of the postal facilities was that the ports would become overfilled, then this issue would happen once more when the boats came from Little St. James with sorted mail. The taking of these islands make no sense, and instead seems like a scheme to make money off the resorts on Great St. James, that will be mentioned in my second claim. These postal facilities should not be built, and the island should be left in the hands of its owners. The facilities cause more problems than they solve, and the resort discussed in my second claim will profit only the elite Virgin Islanders, a percentage of people that make up less than 1/3 of the entire population.
So is it the case that the essence of your argument is that this facility may not expedite the delivery of mail, and it is not needed, therefore an injunction should have been issued?
Yes, it's my case that these postal facilities issue that the Virgin Island does need help in its mail, but to use governmental actions to take the Little and Great St. James is not necessary. It would be much more efficient to do it somewhere else than Little and Great St. James. And to take these islands instead seems like a red herring to get money.
where's the necessity coming from? I'm reading from Kylo. This court's authority, however, extends only to determining whether the city's proposed condemnations are for a public use within the meaning of the Fifth Amendment to the Federal Constitution. The court did not look into whether it was necessary, and I don't know how any court could ever make such a determination. The determination is whether or not it's a public use, not whether or not it's necessary. It's not a First Amendment kind of necessary showing, is it?
Well,
necessary from? Where's that coming from? Is there a case or statute that I'm missing where the court focuses on necessity as opposed to public use?
My public necessity came from the case of Wayne versus Hatchcock. However, in the terms of public use, these islands are very little public use because, as I said before, the mail was getting to these people with or without these facilities. So
okay, but now you're talking necessity again, and I'm not sure necessity is part of the inquiry. That was my concern.
Okay, well, my definition of public use comes from the court of Wayne versus Hatchcock, in which it states that.
What is the citation for that? Do you have that handy?
The citation, yes, I do. It comes from the Michigan Constitution, Article 10, Section 2, where it states that any public corporation or.
So why would we be at all concerned with the provision of the Michigan Constitution?
Your Honor, it appears that my time has expired. May I answer your question?
Yes, I'm not sure why Michigan's Constitution is of any concern to us.
Well, since I was using the court of Wayne versus Hatchcock, mainly because of the many similarities in their case to ours, their definition of public use in that case came from the Michigan Supreme Court. Your Honor, it appears my time has expired. May I proceed to my closing?
You may proceed.
Despite claims from the Postal Office, because there is no clear public use, the plaintiff requests that the court finds the taking of Great and Little St. James a violation of the Fifth Amendment.
Okay, just a reminder to those who just argued, since there's no other people competing, you're entitled to watch this last round of arguments. And our last round is St. Thomas Seventh-day Adventist School appellees. Ariel Joseph, I believe you are up first on that team.
One second, we're coming.
Good afternoon. Can you hear me? Can you hear me well?
Yes, are you getting any feedback over there when I speak?
No, sir.
With that, I believe the judges are ready. So if you could say and spell your name, your school, whether you represent appellants or appellees in the issue you're arguing.
Yes, sir. My name is Ariel Joshua. I'm representing the St. Thomas St. John Seventh-day Adventist School. I am the appellee, and the issue that I am arguing about is the building of the postal hub on Buck Island.
You may proceed.
Good day, Moot Chief Justice Cabret and Associate Justices Lewis and McKee. May it please the court.
My name is Ariel Joshua, and I, along with my co-counsel, Dekai Blake, represent the appellee, the United States Postal Service. Your Honors, with the vast territory that belongs to the United States Virgin Islands, I believe that it would be in our best interest to rid ourselves of our primordial ways and use a morsel of our land to build something grand for the betterment of the people.
Hold on. Your primordial ways. Are you saying we've got to get past all this nature stuff and move into the 21st century? These turtles are standing in the way of progress. Is that what you're saying?
Yes, Your Honor. I refer to our ways as primordial because we have this opportunity to go forth and create a way that mail can come into our land more speedily and more efficiently.
So should we just disregard the law in order to allow this progress to take place?
No, Your Honor, we will not be disregarding the law because we will not be in violation of any proclamations or statutes.
What about the Kennedy Proclamation?
Can you repeat?
Yes, what about the Kennedy Proclamation? I mean, that's one of those things standing in the way of your moving into the 21st century. That proclamation, issued as it was in 1961, is tying you to your primordial ways. Isn't it? It's saying that you can't limit or restrict fishing or do anything to reduce fishing or the recreational privileges of the inhabitants of the Virgin Islands. This thing is tying you to your primordial ways. Do you understand the question?
Your Honor, no, the Kennedy Proclamation is not tying us to our primordial ways. We can go forth with our plans without violating the Kennedy Proclamation. We don't violate the Kennedy Proclamation because it states that no one is to hinder the existing and bathing recreational activities on Buck Island. The Postal Service's plans to seek to accommodate and enhance the recreational activities rather than to hinder. Turtle Beach will still be accessible to the public for bathing. And additionally, the Postal Service plans to have a ferry to transport hundreds of passengers to Buck Island on a daily basis.
Well, that's going to do wonders for the turtles there, isn't it? There's all those ferries going back and forth every 20 minutes. That's going to really help the turtles grow and develop, isn't it? It's going to really help the natural resources that the Kennedy Proclamation was concerned about, having all this marine traffic going back and forth.
Your Honor, in regards to marine traffic, there is already a lot of marine traffic going back and forth between St. Croix and Buck Island. People get to Buck Island through the means of boat, Your Honor.
Is it as much traffic as every 20 minutes?
It may not be, Your Honor, but the wildlife surrounding Buck Island, Your Honor, I believe will be used to the ferry and boat traffic going around the island, Your Honor.
They'll accommodate themselves.
Can you repeat?
At least the ones that can get out of the way of the damn boats will accommodate themselves. The others will just get swept up into the blades. Are you arguing that the nature finds a way that the turtles and everything will accommodate itself to this intrusion into the habitat?
Your Honors, like I said, Your Honors, the boats, the wildlife around Buck Island I believe is used to the boat traffic around Buck Island, Your Honors. And in the end, the reason for us building this post office on Buck Island is for the betterment of the people, Your Honor.
Is that the test, the betterment of the people? Is that the test of public use?
Can you repeat the question?
Yes, is that the test that we have to look at? Whether or not it's a benefit to the people, is that what we have to focus on? Or do we have to focus on the restrictions on the use of the land and whether or not the government has the authority to do what it's trying to do here, given those restrictions? I may not have been very clear, but go ahead. Go ahead with your argument.
Your Honors, I ask that the court affirm the Superior Court's ruling in denying the appellant's motion for an injunction regarding the building of the postal hub on Buck Island for three main reasons. Firstly, the Postal Service had authority under the United States Constitution and the Postal Powers Clause to build the Buck Island Post Office. Secondly, Your Honor, the Postal Service has the right to do what is necessary and proper for the betterment of the people. And lastly, Your Honor, in doing what is necessary and proper, neither the Kennedy Proclamation nor the VI Open Shorelines Act would be violated.
Why? That's what we're trying to get at. Why not?
Your Honors, the Kennedy Proclamation will not be violated because the Kennedy Proclamation states that no one is to hinder the existing bathing and recreational activities on Buck Island. We plan to enhance the recreational activities rather than to hinder. We plan to install a 360-degree observatory that will be built on top of the post office to give unobstructed views to St. Croix and even on clear days, Puerto Rico, Vieques, and Culebra.
But you
Aren't you going to clear?
Go ahead.
Go ahead. Aren't you going to be?
Well, you yourself stressed the existing natural resources, and now you're talking about how this observatory is going to advance the purposes of the Kennedy Proclamation, but it's not going to enhance swimming and boating and fishing. Is that? And I think let me defer to Judge Lewis. Answer that question, and then I'll be quiet because I want to hear Judge Lewis's question.
Your Honor, we will not be hindering the existing bathing and recreational activities. Turtle Beach will still be accessible to the public for bathing, and we will not be hindering it or touching it in our construction plans for the postal hub, Your Honor.
In the 80% of the land that you will be clearing, is it the Postal Service's position that there is no recreational activities that go on over those lands?
Your Honor, it is unknown the specifics of the recreational activities that took place on any other area rather than Turtle Beach. Turtle Beach contained 95% of all recreational activity that takes place on Buck Island, Your Honor. But in the end, the building of this postal hub is for the betterment of the people.
I'm not sure what that means or how that helps us, actually.
Firstly, Your Honor, the United States Postal Service has the power and authority to construct the postal hub on Buck Island. Article 1, Section 8, and Clause 7 of the United States Constitution states that Congress shall have the power to establish post offices. These powers are further
Mr. Joshua, no one doubts that the post office in the United States has the authority to do this. The problem is whether or not that authority has been limited by certain restrictions placed upon the land where they're trying to exercise the authority. You're not saying the authority is absolute, and you can exercise it no matter what restrictions might be impressed upon it, are you? Is it an absolute total authority? You can go in and take any property you want to?
Your Honor, in accordance to the general powers of the Postal Service...
Well, you can answer that one yes or no, then explain it, but that's a yes or no. Are you saying that the power to take is absolute?
Yes, Your Honor.
Okay, go ahead and explain.
The general powers of the Postal Service, on Section 5, it states that the Postal Service has the power to acquire in any lawful manner...
Oh, lawful manner, lawful. Whoa, that's a big word. In a lawful manner. Well, given the restrictions in the Kennedy Proclamation and the Open Shores Act, why is this acquisition in a lawful manner?
Your Honor, it is a lawful manner because it is being done for the betterment of the people, Your Honor.
But isn't it for example, doesn't the post office plan to build two piers? One would be a deep sea pier, which would significantly affect the natural habitat, the water habitat. The other one would be a smaller pier. Together, don't those two piers, won't they affect 2/3 of the Buck Island shoreline?
Your Honor, it is not our belief that the building of these piers will affect the coral or the wildlife around Buck Island. But even if there is such minute destruction or deface of the coral reef, the point of the postal hub is for the betterment of the people, and that trumps all, Your Honor.
You're saying that 2/3 of the Buck Island shoreline is a minute amount?
Your Honors, we do not believe that building the pier will obstruct or deface the coral reef in any way. But if there is such minute or small deface of the coral reef or the wildlife around Buck Island, the use of the postal hub is for the betterment of the people, and that trumps all, Your Honor.
The betterment of the people trumps all?
Yes, it is being done because it is necessary and proper in accordance to the Constitution, Article 1, Section 8, and Clause 18.
Regardless of any adverse effect or impact on the surroundings, as long as there's a conclusion that it is for the quote-unquote betterment of the people, then it doesn't matter what the impact is. Is that the argument?
Yes, Your Honor. The postal hub...
And here the betterment of the people is that you're getting rid of all these primordial restrictions. Is that right?
I see that my time has elapsed. May I please answer your question and briefly conclude?
Yes.
May you please repeat the question?
Yes, you say betterment to the people, and in the context of your argument, I interpret that to mean it's for the betterment of the people because it's getting rid of all these primordial restrictions that are preventing the development of the people of the Virgin Islands. Is that what you're arguing?
I don't quite understand the question, Your Honor.
Let me just try one more time because we're over time now. You started out by saying that what you were trying to do was to, what the result of it would be to get rid of all these primordial, I think was the word you used, restrictions that have been holding the people of the Virgin Islands back. So I assume what you're saying is that this is for the betterment of the people. That's clear, you're saying. And it's for the betterment of the people because you're getting rid of all these restrictions that have been holding back the development of the Virgin Islands. That's why it's for the betterment of the people. Therefore it's legal. That's what you're saying.
Your Honors, we are not getting rid of the restrictions. We are just not in violation of them, meaning that we can still go forth with our plans while not violating the restrictions and rules in place setting up to protect the Buck Island waters and island. Your Honors, the residents of the Virgin Islands have struggled for long enough with the inconvenience of frequently delayed mail. I ask that the court affirm the ruling of the Superior Court and allow the Virgin Islanders to live better and more comfortable lives. Thank you for your time, and unless there are any further questions, I will yield to my co-counsel, Dekai Blake.
Thank you.
All right. Mr. Blake, can we get you up here, please?
Good afternoon. My name is Dekai Blake, D'(K)A)I(B)L(A)K)E. Do I need to repeat that or? Should I repeat your
What was your question?
Oh, I was asking if you needed me to repeat my name. That's why. It seemed that
No, we got your name. We got your name. Who are you representing?
I am representing the appellee in the issue of Great and Little St. James.
All right, are you ready to proceed?
Yes, Your Honor, I am.
Then you may proceed.
Thank you. Good day, Moot Chief Justice Cabret and Associate Justices Lewis and McKean. May it please the court. My name is Ikai Blake, and I, along with my co-counsel Ariel Joshua, represent the appellee, the United States Postal Service. Honorable Justices, the people of the Virgin Islands are living in a primitive generation of technology, transportation, and idealism. It is time that we start making plans to move forward. Our community...
Help me understand where you're going with this. You're saying we've got to get rid of all this idealism that the people of the Virgin Islands have been burdened with? Is that what you're saying? This natural stuff, what is all this natural resources and all this stuff? We got to move past that now. It's kind of what your colleague was arguing. Is that right?
Yes, Your Honor, you are indeed right. It is time that we start moving forward and go along with the advancements of the world.
Should we just kind of trample over the laws to get there? I mean, the laws, should we just trample over the laws to get there? There's some of these laws that are really interfering with achieving progress, moving into the modern day world. This Kennedy Proclamation, we're still living by that 1961 now. It's 80 years old. The Open Shores Act, this archaic act is trying to preserve all these animals that are probably relics of some kind of prior crustacean age. Is that what you're saying? You're asking the court to remove the shackles of idealism so that you can advance and move into the modern ages. And let us build, that's it, right? And let us build these two mansions. Let us put the postal hub in there. Let's create this private residence for the postmaster to live in and have some jet skiing and all this other 21st century kind of stuff. Sea turtles be damned. Who needs sea turtles anyhow? When you got a good jet ski going for you, who needs a sea turtle?
Well, Your Honor, the issues that you have brought up are regarding to Buck Island, and I would love to answer your question, but I am dealing with the issue of Great and Little St. James.
Forget the sea turtle, but the principle is the same, isn't it? You're just basically saying, let's open this up to some elite tourists, create a really plush base for the postmaster to live, and we're going to use governmental authority to do that.
We have the governmental authority from Title 39, United States Code Annotated, Section 401, the general powers of the Postal Service. And as it says, the Postal Service has the power to take property as it deems necessary or convenient in the transaction of its business. And
so as long as the Postal Service has the power to do it, that means it's okay. They have the power, end of discussion, move forward. Is that your argument?
No, Your Honor. We're saying that the postal hub is for the benefit of the people. And even though we may be taking land from one party, it is overall benefits in the Virgin Islands from the 75% increase in mail, increased jobs, and increased tourism. And may I not add, the postal hub selling Little St. James to Great St. James, the Royal Mill Inn, will bring almost close to $1 million to the government.
So economic benefit in and of itself is enough. That's all we have to look at, is the economic benefit.
Yes, Your Honor, and it does constitute as public use, as stated in Kilo.
Well, I'm not sure Kilo is a big help to you here. Help me understand why Kilo advances your argument. Because there you're talking about development of a shopping center pursuant to a municipal development plan. And that plan was being advanced by the development. But it seemed to me that whatever plan we might have in place here would argue against the development, because in order for you to achieve this development, you have to get us to allow you to ignore the restrictions on the use of your power.
Well, Your Honor, when we bring up Kilo, we want to look at the use of public use, whereas Kilo embraced the broader and more natural interpretation of public use as public purpose. And the court has consistently and repeatedly rejected the narrow view the appellants are proposing. The court has...
Why is Kilo's interpretation the more natural interpretation. That is to say that public use means public purpose as opposed to use.
Because
Why is that more natural? Why is that interpretation more natural?
it is more natural, Your Honor, because the definition in Kilo is in effect with the evolving needs of society. And I would like the court to note something said in the Pensacola Telegraph Company case that states the powers granted by the Constitution are not confined to the instrumentalities of commerce or the Postal Service or in use when the Constitution was adopted, but they keep in pace with the progress of the country and adapt themselves to the new developments of time and circumstances.
I don't know how that helps you, because still what we have here is the government is using its authority to promote the interests of the populace for the first round. They're not going to be able to afford this mansion, who are not going to be interested, might be interested in it, won't be able to go using the jet skis and that kind of thing. I don't know how that is consistent with the benefit to the people.
Well, Your Honor, the premises are accessible to everyone. It is nothing strange to charge a rate based on the value of services provided. This is already the norm for many accommodations we have within the islands. The important thing is that the money will be going to fund the postal hub for the people and the government overall. And if I may add...
But there are certain laws that the territory has put in place. And in this plan, there is a security zone that would be implemented that would extend 900 yards from the low tide point on the shores of the island. No boats or other watercraft would be allowed to access the waters. Additionally, a part of the beach would be for the exclusive use of the guest of a private entity. How can that benefit the people of the Virgin Islands when they have less access to the natural resources of the Virgin Islands? And the person that is going to be benefiting is a private person. You're taking private property from a private landowner. And isn't the ownership of property a fundamental right?
It is a fundamental...
Right? So, but you're saying it's okay to take away this fundamental right as long as there's an economic benefit.
Yes, Your Honor. As long as there is an economic benefit, the Postal Service has the power to acquire this land.
I'm not questioning the power of the Postal Service, the eminent domain power of the Postal Service. I'm questioning how it's going about doing what it's doing. And there are certain laws within its plan that clearly contravene the Open Shores Shoreline Act. You don't see any problem with that as long as there's quote unquote progress?
Thank you, Your Honor, but thankfully we do not violate the Open Shorelines Act. That act states that nothing should be erected which interfere with the right of the public to enjoy the shoreline. While there may be no direct access to the shoreline by boat, there will be unfettered access to the shoreline by land. In the case
what about the private beaches?
The private beaches on Great St. James, Your Honor?
Yes, the private beaches in this estate that's going to be developed.
Your Honor, as I stated before, the people will have access to the boat by land, by the beaches by land. We are not restricting anyone from using the accommodation Great St. James has.
It's an island. It's an island. So how are the people going to get to the land, to the island?
Your Honor, the security zone only takes up a small portion. The inhabitants, whoever wants to go to Great St. James, can access it by another part of Great St. James. Even so, as I stated before, they may access it by land. It is not the Postal Service's job to know how they end up on the land, as long as they do not enter by boat.
So in other words, where it says here in this fact pattern, exclusive access to the southern 1/3 of the beach on the west side of the island, the southern 1/3 of the Christmas Cove beach, it does not mean that others won't have access, that there will be some other access for other people who aren't part of, or, in this mansion?
Yes, Your Honor. As long as they access it by land and not by boat, we have no problem with people using the accommodations Great St. James has. I stand before you today and ask that the court affirm the ruling of the Superior Court, denying the appellant's motion for the building of the postal hub on Great and Little St. James because the Superior Court correctly found that 1, the Postal Service has the power to take property for public use. 2, public use is interpreted broadly so that the government can do what is necessary for the benefit of the people. And 3, the Postal Service has not acted to deprive any property, therefore injunctive relief is not necessary. Firstly, the Postal Service has the powers to take and use property for public use. Your Honors, under the general powers of the Postal Service,
I'm still not sure where this public use is coming from when you're basically promoting a private estate.
Thank you for that
mansion in this hotel and the private beaches. I'm not sure where the public use is coming from.
Thank you for that question, Your Honor. It is constituted as public use because in order to finance this project on Little St. James, because the Postal Service has been facing financial, staffing, and operational challenges ever since Hurricanes Irma and Maria, we have to sell Great St. James to Royal Mill Inn in order to build this hub on Little St. James, making the use of Great St. James public use.
Why, given the fact that we have these countervailing factors, the natural resources, the Open Shoreline Act and the like, why shouldn't we adopt a narrower interpretation of public use?
Thank you for that question. We should adopt this narrow interpretation because it benefits the Postal Service and the people of the Virgin Islands. Your Honors, this plan will essentially increase mail delivery by 75%, bring close to $1 million to the government. There will be new jobs to people who do not have any. There will be increased tourism and facilities to withstand storms, making the depression after hurricanes Irma and Maria avoidable. The people outside, I see that my time has expired, Your Honors. May I briefly conclude?
Yes, you may.
In conclusion, I must express that I, along with many of the attorneys here today, are local Virgin Islanders, and we would not want our parents' and ancestors' property to be taken on mere pretext. However, in this case, the Postal Service's plans is for the benefit of the entire community and not just the interest of 1 or 2 persons in bringing. The court should affirm the ruling of the Superior Court. Thank you, honorable judges, for your time.
All right, outstanding, everyone. Everyone can log on now. You can have people, if anyone had logged out, I'm sure there are people watching the live stream, but if they'd like to be online right now to participate in this last little bit, in particular with the issuing of the award, your scores, please get emailed here, or you complete your scores, please email all of them so we can do that. But again, I stand by shop local, but I do want to reiterate for those who may have missed it that if you purchase with this website, smile.amazon.com, and you identify the Virgin Islands Bar Foundation is your nonprofit, that money will directly benefit the Amazon donates 0.5% of the value of your purchase, and that money will directly benefit the moot court competition. Had the people of the Virgin Islands used Amazon Smile after Hurricanes Irma and Maria, we would still be funding scholarships just from the money that was spent during that time. But I do stand by my shop local. We use VIP awards. They are located in the VI. They offer great awards, and we absolutely use them, even though we could use other services that provide slightly less expensive stuff. With that said, I just have to say, wow, this was. I mean, the judges were relentless. I could not have withstood what they put you through when I was in high school. I would have broken down. It was really just a stunning show on the part of the students. And it is clear that you took the 36 hours between Tuesday and this morning to really put in some work, because it was like a whole new group of students, and you all didn't do badly on Tuesday. So I am really, really impressed with that. And this was a tough question for experienced lawyers. So you should really be proud of yourselves on that. And I hope what you saw is that from the questioning of this judges, because this was really, if I ever teach oral advocacy, I will be accessing the archive of this as an example of judges having a conversation among themselves in order to decide, because in the law, we're arguing for a binary outcome, yes or no, right or wrong, affirm or reverse. But life in the law is nothing but gray area. And oral arguments' main purpose is to assist the judges in narrowing the gray area until it balances to a binary outcome. And I have never seen such a wonderful example of judges demonstrating that, and demonstrating it repeatedly with each round of arguments. And so it really was just a remarkable example that every student should have learned from, especially those who are interested in going into law. And with that, before I turn it over to my co-chair for his comments, and then we hear from the judges, I would just say this, that in life, it is possible to do every single thing right. You can do your best. You could have worked your hardest. You could have practiced every spare moment you had. You could have read every letter and character in the law libraries we provided. And you can still fail. That's just life. Sometimes people are just better. So when these announcements come out as to how people were rated, please just remember that everyone should be proud, and you could have been the best you've ever seen. And coming into this competition, someone could have just been better, even though you did nothing wrong. And so don't get disheartened if you didn't place where you wanted to or anything like that, because in seeing this, there isn't a single person who shouldn't be utterly proud of themselves. With that, I turn it over to Rob for his comments.
Yeah, I definitely echo what Adam said. This was impressive. I just hope everybody comes away thinking about the positive, especially when you're before the judges. I know you probably thought that they were attacking you, or they, disagreed. I mean, they may have disagreed with your position, but it was there to help you think about the problem and think clearly. And I think that overall, what I took away from the answers and the questions, what they were trying to do is force you guys to think about the problem and your answers from a logical, clear perspective. And you guys handled it very well, but they were there to try to. It should not be taken as a personal affront or anything. I hope you're encouraged by it and enjoyed it as well. It was definitely an interesting problem.
All right. With that, I would ask Judge Lewis, do you have some general feedback and comments for the students after today?
Yes, thank you. Thank you, Attorney Thorpe. You know, every year that I have the opportunity to participate, I realize yet again why this is one of my favorite activities. And it is because of the incredible talent, you know, the diamonds in the rough that you can see from our high school students. This is not an easy thing to do. The problem was not easy, and to stand in front of, you know, 3 judges and get peppered with questions and have to, you know, keep on the right track and go back to your arguments and come back for questions, and we were interrupting you all the time, but we were doing it, and I hope you realize how well you did, how well each of you did. You know, whenever I do an introduction for this program, I talk about the fact that everybody, as Justice Hodge said this morning, you're all winners. You know, they're gonna, you know, list the folks who and the order in which folks came in, but everybody should walk out thinking, hopefully it was a great opportunity to take advantage of you know, getting up there and making your arguments and doing your presentations, and you did well. You did very, very well. I am really proud of all of you. This is the kind of thing where you get a taste of it, and, you know, all of us have been there where we did our first one, and then, you know, over the course of time, we had more and more experience, and hopefully we improved. But I've got to say, each time I do this, I'm just incredibly impressed by the talent that is displayed, and today was clearly no exception. So thank you for your hard work. Thank you for your dedication. Thank you for your motivation. Thanks to the coaches as well, and the teachers and the parents and all of those who support, of course, our 2 co-chairs, Attorneys Kaczynski and Thorpe, who always do a wonderful job of pulling this all together. It really is a great day. It was a long day, but I hope that you all enjoyed it as much as I did, both you know, hearing you and listening to you and just thinking about how very, very well you did. So congratulations to you all, and I thank you, Council, for the opportunity to participate again this year.
Oh, thank you. We were thrilled to have you. Just wonderful remarks there. Judge McKee, do you have any feedback for the students?
Just briefly, in a comment, I meant to, my first comment, I should have said this morning while the Chief Justice Hodge was on the line. I'm not sure the students appreciate the legal tradition that they're a part of here in the Virgin Islands. I've said this before in public many times. The Virgin Islands Supreme Court is a remarkable institution. It is a court that was fashioned out of whole cloth by Chief Justice Hodge, by Justice Cabret, by Justice Swan, starting from not even having a building. When the Virgin Islands Supreme Court was first created, and I remember when I first came down here and I looked at the facilities of the Virgin Islands Supreme Court, and my only thought was, how in the hell can we get enough money to steal some of these folks away and get them back to Philadelphia? Because your facilities, your IT facilities were better than ours in Philadelphia. And I mentioned before the tremendous respect I have with the Justice Cabret, how she got an issue right years before the Third Circuit got it right while we were getting it wrong. Judge Lewis, a tremendous leader of the Virgin Islands judicial system. We heard earlier from Representative Plaskett. There's just a wonderful, strong, vibrant legal tradition here. I would just not take issue with, but put a different spin on something that Attorney Thorpe said. I agree that you can work as hard as you can and not win. I don't equate not winning in this competition with failing. I think that what you got from this, the educational experience, the being able to respond on your feet to questions that we asked of you, even if you did not win, you did not fail. It was like Edison's response when he was asked about the light bulb, and he said he went through 1,000 filaments for his light bulb before he stumbled on tungsten. All the other ones would burn before they emitted light. And he was asked, well, weren't you frustrated by all those failures? And he said, none of those experiments were failures. From each experiment, I learned something. I learned that that filament didn't work. And I kept learning and learning and learning until I stumbled upon tungsten. And so this has been a learning experience for each of you. One other thing I would just caution, in a legal argument, you have to be aware of the fact that there are rules and there's a body of law, and you have to make your arguments fit with and respond to that body of law. So what might make common sense in an argument over cocktails, I guess you're too young for cocktails, but over a hamburger or whatever, because it just feels right, doesn't necessarily mean it's going to be very persuasive in a legal argument. You've got to pin it to a case, to a statute, to something, some kind of authority. It can't just be your individual sense of justice, your individual sense of what's right. If you can tie your individual sense of justice to an opinion from the Supreme Court, either the Virgin Islands or the U.S. Supreme Court, that's fine. But you've got to argue it in terms of the court's opinion and that legal precedent, not based upon what you think is the proper outcome. But I want to congratulate everybody. This was a notoriously difficult question, as I said at the very beginning, very, very subtle. And it's not one that I would have ever voiced on high school students, which is not to say that the attorneys who developed this were wrong. They appreciate your intellect probably more than I would. I wouldn't think this would be something high school students would handle, but you handled it. And there were a couple of people who argued this case that were on a par with any law school argument that I've ever presided over. Even I would go so far to say on a par with some attorneys who have argued before me in court. Not everybody, but there were a couple of people, and the way they could respond to questions and formulate their legal arguments that were on a par with members of the bar who would come into the Third Circuit and argue it, and we're right below the U.S. Supreme Court. So that's not a small stage. That's a big stage to argue on.
All right. Thank you, Judge McKee. And yeah, absolutely. I like your revision of what I said. That's a much, it's a better approach to life. And with that, Justice Cabret, do you have some feedback and comments for them?
I do. I want to thank everybody for participating. And I want to thank my fellow Moot justices. Adam, is this the first time that we have a judge from the Third Circuit participating?
Yes, it took 3 years of effort to get through and get in contact with what it's like trying to get into Fort Knox with just your high school badge. It took so much effort to actually speak to a judge, but once I did, Judge McKee, I mean, it took him, I think, less than 30 seconds to come up with a response and agree to be a part of this.
Well, thank you, Judge McKee. I think that the students really enjoyed your questioning, and I know that, well, we all did. And the students, I think, should really congratulate themselves. My heart is warm. It becomes, I am touched every time that I take part in moot court. I am touched, and my spirit is buoyed. It's lifted. We have so many diamonds in the rough. Judge Lewis is so correct. We are a community of people who work hard and we persevere. And you showed you showed that today. We can tell that you prepared, you persevered, and some of you are more adept than others at answering the questions. But I hope that some of you decide to go to law school, and remember that it's hard work and perseverance will get you in and out of law school, will get you to pass bar examinations, and you can become a lawyer and represent other people and defend other people, defend their property rights, their private property rights, It's a profession that is too often criticized, but I think it's definitely one of the most honorable professions. And if you really like it, it is going to keep you busy and going. Look at Judge McGee. I mean, he was so into the questioning, so energized. No lunch, and here we are. You know, so I just truly hope that you took away some kernels of wisdom today, and that you understand that your participation, like Chief Justice Hodge said this morning, just your participation makes you a winner. And all of you are winners, so I congratulate each and every one of you, your parents, co-chairs.
Thank you, Justice Cabret. I'm about to send you a private message. We have a tie, and we rely on the Chief Justice to break the tie between any individual or team. So look for that. And with that, Rob and I only need about...
May I ask a question? How do I break the tie? Do I score again or what?
You would review your score. This is what we developed last year, is Ernest reviewed his score sheet, and he looked at the overall evaluation, and he looked at who had the strongest performance based on whatever factors he chose relevant. I think he thought that the technical aspects were more, so he looked more to like demeanor, articulation, stuff like that. But it's up to you. You can choose whichever category of scoring you think is the most important and use that as how you break the tie.
Okay. All right.
We trust you.
Absolutely.
There's one thing you can trust a judge to do, I guess, is make a decision, right?
You said you sent me an email, Adam?
Oh, I can, yes. I can do that just as well.
This is why you make the big bucks, Justice Cabret.
All right, sent.
Thank you. Take a little while.
Fair enough, because we have to take a second here and identify the highest scores for individuals.
Okay.
I'll just step away for a second while you're doing that.
Okay.
Still hot? The AC still? Oh, I see. Oh.
Thank you.
You're welcome.
Thank you so much.
Calvin takes his nose.
You
Well,
know,
he leaves it up here.
you could just put it, you could just take it and put it back there,
Okay.
and then we can figure it out in the morning.
Okay.
Put it over.
So you guys have one more day?
Huh?
You have one more day to report?
It's done.
All right, I'm waiting for my co-chair, and I'm waiting for my email to cycle up. We have to verify that we both came to the same conclusions.
I sent it to you.
Yep, just came through right now.
Okay.
So, we're giving my co-chair a little time here to say the Virgin Islands Bar president has been watching all day, and she was utterly impressed, and she said that the judges this year and the speaker, that the competition was on an entirely different level. Bravo and well done. So people have been watching all day, and apparently it turned out to their liking. So well done, everyone.
I will be right back.
Sorry about that. My co-chair keeping me honest, and actually he caught a couple of mistakes, but it didn't affect the tie that was there. That's that stands, I believe, and he fixed some individual scores. So we're going to start with the individuals. So for our fifth runner up, sixth place, who will get a medal is Ritesh Alwani from Antilles Appellants team. Our fourth runner-up is Benjamin Simpson from St. Croix Educational Complex. Our third runner-up is Kashish Chinani from Antilles Appellees team.
I'm sorry, give me that name again.
Kashish Chinani from Antilles Appellees. Our third runner-up is Nancy Parija from St. Croix Educational Complex. Our second runner-up is Caden Hughes from Antilles Appellants team. And our best oralist for today is Amara Creaky from St. Thomas St. John Seventh-day Adventist School. Congratulations, all of you, for your individual placements. You made a remarkable showing. The schools will receive trophy cups. This is the fourth place trophy cup. And as you can see, I can't fit it all in the screen. I'm not going to be bringing in the third, second, and first place, which gets much larger. The members of the teams will each be given a medal to match their placement on the team. And so with that, we will start with our fourth place team, which was St. Thomas Seventh-day St. Thomas St. John Seventh-day Adventist School appellants Amara Creaky and Deandra Thomas with a score of 211. We had Antilles appellees Kashish Chinani and Aisha Kamani with a total score of 224 points. In second place, we had St. Croix Educational Complex appellees Kiana Alphonse and Nancy Parija with 240 points. And in first place, our championship team are Caden Hughes and Ritesh Elwani with 245 points. And with that, we will call it a very long but very enjoyable and productive day. Thank you so much for judges. Thank you, coaches. And we will be in touch. Oh, judges, did you get the thank you gifts that I sent?
Thank
I
you.
wanted to make sure they got through the mail to you and everything.
Thank you very much. Yes, even
Thanks.
without the new hub,
Thank you.
that suits me.
Awesome. I'm glad you like it. Glad you got them. Glad to hear
Yes.
it.
Very nice.
And with that, I just wish everyone the best of the remainder of your week. And until next year, I look forward to it when that happens.
Hey, good evening.
Take care.
Good
And
day.
thanks
Take care.
to you and Attorney Kaczynski.
Yes, thank you very much.
Court is in recess.
Yeah, right. Adjourned.
Thank you. Adjourned for today. Thank you. Good job, guys.
Thank you.
Thank
Very
you so
nice.
much.
Very, very nice.